Rules of Court. Pursuant to the provisions of Section 5, Paragraph 5 of Article 8 of the Constitution, the Supreme Court hereby adopts and promulgates the following rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts, the admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. Part 1. The 1997 Rules of Civil Procedure. Rule 1. General Provisions. Section 1. Title of the Rules. These rules shall be known and cited as the Rules of Court. 2. In what courts applicable? These rules shall apply in all the courts except as otherwise provided by the Supreme Court. 3. Cases governed. These rules shall govern the procedure to be observed in actions, civil or criminal, and special proceedings. A. A civil action is one by which a party sues another for the enforcement or protection of a right or the prevention or redress of a wrong. A civil action may either be ordinary or special. Both are governed by the rules for ordinary civil actions, subject to the specific rules prescribed for a special civil action. B. A criminal action is one by which the state prosecutes a person for an act or omission punishable by law. C. A special proceeding is a remedy by which a party seeks to establish a status, a right, or a particular fact. 4. In what cases not applicable? These rules shall not apply to election cases, land registration, cadastral, naturalization, and insolvency proceedings, and other cases not herein provided for, except by analogy or an assimilatory character and whenever practicable and convenient. 5. Commencement of action. Civil action is commenced by the filing of the original complaint in court. If an additional defendant is impleaded in a later pleading, the action is commenced with regard to him on the date of the filing of such later pleading, irrespective of whether the motions for its admission, if necessary, is denied by the court. 6. Construction. These rules shall be liberally construed in order to promote their objective of securing a just, speedy, and expensive disposition of every action and proceeding. Civil actions. Ordinary civil actions. Rule 2. Cause of action. 1. Ordinary civil actions. Basis of. Every ordinary civil action must be based on a cause of action. 2. Cause of action defined. A cause of action is the act or omission by which a party violates a right of another. 3. One suit for a single cause of action. A party may not institute more than one suit for a single cause of action. 4. Splitting a single cause of action. Effect of. If two or more suits are instituted on the basis of the same cause of action, the filing of one or the judgment upon the merits in any one is available as a ground for the dismissal of the others. 5. Joinder of causes of action. A party may in one pleading assert in the alternative or otherwise as many causes of action as he may have against an opposing party, subject to the following conditions. A. The party joining the causes of action shall comply with the rules on joinder of parties. B. The joinder shall not include special civil actions or actions governed by special rules. C. When the causes of action are between the same parties but pertain to different venues or jurisdictions, the joinder may be allowed in the regional trial court provided one of the causes of action falls within the jurisdiction of said court and the venue lies therein. And D. Where the claims in all the causes of action are principally for recovery of money, the aggregate amount claimed shall be the test of jurisdiction. 6. Misjoinder of causes of action. Misjoinder of causes of action is not a ground for dismissal of an action. A misjoined cause of action may, on motion of a party or on the initiative of the court, be severed and proceeded with separately. Rule 3. Parties to civil actions. 1. Who may be parties, plaintiff and defendant. Only natural or juridical persons or entities authorized by law may be parties in a civil action. The term plaintiff may refer to the claiming party, the counterclaimant, the cross-claimant, or the third, fourth, etc. party plaintiff. The term defendant may refer to original defending party, the defendant in a counterclaim, the cross-defendant, or the third, fourth, etc. the party defendant. 2. Parties in interest. A real party in interest is the party who stands to be benefited or injured by the judgment in the suit, or the party entitled to the avails of the suit. Unless otherwise authorized by law or these rules, every action must be prosecuted or defended in the name of the real party in interest. 3. Representatives as parties, where the action is allowed to be prosecuted or defended by a representative or someone acting in a fiduciary capacity. The beneficiary shall be included in the title of the case and shall be deemed to be the real party in interest. A representative may be a trustee of an express trust, a guardian, an executor or administrator, or a party authorized by law or these rules. An agent acting in his own name and for the benefit of an undisclosed principal may sue or be sued without joining the principal, except when the contract involves things belonging to the principal. 4. Spouses as parties. Husband and wife shall sue or be sued jointly, except as provided by law. 5. Minor or incompetent persons. A minor or a person alleged to be incompetent may sue or be sued with the assistance of his father, mother, guardian, or if he has none, a guardian ad litem. 6. Permissive joinder of parties. All persons in whom or against whom any right to relief in respect to or arising out of the same transaction or series of transactions is alleged to exist, whether jointly, severally, or in the alternative, may, except as otherwise provided in these rules, join as plaintiffs or be joined as defendants in one complaint, where any question of law or fact common to all such plaintiffs or to all such defendants may arise in the action, but the court may make such orders as may be just to prevent any plaintiff or defendant from being embarrassed or put to expense in connection with any proceedings in which he may have no interest. 7. Compulsory joinder of indispensable parties. Parties in interest without whom no final determination can be had of an action shall be joined either as plaintiffs or defendants. 8. Necessary party. A necessary party is one who is not indispensable but who ought to be joined as a party if complete relief is to be accorded as to those already parties or for a complete determination or settlement of the claims subject of the action. 9. Non-joinder of necessary parties to be pleaded. The pleader shall set forth his name, if known, and shall state why he is omitted. Should the court find the reason for the omission unmeritorious, it may order the inclusion of the omitted necessary party if jurisdiction over his person may be obtained. The failure to comply with the order for his inclusion without justifiable cause shall be deemed a waiver of the claim against such party. The non-inclusion of a necessary party does not prevent the court from proceeding in the action, and the judgment rendered therein shall be without prejudice to the rights of such necessary party. 10. Unwilling co-plaintiff. If the consent of any party who should be joined as plaintiff cannot be obtained, he may be made a defendant, and the reason therefore shall be stated in the complaint. 11. Misjoinder and non-joinder of parties. Neither misjoinder nor non-joinder of parties is ground or dismissal of an action. Parties may be dropped or added by order of the court on motion of any party, or on its own initiative at any stage of the action, and on such terms as are just. Any claim against a misjoined party may be severed and proceeded with separately. 12. Class suit. When the subject matter of the controversy is one of common or general interest to many persons so numerous that it is impracticable to join all as parties, a number of them which the court finds to be sufficiently numerous and representative as to fully protect the interest of all concerned may sue or defend for the benefit of all. Any party in interest shall have the right to intervene to protect his individual interest. 13. Alternative defendants. Where the plaintiff is uncertain against who of several persons he is entitled to relief, he may join any or all of them as defendants in the alternative, although a right to relief against one may be inconsistent with a right of relief against the other. 14. Unknown identity or name of defendant. Whenever the identity or name of a defendant is unknown, he may be sued as the unknown owner, heir, devisee, or by such other designation as the case may require. When his identity or true name is discovered, the pleading must be amended accordingly. 15. Entity without juridical personality as defendant. When two or more persons not organized as an entity with juridical personality enter into a transaction, they may be sued under the name by which they are generally or commonly known. In the answer of such defendant, the names and addresses of the persons composing said entity must all be revealed. 16. Death of party. Duty of counsel. Whenever a party to a pending action dies, and the claim is not thereby extinguished, it shall be the duty of his counsel to inform the court within 30 days after such death of the fact thereof, and to give the name and address of his legal representative or representatives. Failure of counsel to comply with this duty shall be a ground for disciplinary action. The heirs of the deceased may be allowed to be substituted for the deceased without requiring the appointment of an executor or administrator, and the court may appoint a guardian ad litem for the minor heirs. The court shall forthwith order said legal representative or representatives to appear and be substituted within a period of 30 days from notice. If no legal representative is named by the counsel for the deceased party, or if the one so named shall fail to appear within the specified period, the court may order the opposing party, within a specified time, to procure the appointment of an executor or administrator for the estate of the deceased, and the latter shall immediately appear for and on behalf of the deceased. The court charges in procuring such appointment, if defrayed by the opposing party, may be recovered as costs. 17. Death or separation of a party who is a public officer. When a public officer is a party in an action in his official capacity, and during its pendency dies, resigns, or otherwise ceases to hold office, the action may be continued and maintained by or against his successor if, within 30 days after the successor takes office or such time as may be granted by the court, it is satisfactorily shown to the court by any party that there is a substantial need for continuing or maintaining it, and that a successor adopts or continues or threatens to adopt or continue the action of his predecessor. Before a substitution is made, the party or officer to be affected, unless expressly assenting thereto, shall be given reasonable notice of the application therefor, and accorded an opportunity to be heard. 18. Incompetency or incapacity. If a party becomes incompetent or incapacitated, the court, upon motion with notice, may allow the action to be continued by or against the incompetent incapacitated person, assisted by his legal guardian or guardian ad litem. Transfer of interest. In case of any transfer of interest, the action may be continued by or against the original party unless the court, upon motion, directs the person to whom the interest is transferred to be substituted in the action or joined with the original party. 20. Action on contractual money claims. When the action is for recovery of money arising from contract, express or implied, and the defendant dies before entry of final judgment in the court in which the action was pending at the time of such death, it shall not be dismissed but shall instead be allowed to continue until entry of final judgment. A favorable judgment obtained by the plaintiff therein shall be enforced in the manner especially provided in these rules for prosecuting claims against the estate of a deceased person. 21. Indigent party. A party may be authorized to litigate his action, claim, or defense as an indigent if the court, upon an ex parte application and hearing, is satisfied that the party is one who has no money or property sufficient and available for food, shelter, and basic necessities for himself and his family. Such authority shall include an exemption from payment of docket and other lawful fees and of transcripts of stenographic notes which the court may order to be furnished him. The amount of the docket and other lawful fees which the indigent was exempted from paying shall be a lien on any judgment rendered in the case favorable to the indigent unless the court otherwise provides. Any adverse party may contest the grant of such authority at any time before judgment is rendered by the trial court. If the court should determine after hearing that the party declared as an indigent is in fact a person with sufficient income or property, the proper docket and other lawful fees shall be assessed and collected by the clerk of court. If payment is not made within the time fixed by the court, execution shall issue or the payment thereof without prejudice to such other sanctions as the court may impose. 22. Notice to the Solicitor General in any action involving the validity of any treaty, law, ordinance, executive order, presidential decree, rules or regulations. The court, in its discretion, may require the appearance of the Solicitor General who may be heard in person or through a representative duly designated by him. Rule 4. Venue of actions. 1. Venue of real actions. Actions affecting Title II or possession of real property or interest therein shall be commenced and tried in the proper court, which has jurisdiction over the area wherein the real property involved or a portion thereof is situated. Forcible entry and detainer actions shall be commenced and tried in the municipal trial court of the municipality or city wherein the real property involved or a portion thereof is situated. 2. Venue of personal actions. All other actions may be commenced and tried where the plaintiff or any of the principal plaintiffs resides, or where the defendant or any of the principal defendants resides, or in the case of a non-resident defendant, where he may be found at the election of the plaintiff. 3. Venue of actions against non-residents. If any of the defendants does not reside and is not found in the Philippines, and the action affects the personal status of the plaintiff or any property of said defendant located in the Philippines, the action may be commenced and tried in the court of the place where the plaintiff resides, where the property or any portion thereof is situated or found. 4. When the rule not applicable. This rule shall not apply a. In those cases where a specific rule or law provides otherwise, or b. Where the parties have validly agreed in writing before the filing of the action on the exclusive venue thereof. 5. Uniform procedure in trial courts. 1. Uniform procedure. The procedure in the municipal trial courts shall be the same as in the regional trial courts except a. Where a particular provision expressly or impliedly applies only to either of said courts, or b. In civil cases governed by the rule on summary procedure. 2. Meaning of terms. The term municipal trial courts, as used in these rules, shall include metropolitan trial courts, municipal trial courts in cities, municipal trial courts, and municipal circuit trial courts. Procedure in regional trial courts. Rule 6. Kinds of pleadings. 1. Pleadings defined. Pleadings are the written statements of the respective claims and defenses of the parties submitted to the court for appropriate judgment. 2. Pleadings allowed. The claims of a party are asserted in a complaint, counterclaim, cross-claim, third, fourth, etc., party complaint or complaint in intervention. The defenses of a party are alleged in the answer to the pleading asserting a claim against him or her. An answer may be responded to by a reply only if the defending party attaches an actionable document to the answer. 3. Complaint. The complaint is the pleading alleging the plaintiff's or claiming party's cause or causes of action. The names and residences of the plaintiff and defendant must be stated in the complaint. 4. Answer. An answer is a pleading in which a defending party sets forth his or her defenses. 5. Defenses. Defenses may either be negative or affirmative. A negative defense is a specific denial of the material fact or facts alleged in the pleading of the claimant, essential to his or her causes of action. B. An affirmative defense is an allegation of a new matter which, while hypothetically admitting the material allegations in the pleading of the claimant, would nevertheless prevent or bar recovery by him or her. The affirmative defenses include fraud, statute of limitations, release, payment, illegality, statute of frauds, estoppel, former recovery, discharge in bankruptcy, and any other matter by way of confession and avoidance. Affirmative defenses may also include grounds for the dismissal of a complaint, specifically that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, or that the action is barred by a prior judgment. 6. Counterclaim. A counterclaim is any claim which a defending party may have against an opposing party. 7. Compulsory counterclaim. A compulsory counterclaim is one which, being cognizable by the regular courts of justice, arises out of or is connected with the transaction or occurrence constituting the subject matter of the opposing party's claim, and does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction. Such a counterclaim must be within the jurisdiction of the court, both as to the amount and the nature thereof, except that in an original action before the regional trial court, the counterclaim may be considered compulsory regardless of the amount. A compulsory counterclaim not raised in the same action is barred unless otherwise allowed by these rules. 8. Cross-claim. A cross-claim is any claim by one party against a co-party arising out of the transaction or occurrence that is the subject matter either of the original action or of a counterclaim therein. Such cross-claim may cover all or part of the original claim. 9. Counterclaims and counterclaims. Cross-claims. A counterclaim may be asserted against an original counterclaimant. A cross-claim may also be filed against an original cross-claimant. 10. Reply. All new matters alleged in the answer are deemed controverted. If the plaintiff wishes to interpose any claims arising out of the new matters so alleged, such claims shall be set forth in an amended or supplemental complaint. However, the plaintiff may file a reply only if the defending party attaches an actionable document to his or her answer. A reply is a pleading, the office or function of which is to deny or allege facts in denial or avoidance of new matters alleged in or relating to said actionable document. In the event of an actionable document attached to the reply, the defendant may file a rejoinder if the same is based solely on an actionable document. 11. Third, fourth, etc. Party complaint. A third, fourth, etc. party complaint is a claim that a defending party may, with leave of court, file against a person not a party to the action, called the third, fourth, etc. party defendant for contribution, indemnity, subrogation, or any other relief in respect of his or her opponent's claim. The third, fourth, etc. party complaint shall be denied admission, and the court shall require the defendant to institute a separate action where a. The third, fourth, etc. party defendant cannot be located within 30 calendar days from the grant of such leave, b. Matters extraneous to the issue in the principal case are raised, or c. The effect would be to introduce a new and separate controversy into the action. 12. Bringing new parties. When the presence of parties other than those to the original action is required for the granting of complete relief in the determination of a counterclaim or cross-claim, the court shall order them to be brought in as defendants if jurisdiction over them can be obtained. 13. Answer the third, fourth, etc. party complaint. A third, fourth, etc. party defendant may allege in his or her answer his or her defenses, counterclaims or cross-claims, including such defenses that the third, fourth, etc. party plaintiff may have against the original plaintiff's claim. In proper cases, he or she may also assert a counterclaim against the original plaintiff in respect of the latter's claim against the third-party plaintiff. Rule 7. Parts and contents of a pleading. 1. Caption. The caption sets forth the name of the court, the title of the action, and the docket number if assigned. The title of the action indicates the names of the parties. They shall all be named in the original complaint or petition, but in subsequent pleadings it shall be sufficient if the name of the first party on each side be stated with an appropriate indication when there are other parties. The respective participation in the case shall be indicated. 2. The body. The body of the pleading sets forth its designation, the allegations of the parties' claims or defenses, the relief prayed for, and the date of the pleading. A. Paragraphs. The allegations in the body of a pleading shall be divided into paragraphs so numbered to be readily identified, each of which shall contain a statement of a single set of circumstances, so far as that can be done with convenience. A paragraph may be referred to by its number in all succeeding pleadings. B. Headings. When two or more causes of action are joined, the statement of the first shall be prefaced by the words first cause of action, of the second by second cause of action, and so on for the others. When one or more paragraphs in the answer are addressed to one of several causes of action in the complaint, they shall be prefaced by the words answer to the first cause of action or answer to the second cause of action, and so on. And when one or more paragraphs of the answer are addressed to several causes of action, they shall be prefaced by words to that effect. C. Relief. The pleading shall specify the relief sought, but it may add a general prayer for such further or other relief as may be deemed just or equitable. D. Date. Every pleading shall be dated. 3. Signature and address. A. Every pleading and other written submissions to the court must be signed by the party or counsel representing him or her. B. The signature of counsel constitutes a certificate by him or her that he or she has read the pleading and document, that to the best of his or her knowledge, information, and belief formed after an inquiry reasonable under the circumstances, 1. It is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. 2. The claims, defenses, and other legal contentions are warranted by existing law or jurisprudence, or by a non-frivolous argument for extending, modifying, or reversing existing jurisprudence. 3. The factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after availment of the most of discovery under these rules. And 4. The denials of factual contentions are warranted on the evidence or, if specifically so identified, are reasonably based on belief or a lack of information. C. If the court determines, on motion or motu proprio and after notice and hearing, that this rule has been violated, it may impose an appropriate sanction or refer such violation to the proper office for disciplinary action on any attorney, law firm, or party that violated the rule or is responsible for the violation. Absent exceptional circumstances, a law firm shall be held jointly and severally liable for a violation committed by its partner, associate, or employee. The sanction may include, but shall not be limited to, non-monetary directive or sanction, an order to pay a penalty in court, or if imposed on motion and warranted for effective deterrence, an order directing payment to the movement of part or all of the reasonable attorney's fees and other expenses directly resulting from the violation, including attorney's fees for the filing of the motion for sanction. The lawyer or law firm cannot pass on the monetary penalty to the client. Section 4. Verification. Except when otherwise specifically required by law or rule, pleadings need not be under oath or verified. A pleading is verified by an affidavit of an affiant duly authorized to sign said verification. The authorization of the affiant to act on behalf of a party, whether in the form of a secretary's certificate or a special power of attorney, should be attached to the pleading and shall allege the following attestations. A. The allegations in the pleading are true and correct based on his or her personal knowledge or based on authentic documents. B. The pleading is not filed to harass, cause unnecessary delay, or needlessly increase the cost of litigation. And C. The factual allegations therein have evidentiary support or, if specifically so identified, will likewise have evidentiary support after a reasonable opportunity for discovery. The signature of the affiant shall further serve as a certification of the truthfulness of the allegations in the pleading. A pleading required to be verified that contains a verification based on information and belief, or upon knowledge, information, and belief, or lacks a proper verification, shall be treated as an unsigned pleading. 5. Certification against forum shopping. The plaintiff or principal party shall certify under oath in the complaint or other initiatory pleading asserting a claim for relief, or in a sworn certification annexed thereto and simultaneously filed therewith, a. that he or she has not theretofore commenced any action or filed any claim involving the same issues in any court, tribunal, or quasi-judicial agency, and to the best of his or her knowledge, no such other action or claim is pending therein. If there is such other pending action or claim, a complete statement of the present status thereof, and c. if he or she should thereafter learn that the same or similar action or claim has been filed or is pending, he or she shall report that fact within 5 calendar days therefrom to the court wherein his or her aforesaid complaint or initiatory pleading has been filed. The authorization of the affiant to act on behalf of a party, whether in the form of a secretary's certificate or a special power of attorney, should be attached to the pleading. Failure to comply with the foregoing requirements shall not be curable by mere amendment of the complaint or other initiatory pleading, but shall be cause for the dismissal of the case without prejudice, unless otherwise provided, upon motion and after hearing. The submission of a false certification or non-compliance with any of the undertakings therein shall constitute indirect contempt of court without prejudice to the corresponding administrative and criminal actions. If the acts of the party or his or her counsel clearly constitute willful and deliberate forum shopping, the same shall be ground for summary dismissal with prejudice and shall constitute direct contempt as well as a cause for administrative sanctions. 6. Contents. Every pleading stating a party's claims or defenses shall, in addition to those mandated by Section 2, Rule 7, state the following. A. Names of witnesses who will be presented to prove a party's claim or defense. B. Summary of the witnesses' intended testimonies, provided that the judicial affidavits of said witnesses shall be attached to the pleading and form an integral part thereof. Only witnesses whose judicial affidavits are attached to the pleading shall be presented by the parties during trial, except if a party presents meritorious reasons as basis for the admission of additional witnesses. No other witness or affidavit shall be heard or admitted by the court. And C. Documentary and object evidence in support of the allegations contained in the pleading. Rule 8. Manner of making allegations in pleadings. 1. In general, every pleading shall contain, in a methodical and logical form, a plain, concise, and direct statement of the ultimate facts, including the evidence on which a party pleading relies for his or her claim or defense, as the case may be. If a cause of action or defense relied on is based on law, the pertinent provisions thereof, and the relative causes of action or defenses, a party may set forth two or more statements of a claim or defense alternatively or hypothetically, either in one cause of action or defense or in separate causes of action or defenses. When two or more statements are made in the alternative, and one of them, if made independently, would be sufficient, the pleading is not made insufficient by the insufficiency of one or more of the alternative statements. 3. Conditions precedent. In any pleading, a general averment of the performance or occurrence of all conditions precedent shall be sufficient. 4. Capacity. Facts showing the capacity of a party to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, or the legal existence of an organized association of persons that is made a party, must be averred. A party desiring to raise an issue as to the legal existence of any party, or the capacity of any party to sue or be sued in a representative capacity, shall do so by specific denial, which shall include such supporting particulars as are peculiarly within the pleader's knowledge. 5. Fraud, mistake, condition of the mind. In all averments of fraud or mistake, the circumstances constituting fraud or mistake must be stated with particularity. Malice, intent, knowledge, or other condition of the mind of a person may be averred generally. 6. Judgment. In pleading a judgment or decision of a domestic or foreign court, judicial or quasi-judicial tribunal, or of a board or officer, it is sufficient to aver the judgment or decision without setting forth matter showing jurisdiction to render it. An authenticated copy of the judgment or decision shall be attached to the pleading. 7. Action or defense based on document. Whenever an action or defense is based upon a written instrument or document, the substance of such instrument or document shall be set forth in the pleading, and the original or a copy thereof shall be attached to the pleading as an exhibit, which shall be deemed to be a part of the pleading. 8. How to contest such documents. When an action or defense is founded upon a written instrument or attached to the corresponding pleading as provided in the preceding section, the genuineness and due execution of the instrument shall be deemed admitted unless the adverse party, under oath, specifically denies them and sets forth what he or she claims to be the facts. But the requirement of an oath does not apply when the adverse party does not appear to be a party to the instrument, or when compliance with an order for an inspection of the original instrument is refused. 9. Official document or act. In pleading an official document or official act, it is sufficient to aver that the document was issued or the act was done in compliance with law. 10. Specific denial. A defendant must specify each material allegation of fact, the truth of which he or she does not admit, and, whenever practicable, shall set forth the substance of the matters upon which he or she relies to support his or her denial. Where a defendant desires to deny only a part of an averment, he or she shall specify so much of it as is true and material, and shall deny only the remainder. Where a defendant is without knowledge or information sufficient to form a belief as to the truth of a material averment made to the complaint, he or she shall so state, and this shall have the effect of a denial. 11. Allegations not specifically denied deemed admitted. Material averments in a pleading asserting a claim or claims, other than those as to the amount of unliquidated damages, shall be deemed admitted when not specifically denied. 12. Affirmative defenses. A. A defendant shall raise his or her affirmative defenses in his or her answer, which shall be limited to the reasons set forth under Section 5B, Rule 6, and the following grounds. 1. That the court has no jurisdiction over the person of the defending party. 2. That venue is improperly laid. 3. That the plaintiff has no legal capacity to sue. 4. That the pleading asserting the claim states no cause of action. And 5. That a condition precedent for filing the claim has not been complied with. B. Failure to raise the affirmative defenses at the earliest opportunity shall constitute a waiver thereof. C. The court shall motu proprio resolve the above affirmative defenses within 30 calendar days from the filing of the answer. D. As to the other affirmative defenses under the first paragraph of Section 5B, Rule 6, the court may conduct a summary hearing within 15 calendar days from the filing of the answer. Such affirmative defenses shall be resolved by the court within 30 calendar days from the termination of the summary hearing. E. Affirmative defenses, if denied, shall not be the subject of a motion for reconsideration or petition for certiorari, prohibition, or mandamus, but may be among the matters to be raised on appeal after a judgment on the merits. 13. Striking out of pleading or matter contained therein. Upon motion made by a party before responding to a pleading or, if no responsive pleading is permitted by these rules, upon motion made by a party within 20 calendar days after the service of the pleading upon him or her, or upon the court's own initiative at any time, the court may order any pleading to be stricken out or that any sham or false, redundant, immaterial, impertinent, or scandalous matter be stricken out therefrom. Rule 9. Effect of failure to plead. 1. Defenses and objections not pleaded. Defenses and objections not pleaded either in a motion to dismiss or in the answer are deemed waived. However, when it appears from the pleadings or the evidence on record that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, or that the action is barred by a prior judgment or by statute of limitations, the court shall dismiss the claim. 2. Compulsory counterclaim or cross-claim not set up barred. A compulsory counterclaim or a cross-claim not set up shall be barred. 3. Default declaration of. If the defending party fails to answer within the time allowed therefore, the court shall, upon motion of the claiming party with notice to the defending party and proof of such failure, declare the defending party in default. Thereupon, the court shall proceed to render judgment granting the claimant such relief as his or her pleading may warrant, unless the court in its discretion requires the claimant to submit evidence. Such reception of evidence may be delegated to the clerk of court. A. Effective order of default. A party in default shall be entitled to notices of subsequent proceedings, but shall not take part in the trial. B. Relief from order of default. A party declared in default may at any time after notice thereof and before judgment file a motion under oath to set aside the order of default upon proper showing that his or her failure to answer was due to fraud, accident, mistake, or excusable negligence, and that he or she has a meritorious defense. In such case, the order of default may be set aside on such terms and conditions as the judge may impose in the interest of justice. C. Effect of partial default. When a pleading asserting a claim states a common cause of action against several defending parties, some of whom answer and the others fail to do so, the court shall try the case against all upon the answers thus filed and render judgment upon the evidence presented. D. Extent of relief to be awarded. A judgment rendered against a party in default shall neither exceed the amount or be different in kind from that paid for nor award unliquidated damages. E. Were no defaults allowed, if the defending party in an action for annulment or declaration of nullity of marriage or for legal separation fails to answer, the court shall order the Solicitor General or his or her deputized public prosecutor to investigate whether or not a collusion between the parties exists, and if there is no collusion, to intervene for the state in order to see to it that the evidence submitted is not fabricated. Rule 10. Amended and supplemental pleadings. 1. Amendments in general. Pleadings may be amended by adding or striking out an allegation or the name of any party, or by correcting a mistake in the name of a party or a mistaken or inadequate allegation or description in any other respect, so that the actual merits of the controversy may speedily be determined without regard to technicalities in the most expeditious and inexpensive manner. 2. Amendments as a matter of right. A party may amend his pleading once as a matter of right at any time before a responsive pleading is served or, in the case of a reply, at any time within 10 calendar days after it is served. 3. Amendments by leave of court. Except as provided in the next preceding section, substantial amendments may be made only upon leave of court, but such leave shall be refused if it appears to the court that the motion was made with intent to delay or confer jurisdiction on the court, or the pleading stated no cause of action from the beginning which could be amended. Orders of the court upon the matters provided in this section shall be made upon motion filed in court and after notice to the adverse party and an opportunity to be heard. 4. Formal amendments. A defect in the designation of the parties and other clearly clerical or typographical errors may be summarily corrected by the court at any stage of the action, at its initiative or on motion, provided no prejudice is caused thereby to the adverse party. 5. No amendment necessary to conform to or authorize presentation of evidence. When issues not raised by the pleadings are tried with the express or implied consent of the parties, they shall be treated in all respects as if they had been raised in the pleadings. No amendment of such pleadings deemed amended is necessary to cause them to conform to the evidence. 6. Supplemental pleadings. Upon motion of a party, the court may, upon reasonable notice and upon such terms as are just, permit him or her to serve a supplemental pleading setting forth transactions, occurrences, or events which have happened since the date of the pleading sought to be supplemented. The adverse party may plead thereto within 10 calendar days from notice of the order admitting the supplemental pleading. 7. Filing of amended pleadings. When any pleading is amended, a new copy of the entire pleading, incorporating the amendments, which shall be indicated by appropriate marks, shall be filed. 8. Effect of amended pleadings. An amended pleading supersedes the pleading that it amends. However, admissions in superseded pleadings may be offered in evidence against the pleader, and claims or defenses alleged therein not incorporated in the amended pleading shall be deemed waived. 11. Rule 11. When to file responsive pleadings. 1. Answer to the complaint. The defendant shall file his or her answer to the complaint within 30 calendar days after service of summons unless a different period is fixed by the court. 2. Answer of a defendant, foreign private juridical entity. Where the defendant is a foreign private juridical entity and service of summons is made on a government official designated by law to receive the same, the answer shall be filed within 60 calendar days after receipt of summons by such entity. 3. Answer to amended complaint. When the plaintiff files an amended complaint as a matter of right, the defendant shall answer the same within 30 calendar days after being served with a copy thereof. Where its filing is not a matter of right, the defendant shall answer the amended complaint within 15 calendar days from notice of the order admitting the same. An answer earlier filed may serve as the answer to the amended complaint if no new answer is filed. This rule shall apply to the answer to an amended counterclaim, amended cross-claim, amended third, fourth, etc. party complaint, and amended complaint in intervention. 4. Answer to counterclaim or cross-claim. A counterclaim or cross-claim must be answered within 20 calendar days from service. 5. Answer to third, fourth, etc. party complaint. The time to answer a third, fourth, etc. party complaint shall be governed by the same rule as the answer to the complaint. 6. Reply. A reply, if allowed under Section 10, Rule 6 hereof, may be filed within 15 calendar days from service of the pleading responded to. 7. Answer to supplemental complaint. A supplemental complaint may be answered within 20 calendar days from notice of the order admitting the same, unless a different period is fixed by the court. The answer to the complaint shall serve as the answer to the supplemental complaint if no new or supplemental answer is filed. 8. Existing counterclaim or cross-claim. A compulsory counterclaim or a cross-claim that a defending party has at the time he or she files his or her answer shall be contained therein. 9. Counterclaim or cross-claim arising after answer. A counterclaim or a cross-claim which either matured or was acquired by a party after serving his or her pleading may, with the permission of the court, be presented as a counterclaim or a cross-claim by supplemental pleading before judgment. 10. Omitted counterclaim or cross-claim. When a pleader fails to set up a counterclaim or a cross-claim through oversight, inadvertence, or excusable neglect, or when justice requires, he or she may, by leave of court, Set up the counterclaim or cross-claim by amendment before judgment. 11. Extension of time to file an answer. A defendant may, for meritorious reasons, be granted an additional period of not more than 30 calendar days to file an answer. A defendant is only allowed to file one motion for extension of time to file an answer. A motion for extension to file any pleading other than an answer is prohibited and considered a mere scrap of paper. The court, however, may allow any other pleading to be filed after the time fixed by these rules. Rule 12, Bill of Particulars, Section 1. When applied for, purpose. Before responding to a pleading, a party may move for a definite statement or for a bill of particulars of any matter which is not averred with sufficient definiteness or particularity to enable him or her properly to prepare his or her responsive pleading. If the pleading is a reply, the motion must be filed within 10 calendar days from service thereof. Such motion shall point out the defects complained of, the paragraphs wherein they are contained, and the details desired. 2. Action by the court. Upon the filing of the motion, the clerk of court must immediately bring it to the attention of the court, which may either deny or grant it outright, or allow the parties the opportunity to be heard. 3. Compliance with order. If the motion is granted, either in whole or in part, the compliance therewith must be effected within 10 calendar days from notice of the order, unless a different period is fixed by the court. The bill of particulars or a more definite statement ordered by the court may be filed either in a separate or in an amended pleading, serving a copy thereof on the adverse party. 4. Effect of noncompliance. If the order is not obeyed, or in case of insufficient compliance therewith, the court may order the striking out of the pleading or the portions thereof to which the order was directed, or make such other order as it deems just. 5. Stay of period to file responsive pleading. After service of the bill of particulars or of a more definite pleading, or after notice of denial of his or her motion, the moving party may file his or her responsive pleading within the period to which he or she was entitled at the time of the filing of his or her motion, which shall not be less than 5 calendar days in any event. 6. Bill a part of pleading. A bill of particulars becomes part of the pleading for which it is intended. Rule 13. Filing and service of pleadings, judgments, and other papers. 1. Coverage. This rule shall govern the filing of all pleadings, motions, and other court submissions, as well as their service, except those for which a different mode of service is prescribed. 2. Filing and service defined. Filing is the act of submitting the pleading or other paper to the court. Service is the act of providing a party with a copy of the pleading or any other court submission. If a party has appeared by counsel, service upon such party shall be made upon his or her counsel, unless service upon the party and the party's counsel is ordered by the court. Where one counsel appears for several parties, such counsel shall only be entitled to one copy of any paper served by the opposite side. Where several counsels appear for one party, such party shall be entitled to only one copy of any pleading or paper to be served upon the lead counsel if one is designated, or upon any one of them if there is no designation of a lead counsel. 3. Manner of filing. The filing of pleadings and other court submissions shall be made by a. Submitting personally the original thereof, plainly indicated as such to the court. B. Sending them by registered mail. C. Sending them by accredited courier. Or D. Transmitting them by electronic mail or other electronic means as may be authorized by the court in places where the court is electronically equipped. In the first case, the clerk of court shall endorse on the pleading the date and hour of filing. In the second and third cases, the date of the mailing of motions, pleadings, and other court submissions, and payments or deposits, as shown by the post office stamp on the envelope or the registry receipt, shall be considered as the date of their filing, payment, or deposit in court. The envelope shall be attached to the record of the case. In the fourth case, the date of electronic transmission shall be considered as the date of filing. 4. Papers to be filed and served. Every judgment, resolution, order, pleading subsequent to the complaint, written motion, notice, appearance, demand, offer of judgment, or similar papers shall be filed with the court and served upon the parties affected. 5. Modes of service. Pleadings, motions, notices, orders, judgments, and other court submissions shall be served personally or by registered mail, accredited courier, electronic mail, Facsimile transmission, other electronic means as may be authorized by the court or as provided for in international conventions to which the Philippines is a party. 6. Personal service. Court submissions may be served by personal delivery of a copy to the party or to the party's counsel or to their authorized representative named in the appropriate pleading or motion, or by leaving it in his or her office with his or her clerk or with the person having charge thereof. If no person is found in his or her office, or his or her office is not known, or he or she has no office, then by leaving the copy between the hours of 8 in the morning and 6 in the evening at the party's or counsel's residence, if known, with a person of sufficient age and discretion residing therein. 7. Service by mail. Service by registered mail shall be made by depositing the copy in the post office in a sealed envelope, plainly addressed to the party or to the party's counsel at his or her office, if known, otherwise at his or her residence, if known, with postage fully prepaid and with instructions to the postmaster to return the mail to the sender after 10 calendar days if undelivered. If no registry service is available in the locality of either the sender or the addressee, service may be done by ordinary mail. 8. Substituted service. If service of pleadings, motions, notices, resolutions, orders, and other papers cannot be made under the two preceding sections, the office and place of residence of the party or his or her counsel being unknown, service may be made by delivering the copy to the clerk of court with proof of failure of both personal service and service by mail. The service is complete at the time of such delivery. 9. Service by electronic means and facsimile. Service by electronic means and facsimile shall be made if the party concerned consents to such modes of service. Service by electronic means shall be made by sending an email to the party's or counsel's electronic mail address or through other electronic means of transmission as the parties may agree on or upon direction of the court. Service by facsimile shall be made by sending a facsimile copy to the parties or counsel's given facsimile number. 10. Presumptive service. There shall be presumptive notice to a party of a court setting if such notice appears on the records to have been mailed at least 20 calendar days prior to the scheduled date of hearing, and if the addressee is from within the same judicial region of the court where the case is pending, or at least 30 calendar days if the addressee is from outside the judicial region. 11. Change of electronic mail address or facsimile number. A party who changes his or her electronic mail address or facsimile number while the action is pending must promptly file, within 5 calendar days from such change, a notice of change of email address or facsimile number with the court and serve the notice on all other parties. Service through the electronic mail address or facsimile number of a party shall be presumed valid unless such a party notifies the court of any change as aforementioned. 12. Electronic mail and facsimile subject and title of pleadings and other documents. The subject of the electronic mail and facsimile must follow the prescribed format: case number, case title, and the pleading, order or document title, the title of each electronically filed or served pleading or other document, and each submission served by facsimile shall contain sufficient information to enable the court to ascertain from the title: A. The party or parties filing or serving the paper; B. Nature of the paper; C. The party or parties against whom relief, if any, is sought; and D. The nature of the relief sought. 13. Service of judgments, final orders, or resolutions. Judgments, final orders, or resolutions shall be served either personally or by registered mail. Upon ex parte motion of any party in the case, a copy of the judgment, final order, or resolution may be delivered by accredited courier at the expense of such party. When a party summoned by publication has failed to appear in the action, judgments, final orders, or resolutions against him or her shall be served upon him or her also by means of publication at the expense of the prevailing party. 13. Conventional service or filing of orders, pleadings, and other documents. Notwithstanding the foregoing, the following orders, pleadings, and other documents must be served or filed personally or by registered mail when allowed, and shall not be served or filed electronically unless express permission is granted by the court. A. Initiatory pleadings and initial responsive pleadings, such as an answer. B. Subpoena, protection orders, and writs. C. Appendices and exhibits to motions or other documents that are not readily amendable to electronic scanning may, at the option of the party filing such, be filed and served conventionally, and B. Sealed and confidential documents or records. 15. Completeness of service. Personal service is complete upon actual delivery. Service by ordinary mail is complete upon the expiration of 10 calendar days after mailing, unless the court otherwise provides. Service by registered mail is complete upon actual receipt by the addressee, or after 5 calendar days from the date he or she received the first notice of the postmaster, whichever date is earlier. Service by accredited courier is complete upon actual receipt by the addressee, or after at least 2 attempts to deliver by the courier service, or upon the expiration of 5 calendar days after the first attempt to deliver, whichever is earlier. Electronic service is complete at the time of the electronic transmission of the document, or when available at the time that the electronic notification of service of the document is sent. Electronic service is not effective or complete if the party serving the document learns that it did not reach the addressee or person to be served. Service by facsimile transmission is complete upon receipt by the other party, as indicated in the facsimile transmission printout. 16. Proof of filing. The filing of a pleading or any other court submission shall be proved by its existence in the record of the case. A. If the pleading or any other court submission is not in the record, but is claimed to have been filed personally, the filing shall be proven by the written or stamped acknowledgement of its filing by the clerk of court on a copy of the pleading or court submission. B. If the pleading or any other court submission was filed by registered mail, the filing shall be proven by the registry's receipt and by the affidavit of the person who mailed it, containing a full statement of the date and place of deposit of the bill in the post office in a sealed envelope addressed to the court, with postage fully prepaid, and with instructions to the postmaster to return the bill to the sender after 10 calendar days if not delivered. C. If the pleading or any other court submission was filed through an accredited courier service, the filing shall be proven by an affidavit of service of the person who brought the pleading or other document to the service provider, together with the courier's official receipt and document tracking number. D. If the pleading or any other court submission was filed by electronic mail, the same shall be proven by an affidavit of electronic filing of the filing party accompanied by a paper copy of the pleading or other document transmitted, or a written or stamped acknowledgement of its filing by the clerk of court. If the paper copy sent by electronic mail was filed by registered mail, paragraph B of this section applies. E. If the pleading or any other court submission was filed through other authorized electronic means, the same shall be proven by an affidavit of electronic filing of the filing party accompanied by a copy of the electronic acknowledgement of its filing by the court. 17. Proof of service. Proof of personal service shall consist of a written admission of the party served, or the official return of the server, or the affidavit of the party serving, containing a statement of the date, place, and manner of service. If the service is made by a ordinary mail, proof shall consist of an affidavit of the person mailing stating the facts showing compliance with Section 7 of this rule. B. Registered mail. Proof shall be made by the affidavit mentioned above and the registry receipt issued by the mailing office. The registry return card shall be filed immediately upon its receipt by the sender, or in lieu thereof, the unclaimed letter together with a certified or sworn copy of the notice given by the postmaster to the addressee. C. Accredited courier service. Proof shall be made by an affidavit of service executed by the person who brought the pleading or paper to the service provider, together with the courier's official receipt or document tracking number. D. electronic mail, facsimile, or other authorized electronic means of transmission, proof shall be made by an affidavit of service executed by the person who sent the email, facsimile, or other electronic transmission, together a printed proof of transmittal. 18. Court-issued orders and other documents. The court may electronically serve orders and other documents to all the parties in the case, which shall have the same effect and validity as provided herein. A paper copy of the order or other document electronically served shall be retained and attached to the record of the case. 19. Notice of lis pendens. In an action affecting the title or the right of possession of real property, the plaintiff and the defendant, when affirmative relief is claimed in his or her answer, may record in the office of the registry of deeds of the province in which the property is situated a notice of the pendency of the action. Said notice shall contain the names of the parties and the object of the action or defense, and a description of the property in that province affected thereby. Only from the time of filing such notice for record shall a purchaser or encumbrancer of the property affected thereby be deemed to have constructive notice of the pendency of the action, and only of its pendency against the parties designated by the real names. The notice of lis pendens herein above mentioned may be cancelled only upon order of the court, after proper showing that the notice is for the purpose of molesting the adverse party, or that it is not necessary to protect the rights of the party who caused it to be recorded. Rule 13. Summons. 1. Clerk to issue summons. Unless the complaint is on its face dismissible under Section 1, Rule 9, the court shall, within 5 calendar days from receipt of the initiatory pleading and proof of payment of the requisite legal fees, direct the clerk of court to issue the corresponding summons to the defendants. 2. Contents. The summons shall be directed to the defendant, signed by the clerk of court under seal, and contain a. The name of the court and the names of the parties to the action. b. When authorized by the court upon ex parte motion, an authorization for the plaintiff to serve summons to the defendant. c. A direction that the defendant answer within the time fixed by these rules, and d. A notice that unless the defendant so answers, plaintiff will take judgment by default and may be granted the relief applied for. A copy of the complaint and order for appointment of guardian ad litem, if any, shall be attached to the original and each copy of the summons. 3. By whom served. The summons may be served by the sheriff, his or her deputy, or other proper court officer, and in case of failure of service of summons by them, the court may authorize the plaintiff to serve the summons together with the sheriff. In cases where summons is to be served outside the judicial region of the court where the case is pending, the plaintiff shall be authorized to cause the service of summons. If the plaintiff is a juridical entity, it shall notify the court in writing and name its authorized representative therein, attaching a board resolution or a secretary's certificate thereto, as the case may be, stating that such representative is duly authorized to serve the summons on behalf of the plaintiff. If the plaintiff misrepresents that the defendant was served summons, and it is later proved that no summons was served, the case shall be dismissed with prejudice, the proceedings shall be nullified, and the plaintiff shall be meted appropriate sanctions. If summons is returned without being served on any or all of the defendants, the court shall order the plaintiff to cause the service of summons by other means available under the rules. Failure to comply with the order shall cause the dismissal of the initial pleading without prejudice. 4. Validity of summons and issuance of alias summons. Summons shall remain valid until duly served unless it is recalled by the court. In case of loss or destruction of summons, the court may, upon motion, issue an alias summons. There is failure of service after unsuccessful attempts to personally serve the summons on the defendant in his or her address indicated in the complaint. Substituted service should be in the manner provided under Section 6 of this rule. 5. Service in person on defendant. Whenever practicable, the summons shall be served by handing a copy thereof to the defendant in person and informing the defendant that he or she is being served, or, if he or she refuses to receive and sign for it, by leaving the summons within the view and in the presence of the defendant. 6. Substituted service. If, for justifiable causes, the defendant cannot be served personally after at least 3 attempts on 2 different dates, service may be effected a. by leaving copies of the summons at the defendant's residence to a person at least 18 years of age and of sufficient discretion residing therein. B. By leaving copies of the summons at the defendant's office or regular place of business with some competent person in charge thereof. A competent person includes, but is not limited to, one who customarily receives correspondence for the defendant. C. By leaving copies of the summons, if refused entry upon making his or her authority and purpose known, with any of the officers of the Homeowners Association or Condominium Corporation, or its chief security officer in charge of the community or the building where the defendant may be found. And D. By sending an electronic mail to the defendant's electronic mail address if allowed by the court. 7. Service upon entity without juridical personality. When persons associated in an entity without juridical personality are sued under the name by which they are generally or commonly known, service may be effected upon all the defendants by serving upon any one of them, or upon the person in charge of the office or place of business maintained in such name. But such service shall not bind individually any person whose connection with the entity has, upon due notice, been severed before the action was filed. A. Service upon prisoners. When the defendant is a prisoner confined in a jail or institution, service shall be effected upon him or her by the officer having the management of such jail or institution, who is deemed as a special sheriff for said purpose. The jail warden shall file a return within 5 calendar days from service of summons to the defendant. 9. Service consistent with international conventions. Service may be made through methods which are consistent with established international conventions to which the Philippines is a party. 10. Service upon minors and incompetents. When the defendant is a minor, insane, or otherwise an incompetent person, service of summons shall be made upon him or her personally, and on his or her legal guardian, if he or she has one, or if none, upon his or her guardian ad litem whose appointment shall be applied for by the plaintiff. In the case of a minor, service shall be made on his or her parent or guardian. 11. Service upon spouses. When spouses are sued jointly, service of summons should be made to each spouse individually. 12. Service upon domestic private juridical entity. When the defendant is a corporation, partnership, or association organized under the laws of the Philippines with a juridical personality, service may be made on the president, managing partner, general manager, corporate secretary, treasurer, or in-house counsel of the corporation wherever they may be found, or in their absence or unavailability on their secretaries. If such service cannot be made upon any of the foregoing persons, it shall be made upon the person who customarily receives the correspondence for the defendant at its principal office. In case the domestic juridical entity is under receivership or liquidation, service of summons shall be made on the receiver or liquidator as the case may be. Should there be a refusal on the part of the persons above mentioned to receive summons despite at least 3 attempts on 2 different dates, service may be made electronically if allowed by the court, as provided under Section 6 of this rule. 13. Duty of counsel of record. Where the summons is improperly served and a lawyer makes a special appearance on behalf of the defendant to, among others, question the validity of service of summons, the counsel shall be deputized by the court to serve summons on his or her client. 13. Service upon foreign private juridical entities. When the defendant is a foreign private juridical entity which has transacted or is doing business in the Philippines as defined by law, service may be made on its resident agent designated in accordance with law for that purpose, or if there be no such agent, on the government official designated by law to that effect, or on any of its officers, agents, directors, or trustees within the Philippines. If the foreign private juridical entity is not registered in the Philippines, or has no resident agent but has transacted or is doing business in it, as defined by law, such service may, with leave of court, be effected outside of the Philippines through any of the following means. A. By personal service coursed through the appropriate court in the foreign country with the assistance of the Department of Foreign Affairs. B. by publication once in a newspaper of general circulation in the country where the defendant may be found, and by serving a copy of the summons in the court order by registered mail at the last known address of the defendant. C. By facsimile. D. By electronic means with the prescribed proof of service, or E. By such other means as the court in its discretion may direct. 15. Service upon public corporations. When the defendant is the Republic of the Philippines, service may be effected on the Solicitor General. In the case of a province, city, or municipality, or like public corporations, service may be effected on its executive head, or on such other officer or officers as the law or the court may direct. 16. Service upon defendant whose identity or whereabouts are unknown. In any action where the defendant is designated as an unknown earner or the like, or whenever his or her whereabouts are unknown and cannot be ascertained by diligent inquiry within 90 calendar days from the commencement of the action, service may, by leave of court, be effected upon him or her by publication in a newspaper of general circulation and in such places and for such time as the court may order. Any order granting such leave shall specify a reasonable time, which shall not be less than 60 calendar days after notice, within which the defendant must answer. 17. Extraterritorial service. When the defendant does not reside and is not found in the Philippines, and the action affects the personal status of the plaintiff or relates to, or the subject of which is property within the Philippines, in which the defendant has or claims a lien or interest, actual or contingent, or in which the relief demanded consists wholly or in part in excluding the defendant from any interest therein, or the property of the defendant has been attached within the Philippines, service may, by leave of court, be effected out of the Philippines by personal service as under Section 6, or as provided for in international conventions to which the Philippines is a party, or by publication in a newspaper of general circulation, in such places and for such time as the court may order, in which case a copy of the summons and order of the court shall be sent by registered mail to the last known address of the defendant, or in any other manner the court may deem sufficient. Any order granting such leave shall specify a reasonable time, which shall not be less than 60 calendar days after notice, within which the defendant must answer. 18. Residence temporarily out of the Philippines. When any action is commenced against a defendant who ordinarily resides within the Philippines, but who is temporarily out of it, service may, by leave of court, be also effected out of the Philippines as under the preceding section. 19. Leave of court. Any application to the court under this rule for leave to effect service in any manner for which leave of court is necessary shall be made by motion in writing, supported by affidavit of the plaintiff or some person on his behalf, setting forth the grounds for the application. 20. Return. Within 30 calendar days from issuance of summons by the clerk of court and receipt or process server or person authorized by the court shall complete its service. Within 5 calendar days from service of summons, the server shall file with the court and serve a copy of the return to the plaintiff's counsel, personally, by registered mail, or by electronic means authorized by the rules. Should substituted service have been effected, the return shall state the following. 1. The impossibility of prompt personal service within a period of 30 calendar days from issue and receipt of summons. 2. The date and time of the 3 attempts on at least 2 different dates to cause personal service and the details of the inquiries made to locate the defendant residing thereat. And 3. The name of the person at least 18 years of age and of sufficient discretion residing thereat. Name of competent person in charge of the defendant's office or regular place of business, or name of the officer of the homeowners association or condominium corporation, or its chief security officer in charge of the community or building where the defendant may be found. 21. Proof of service. The proof of service of a summons shall be made in writing by the server and shall set forth the manner, place, and date of service, shall specify any papers which have been served with the process and the name of the person who received the same, and shall be sworn to when made by a person other than a sheriff or his or her deputy. If summons was served by electronic mail, a printout of said email with a copy of the summons as served and the affidavit of the person mailing shall constitute as proof of service. 22. Proof of service by publication. the service has been made by publication, service may be proved by the affidavit of the publisher, editor, business, or advertising manager, to which affidavit a copy of the publication shall be attached, and by an affidavit showing the deposit of a copy of the summons in order for a publication in the post office, postage prepaid, directed to the defendant by registered mail to his or her last known address. 23. Voluntary appearance. The defendant's voluntary appearance in the action shall be equivalent to service of summons. The inclusion in the motion to dismiss of other grounds aside from lack of jurisdiction Rule over the
15
person of the
motions,
defendant shall
Section
be
1.
deemed a
Motion
voluntary
defined.
appearance.
A motion is an application for relief other than by a pleading. Section 2. Motions must be in writing. All motions shall be in writing except those made in open court or in the course of a hearing or trial. A motion made in open court or in the course of a hearing or trial should immediately be resolved in open court after the adverse party is given the opportunity to argue his or her opposition thereto. When a motion is based on facts not appearing on record, the court may hear the matter on affidavits or depositions presented by the respective parties, but the court may direct that the matter be heard wholly or partly on oral testimony or depositions. 3. Contents. A motion shall state the relief sought to be obtained and the grounds upon which it is based, and if required by these rules or necessary to prove facts alleged therein, shall be accompanied by supporting affidavits and other papers. 4. Hearing of motion. Deleted. 4. Non-litigious motions. Motions which the court may act upon without prejudicing the rights of adverse parties are non-litigious motions. These motions include a. Motion for the issuance of an alias summons, b. Motion for extension to file answer, c. Motion for postponement, d. Motion for the issuance of a writ of execution, e. Motion for the issuance of an alias writ of execution, f. Motion for the issuance of a writ of possession, G. Motion for the issuance of an order directing the sheriff to execute the final certificate of sale, and H. Other similar motions. These motions shall not be set for hearing and shall be resolved by the court within 5 calendar days from receipt thereof. 5. Litigious motions. A. Litigious motions include 1. Motion for bill of particulars, 2. Motion to dismiss, 3. Motion for new trial, 4. Motion for reconsideration, 5. Motion for execution pending appeal, 6. Motion to amend after a responsive pleading has been filed, 7. Motion to cancel statutory lien, 8. Motion for an order to break in or for a writ of demolition, 9. Motion for intervention, 10. Motion for judgment on the pleadings, 11. Motion for summary judgment, 12. Demurrer to evidence, 13. Motion to declare defendant in default, and 14. Other similar motions. B. All motions shall be served by personal service, accredited private courier or registered mail, or electronic means so as to ensure the receipt by the other party. C. The opposing party shall file his or her opposition to a litigious motion within 5 calendar days from receipt thereof. No other submissions shall be considered by the court in the resolution of the motion. The motion shall be resolved by the court within 15 calendar days from its receipt of the opposition thereto or upon expiration of the period to file such opposition. 6. Notice of hearing on litigious motions, discretionary. The court may, in the exercise of its discretion and if deemed necessary for its resolution, call a hearing on the motion. The notice of hearing shall be addressed to all parties concerned and shall specify the time and date of the hearing. 7. Proof of service necessary. No written motion shall be acted upon by the court without proof of service thereof, pursuant to Section 5B hereof. 8. Motion day. Except for motions requiring immediate action, where the court decides to conduct hearing on a litigious motion, the same shall be set on a Friday. 9. Omnibus motion. Subject to the provisions of Section 1 of Rule 9, a motion attacking a pleading, order, judgment, or proceeding shall include all objections then available, and all objections not so included shall be deemed waived. 10. Motion for leave. A motion for leave to file a pleading or motion shall be accompanied by the pleading or motion sought to be admitted. 11. Form. The rules applicable to pleadings shall apply to written motions so far as concerns caption, designation, signature, and other matters of form. 12. Prohibited motions. The following motions shall not be allowed. A. Motion to dismiss except on the following grounds. 1. That the court has no jurisdiction over the subject matter of the claim. 2. That there is another action pending between the same parties for the same cause. And 3. That the cause of action is barred by a prior judgment or by the statute of limitations. B. Motion to hear affirmative defenses. C. Motion for reconsideration of the court's action on the affirmative defenses. D. Motion to suspend proceedings without a temporary restraining order or injunction issued by a higher court. E. Motion for extension of time to file pleadings, affidavits, or any other papers except a motion for extension to file an answer as provided by Section 11, Rule 11, and F. Motion for postponement intended for delay except if it is based on acts of God, force majeure, or physical inability of the witness to appear and testify. If the motion is granted based on such exceptions, the moving party shall be warned that the presentation of its evidence must still be terminated on the dates previously agreed upon. A motion for postponement, whether written or oral, shall at all times be accompanied by the original official receipt from the office of the clerk of court, evidencing payment of the postponement fee under Section 21B, Rule 141, to be submitted either at the time of the filing of said motion or not later than the next hearing date. The clerk of court shall not accept the motion unless accompanied by the original receipt. 13. Dismissal without prejudice. Subject to the right of appeal, an order granting a motion to dismiss or an affirmative defense that the cause of action is barred by a prior judgment or by the statute of limitations, that the claim or demand set forth in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished, and that the claim on which the action is founded is unenforceable under the provisions of the statute of frauds, shall bar the refiling of the same action or claim. Rule 16. Motion to dismiss. Provisions either deleted or transposed. Rule 17. Dismissal of actions. 1. Dismissal upon notice by plaintiff. A complaint may be dismissed by the plaintiff by filing a notice of dismissal at any time before service of the answer or of a motion for summary judgment. Upon such notice being filed, the court shall issue an order confirming the dismissal. Unless otherwise stated in the notice, the dismissal is without prejudice, except that a notice operates as an adjudication upon the merits when filed by a plaintiff who has once dismissed in a competent court an action based on or including the same claim. 2. Dismissal upon motion of plaintiff. A complaint may be dismissed by the plaintiff by filing a notice of dismissal at any time before service of the answer or of a motion for summary judgment. Upon such notice being filed, the court shall issue an order confirming the dismissal. Unless otherwise stated in the notice, the dismissal is without prejudice, except that a notice operates as an adjudication upon the merits when filed by a plaintiff who has once dismissed in a competent court an action based on or including the same claim. 2. Dismissal upon motion of plaintiff. Except as provided in the preceding section, a complaint shall not be dismissed at the plaintiff's instance save upon approval of the court and upon such terms and conditions as the court deems proper. If a counterclaim has been pleaded by a defendant prior to the service upon him or her of the plaintiff's motion for dismissal, the dismissal shall be limited to the complaint. The dismissal shall be without prejudice to the right of the defendant to prosecute his or her counterclaim in a separate action unless within 15 calendar days from notice of the motion he or she manifests his or her preference to have his or her counterclaim resolved in the same action. Unless otherwise specified in the order, the dismissal under this paragraph shall be without prejudice. A class suit shall not be dismissed or compromised without the approval of the court. 3. Dismissal due to fault of plaintiff. If, for no justifiable cause,
The plaintiff fails to appear on the date of the presentation of his or her evidence in chief on the complaint, or to prosecute his or her action for an unreasonable length of time, or to comply with these rules or any order of the court, the complaint may be dismissed upon motion of the defendant or upon the court's own motion, without prejudice to the right of the defendant to prosecute his or her counterclaim in the same or in a separate action. This dismissal shall have the effect of an adjudication upon the merits unless otherwise declared by the court. 4. Dismissal of counterclaim, cross-claim, or third-party complaint. The provisions of this rule shall apply to the dismissal of any counterclaim, cross-claim, or third-party complaint. A voluntary dismissal by the claimant by notice, as in Section 1 of this rule, shall be made before a responsive pleading or a motion for summary judgment is served, or, if there is none, before the introduction of evidence at the trial or hearing. Rule 18. Pre-trial. 1. When conducted. After the last responsive pleading has been served and filed, the branch clerk of court shall issue, within 5 calendar days from filing, a notice of pre-trial which shall be set not later than 60 calendar days from the filing of the last responsive pleading. 2. Nature and purpose. The pre-trial is mandatory and should be terminated promptly. The court shall consider A. The possibility of an amicable settlement or of a submission to alternative modes of dispute resolution. B. The simplification of the issues. C. The possibility of obtaining stipulations or admissions of facts and of documents to avoid unnecessary proof. D. The limitation of the number and identification of witnesses and the setting of trial dates. E. The advisability of a preliminary reference of issues to a commissioner. F. The propriety of rendering judgment on the pleadings or summary judgment, or of dismissing the action should a valid ground therefore be found to exist. G. The requirement for the parties to 1. Mark the respective evidence, if not yet marked, in the judicial affidavits of their witnesses. 2. Examine and make comparisons of the adverse parties' evidence vis-a-vis the copies to be marked. 3. Manifest for the record stipulations regarding the faithfulness of the reproductions and the genuineness and due execution of the adverse parties' evidence. 4. Reserve evidence not only available at the pretrial, but only in the following manner. I. For testimonial evidence, by giving the name or position and the nature of the testimony of the proposed witness. II. For documentary evidence and other object evidence, by giving a particular description of the evidence. No reservation shall be allowed if not made in the manner described above. H. Such other matters as may aid in the prompt disposition of the action. The failure without just cause of a party and counsel to appear during pre-trial, despite notice, shall result in a waiver of any objections to the faithfulness of the reproductions marked, or their genuineness and due execution. The failure without just cause of a party and counsel to appear during pre-trial, despite notice, shall result in a waiver of any objections to the faithfulness of the reproductions marked, or their genuineness and due execution. The failure without just cause of a party and or counsel to bring the evidence required shall be deemed a waiver of the presentation of such evidence. The branch clerk of court shall prepare the minutes of the pre-trial, which shall have the following format. See prescribed form 2A. 3. Notice of pretrial. The notice of pretrial shall include the dates respectively set for A. Pretrial, B. Court annexed mediation, and C. Judicial dispute resolution if necessary. The notion of pretrial shall be served on counsel or on the party if he or she has no counsel. The counsel served with such notice is charged with the duty of notifying the party represented by him or her. Non-appearance at any of the foregoing settings shall be deemed as non-appearance at the pretrial and shall merit the same sanctions under Section 5 hereof. 4. Appearance of parties. It shall be the duty of the parties and their counsel to appear at the pretrial, court annexed mediation, and judicial dispute resolution if necessary. The non-appearance of a party and counsel may be excused only for acts of God, force majeure, or dully substantiated physical inability. A representative may appear on behalf of a party, but must be fully authorized in writing to enter into an amicable settlement, to submit to alternative modes of dispute resolution, and to enter into stipulations or admissions of facts and documents. 5. Effect of failure to appear. When duly notified, the failure of the plaintiff and counsel to appear without valid cause, when so required pursuant to the next preceding section, shall cause the dismissal of the action.
The dismissal shall be with prejudice unless otherwise ordered by the court. A similar failure on the part of the defendant and counsel shall be caused to allow the plaintiff to present his or her evidence ex parte within 10 calendar days from termination of the pretrial, and the court to render judgment on the basis of the evidence offered. 6. Pre-trial brief. The parties shall file with the court and serve on the adverse party in such manner as shall ensure the receipt thereof at least 3 calendar days before the date of the pre-trial, the respective pre-trial briefs, which shall contain, among others, a concise statement of the case and the reliefs prayed for; b. a summary of admitted facts and proposed stipulation of facts; c. the main factual and legal issues to be tried or resolved; d. the propriety of referral of factual issues to commissioners; e. the documents or other object evidence to be marked, stating the purpose thereof; f. the names of the witnesses and the summary of their respective testimonies; and g. a brief statement of points of law and citation of authorities. Failure to file the pretrial brief shall have the same effect as failure to appear at the pretrial. 7. Pretrial order. Upon termination of the pretrial, the court shall issue an order within 10 calendar days, which shall recite in detail the matters taken up. The order shall include an enumeration of the admitted facts; b. the minutes of the pretrial conference; c. the legal and factual issues to be tried; d. the applicable law, rules, and jurisprudence; e. the evidence marked; f. a specific trial dates for continuous trial, which shall be within the period provided by the rules; g. the case flow chart to be determined by the court, which shall contain the different stages of the proceedings up to the promulgation of the decision, and the use of time frames for each stage in setting the trial dates; h. a statement that the one-day examination of witness rule and most important witness rule under AM number 03109 SC guidelines for pre-trial shall be strictly followed; and a statement that the court shall render judgment on the pleadings or summary judgment as the case may be. The direct testimony of witnesses for the plaintiff shall be in the form of judicial affidavits. After the identification of such affidavits, cross-examination shall proceed immediately. Postponement of is based on acts of God, force majeure, or dully substantiated physical inability of the witness to appear and testify. The party who caused the postponement is warned that the presentation of its evidence must still be terminated within the remaining dates previously agreed upon. Should the opposing party fail to appear without valid cause stated in the next preceding paragraph, the presentation of the scheduled witness will proceed with the absent party being deemed to have waived the right to interpose objection and conduct cross-examination. The contents of the pretrial order shall control the subsequent proceedings, unless modified before trial to prevent manifest injustice. 8. Court Annexed Mediation. After pretrial and after issues are joined, the court shall refer the parties for mandatory court annexed mediation. The period for court annexed mediation shall not exceed 30 calendar days without further extension. 9. Judicial dispute resolution. Only if the judge of the court to which the case was originally raffled is convinced that settlement is still possible, the case may be referred to another court for judicial dispute resolution. The judicial dispute resolution shall be conducted within a non-extendable period of 15 calendar days from notice of failure of the court annexed mediation. If judicial dispute resolution fails, trial before the original court shall proceed on the dates agreed upon. All proceedings during the court annexed mediation and the judicial dispute resolution shall be confidential. 10. Judgment after pre-trial. Should there be no more controverted facts, or no more genuine issue as to any material fact, or an absence of any issue, or should the answer fail to tender an issue, the court shall, without prejudice to a party moving for judgment on the pleadings under Rule 34 or summary judgment under Rule 35, motu proprio include in the pre-trial order that the case be submitted for summary judgment or judgment on the pleadings without need of position papers or memoranda. In such cases, judgment shall be rendered within 90 calendar days from termination of the pre-trial. The order of the court to submit the case for judgment pursuant to this rule shall not be the subject to appeal or certiorari. Rule 19. Intervention. 1. Who may intervene? A person who has a legal interest in the matter in litigation or in the success of either of the parties, or an interest against both, or is so situated as to be adversely affected by a distribution or other disposition of property in the custody of the court or of an officer thereof may, with leave of court, be allowed to intervene in the action. The court shall consider whether or not the intervention will unduly delay or prejudice the adjudication of the rights of the original parties, and whether or not the intervener's rights may be fully protected in a separate proceeding. 2. Time to intervene. The motion to intervene may be filed at any time before rendition of judgment by the trial court. A copy of the pleading in intervention should be attached to the motion and served on the original parties. 3. Pleadings and intervention. The intervener shall file a complaint in intervention if he or she asserts a claim against either or all of the original parties, or an answer in intervention if he or she unites with the defending party in resisting a claim against the latter. 4. Answer to complaint and intervention. The answer to the complaint in intervention shall be filed within 15 calendar days from notice of the order admitting the same, unless a different period is fixed by the court. Rule 20. Calendar of cases. 1. Calendar of cases. The clerk of court, under the direct supervision of the judge, shall keep a calendar of cases for pre-trial, for trial, those whose trials were adjourned or postponed, and those with motions to set for hearing. Preference shall be given to habeas corpus cases, election cases, special civil actions, and those so required by law. 2. Assignment of cases. The assignment of cases to the different branches of a court shall be done exclusively by raffle. The assignment shall be done in open session, of which adequate notice shall be given so as to afford interested parties the opportunity to be present. Rule 21. Subpoena. 1. Subpoena and subpoena ducis tecum. Subpoena is a process directed to a person requiring him or her to attend and to testify at the hearing or the trial of an action, or at any investigation conducted by competent authority, or for the taking of his or her deposition. It may also require him or her to bring with him or her any books, documents, or other things under his or her control, in which case it is called a subpoena ducis tecum. 2. By whom issued. The subpoena may be issued by a. The court before whom the witness is required to attend. B. The court of the place where the deposition is to be taken. C. The officer or body authorized by law to do so in connection with investigations conducted by said officer or body. Or D. Any justice of the Supreme Court or the Court of Appeals in any case or investigation pending within the Philippines. When an application for a subpoena to a prisoner is made, the judge or officer shall examine and study carefully such application to determine whether the same is made for a valid purpose. No prisoner sentenced to death, reclusion perpetua, or life imprisonment and who is confined in any penal institution shall be brought outside the penal institution for appearance or attendance in any court unless authorized by the Supreme Court. 3. Form and contents. A subpoena shall state the name of the court and the title of the action or investigation, shall be directed to the person whose attendance is required, and in the case of a subpoena ducis tecum, it shall also contain a reasonable description of the books, documents, or things demanded, which must appear to the court prima facie relevant. 4. Quashing a subpoena. The court may quash a subpoena ducis tecum upon motion promptly made and, in any event, at or before the time specified therein if it is unreasonable and oppressive, or the relevancy of the books, documents, or things does not appear, or if the person in whose behalf the subpoena is issued fails to advance the reasonable cost of the production thereof. The court may quash a subpoena ad testificando on the ground that the witness is not bound thereby. In either case, the subpoena may be quashed on the ground that the witness fees and kilometrage allowed by these rules were not tendered when the subpoena was served. 5. Subpoena for depositions. Proof of service of a notice to take a deposition, as provided in sections 15 and 25 of Rule 23, shall constitute sufficient authorization for the issuance of subpoenas for the persons named in said notice by the clerk of the court of the place in which the deposition is to be taken. The clerk shall not, however, issue a subpoena ducis tecum to any such person without an order of the court. 6. Service. Services of subpoena shall be made in the same manner as personal or substituted service of summons. The original shall be exhibited and a copy thereof delivered to the person on whom it is served. The service must be made so as to allow the witness a reasonable time for preparation and travel to the place of attendance. Costs for court attendance and the production of documents and other materials subject of the subpoena shall be tendered or charged accordingly. 7. Personal appearance in court. A person present in court before a judicial officer may be required to testify as if he or she were in attendance upon a subpoena issued by such court or officer. 8. Compelling attendance. In case of failure of a witness to attend, the court or judge issuing the subpoena, upon proof of the service thereof and of the failure of the witness, may issue a warrant to the sheriff of the province or his or her deputy to arrest the witness and bring him or her before the court or officer where his or her attendance is required, and the cost of such warrant and seizure of such witness shall be paid by the witness if the court issuing it shall determine that his or her failure to answer the subpoena was willful and without just cause. Excuse. 9. Contempt. Failure by any person without adequate cause to obey a subpoena served upon him or her shall be deemed a contempt of the court from which a subpoena is issued. If the subpoena was not issued by a court, the disobedience thereto shall be punished in accordance with the applicable law or rule. 10. Exceptions. The provisions of sections 8 and 9 of this rule shall not apply to a witness who resides more than 100 kilometers from his or her residence to the place where he or she is to testify by the ordinary course of travel, or to a detention prisoner if no permission of the court in which his or her case is pending was obtained. Rule 22. Computation of time. 1. How to compute time. In computing any period of time prescribed or allowed by these rules, or by order of the court, or by any applicable statute, the day of the act or event from which the designated period of time begins to run is to be excluded, and the date of performance included. If the last day of the period as thus computed falls on a Saturday, a Sunday, or a legal holiday in the place where the court sits, the time shall not run until the next working day. 2. Effect of interruption. Should an act be done which effectively interrupts the running of the period, the allowable period after such interruption shall start to run on the day after notice of the cessation of the cause thereof. Rule 23. Depositions pending actions. 1. Depositions pending action when may be taken. Upon ex parte motion of a party, the testimony of any person, whether a party or not, may be taken by deposition upon oral examination or written interrogatories. The attendance of witnesses may be compelled by the use of a subpoena as provided in Rule 21. Depositions shall be taken only in accordance with these rules. The deposition of a person confined in prison may be taken only by leave of court on such terms as the court prescribes. 2. Scope of examination. Unless otherwise ordered by the court as provided by Section 16 or 18 of this rule, the deponent may be examined regarding any matter not privileged, which is relevant to the subject of the pending action, whether relating to the claim or defense of any other party, including the existence, description, nature, custody, condition, and location of any books, documents, or other tangible things, and the identity and location of persons having knowledge of relevant facts. 3. Examination and cross-examination. Examination and cross-examination of deponents may proceed as permitted at the trial under Sections 3 to 18 of Rule 132. 4. Use of depositions. At the trial or upon the hearing of a motion or an interlocutory proceeding, any part or all of a deposition, so far as admissible under the rules of evidence, may be used against any party who was present or represented at the taking of the deposition or who had due notice thereof, in accordance with any of the following provisions. A. Any deposition may be used by any party for the purpose of contradicting or impeaching the testimony of the deponent as a witness. B. The deposition of a party or of anyone who at the time of taking the deposition was an officer, director, or managing agent of a public or private corporation, partnership, or association, which is a party may be used by an adverse party for any purpose. C. The deposition of a witness, whether or not a party, may be used by any party for any purpose if the court finds 1. That the witness is dead, or 2. That the witness resides at a distance more than 100 kilometers from the place of trial or hearing, or is out of the Philippines, unless it appears that his or her absence was procured by the party offering the deposition, or 3. That the witness is unable to attend or testify because of age, sickness, infirmity, or imprisonment, or 4. That the party offering the deposition has been unable to procure the attendance of the witness by subpoena, or 5, upon application and notice that such exceptional circumstances exist as to make it desirable, in the interest of justice and with due regard to the importance of presenting the testimony of witnesses orally in open court, to allow the deposition to be used, and D, if only part of a deposition is offered in evidence by a party, the adverse party may require him or her to introduce all of it which is relevant to the part introduced, and any party may introduce any other parts. 5. Effect of substitution of parties. Substitution of parties does not affect the right to use depositions previously taken, and when an action has been dismissed and another action involving the same subject is afterward brought between the same parties or their representatives or successors in interest, all depositions lawfully taken and duly filed in the former action may be used in the latter as if originally taken therefore. 6. Objections to admissibility. Subject to the provisions of Section 29 of this rule, objections may be made at a trial or hearing to receiving in evidence any deposition or part thereof for any reason which would require the exclusion of the evidence if the witness were then present and testifying. 7. Effect of taking depositions. A party shall not be deemed to make a person his or her own witness for any purpose by taking his or her deposition. 8. Effect of using depositions. The introduction and evidence of the deposition or any part thereof for any purpose other than that of contradicting or impeaching the deponent makes a deponent the witness of the party introducing the deposition, but this shall not apply to the use by adverse party of a deposition as described in paragraph B of section 4 of this rule. 9. Rebutting this deposition. At the trial or hearing, any party may rebut any relevant evidence contained in a deposition, whether introduced by him or her by any other party. 10. Persons before whom depositions may be taken within the Philippines. Within the Philippines, depositions may be taken before any judge, notary public, or the person referred to in Section 14 hereof. 11. Persons before whom depositions may be taken in foreign countries. In a foreign state or country, depositions may be taken a. On notice before a Secretary of Embassy or Legation, Consul General, Consul, Vice Consul, or Consular Agent of the Republic of the Philippines. B. Before such person or officer as may be appointed by commission or under letters rogatory, or C. The person referred to in Section 14 hereof. 12. Commission or letters rogatory. A commission or letters rogatory shall be issued only when necessary or convenient, on application and notice, and on such terms and with such direction as are just and appropriate. Officers may be designated in notices or commissions either by name or descriptive title, and letters rogatory may be addressed to the appropriate judicial authority in the foreign country. 13. Disqualification by interest. No deposition shall be taken before a person who is a relative within the 6th degree of consanguinity or affinity, or employee or counsel of any of the parties, or who is a relative within the same degree or employee of such counsel, or who is financially interested in the action. 14. Stipulations regarding taking of depositions. If the parties so stipulate in writing, depositions may be taken before any person authorized to administer oaths at any time or place in accordance with these rules, and when so taken may be used like other depositions. 15. Deposition upon oral examination, notice, time, and place. A party desiring to take the deposition of any person upon oral examination shall give reasonable notice in writing to every other party to the action. The notice shall state the time and place for taking the deposition, and the name and address of each person to be examined if known, and if the name is not known, a general description sufficient to identify him or her or the particular class or group to which he or she belongs. On motion of any party upon whom the notice is served, the court may for cause known shown in large or short in the time. 16. Orders for the protection of parties and deponents. After notice is served for taking a deposition by oral examination, upon motion seasonably made by any party or by the person to be examined and for good cause shown, the court in which the action is pending may make the following orders. A. That the deposition shall not be taken. B. That deposition may be taken only at some designated place other than that stated in the notice. C. That the deposition may be taken only on written interrogatories. D. That certain matters shall not be inquired into. That the scope of the examination shall be held with no one present except the parties to the action and their officers or counsel. That after being sealed, the deposition shall be opened only by order of the court. That secret processes, developments, or research need not be disclosed. Or that the parties shall simultaneously file specified documents or information enclosed in sealed envelopes to be opened as directed by the court. The court may make any other order which justice requires to protect the party or witness from annoyance, embarrassment, or oppression. 17. Record of examination. Oath objections. The officer before whom the deposition is to be taken shall put the witness on oath and shall personally or by someone acting under his or her direction and in his or her presence record the testimony of the witness. The testimony shall be taken stenographically unless the parties agree otherwise. All objections made at the time of the examination to the qualifications of the officer taking the deposition, or to the manner of taking it, or to the evidence presented, or to the conduct of any party, and any other objection to the proceedings shall be noted by the officer upon the deposition. Evidence objected to shall be taken subject to the objections. In lieu of participating in the oral examination, parties served with notice of taking a deposition may transmit written interrogatories to the officers, who shall propound them to the witness and record the answers verbatim. 18. Motion to terminate or limit examination. At any time during the taking of the deposition on motion or petition of any party or of the deponent, and upon a showing that the examination is being conducted in bad faith or in such manner as unreasonably to annoy, embarrass, or oppress the deponent or party, the court in which the action is pending or the regional trial court of the place where the deposition is being taken may order the officer conducting the examination to cease forthwith from taking the deposition or may limit the scope and manner of the taking of the deposition as provided in Section 16 of this rule. If the order made terminates the examination, it shall be resumed thereafter only upon the order of the court in which the action is pending. Upon demand of the objecting party or deponent, the taking of the deposition shall be suspended for the time necessary to make a notice for an order. In granting or refusing such order, the court may impose upon either party or upon the witness the requirements or expenses as the court may deem reasonable. 19. Submission to witness changes signing. When the testimony is fully transcribed, the deposition shall be submitted to the witness for examination and shall be read to or by him or her, unless such examination and reading are waived by the witness and by the parties. Any changes in form or substance which the witness desires to make shall be entered upon the deposition by the officer with a statement of the reasons given by the witness for making them. The deposition shall then be signed by the witness, unless the parties by stipulation waive the signing or the witness is ill or cannot be found or refuses to sign. If the deposition is not signed by the witness, the officer shall sign it and state on the record the fact of the waiver or of the illness or absence of the witness or the fact of the refusal to sign together with the reason given therefor, if any, and the deposition may then be used as fully as though signed, unless on a motion to suppress under Section 29F of this rule, the court holds that the reasons given for the refusal to sign require rejection of the deposition in whole or in part. 20. Certification and filing by officer. The officer shall certify on the deposition that the witness was duly sworn to by him or her, and that the deposition is a true record of the testimony given by the witness. He or she shall then securely seal the deposition in an envelope endorsed with the title of the action, and mark deposition of here insert the name of witness. It shall promptly file it with the court in which the action is pending, or send it by registered mail to the clerk thereof for filing. 21. Notice of filing. The officer taking the deposition shall give prompt notice of its filing to all the parties. 22. Furnishing copies. Upon payment of reasonable charges, therefore, the officer shall furnish a copy of the deposition to any party or to the deponent. 23. Failure to attend of party giving notice. If the party giving the notice of the taking of the deposition fails to attend and proceed therewith, and another attends in person or by counsel pursuant to the notice, the court may order the party giving the notice to pay such other party the amount of the reasonable expenses incurred by him or her and his or her counsel in so attending, including reasonable attorney's fees. 24. Failure of party giving notice to serve subpoena. If the party giving the notice of the taking of a deposition of a witness fails to serve a subpoena upon him or her, and the witness, because of such failure, does not attend, and if another party attends in person or by counsel because he or she expects the deposition of that witness to be taken, the court may order the party giving the notice to pay such other party the amount of the reasonable expenses incurred by him or her and his or her counsel in so attending, including reasonable attorney's fees. 25. Deposition upon written interrogatories, service of notice and of interrogatories. A party desiring to take the deposition of any person upon written interrogatories shall serve them upon every other party with a notice stating the name and address of the person who is to answer them, and the name or descriptive title and address of the officer before whom the deposition is to be taken. Within 10 calendar days thereafter, a party so served may serve cross interrogatories upon the party proposing to take the deposition. Within 5 calendar days thereafter, the latter may serve redirect interrogatories upon a party who has served cross-interrogatories. Within 3 calendar days after being served with redirect interrogatories, a party may serve cross-interrogatories upon the party proposing to take the deposition. 26. Officers to take responses and prepare record. A copy of the notice and copies of all interrogatories served shall be delivered by the party taking the deposition to the officer designated in the notice, who shall proceed promptly, in the manner provided by sections 17, 19, and 20 of this rule, to take the testimony of the witness in response to the interrogatories and to prepare, certify, and file or mail the deposition, attaching thereto the copy of the notice and the interrogatories received by him or her. 27. Notice of filing and furnishing copies. When a deposition upon interrogatories is filed, the officer taking it shall promptly give notice thereof to all the parties and may furnish copies to them or to the deponent upon payment of reasonable charges therefor. 28. Orders for the protection of parties and deponents. After the service of the interrogatories and prior to the taking of the testimony of the deponent, the court in which the action is pending on motion promptly made by a party or a deponent, and for good cause shown, may make any order specified in sections 15 and 16 and 18 of this rule, which is appropriate and just, or an order that the deposition shall not be taken before the officer designated in the notice, or that it shall not be taken except upon oral examination. 29. Effect of errors and irregularities in depositions. A. As to notice, all errors and irregularities in the notice for taking a deposition are waived unless written objection is promptly served upon the party giving the notice. B. As to disqualification of officer, objection to taking a deposition because of disqualification of the officer before whom it is to be taken is waived unless made before the taking of the deposition begins or as soon thereafter as the disqualification becomes known or could be discovered with reasonable diligence. C. As to competency or relevancy of evidence, objections to the competency of a witness or the competency, relevancy, or materiality of testimony are not waived by failure to make them before or during the taking of the deposition, unless the ground of the objection is one which might have been obviated or removed if presented at that time. D. As to oral examination and other particulars, errors and irregularities occurring at the oral examination in the manner of taking the deposition, in the form of the questions or answers, in the oath or affirmation, or in the conduct of the parties, and errors of any kind which might be obviated, removed, or cured if promptly prosecuted, are waived unless a reasonable objection thereto is made at the taking of the deposition. E. As to form of written interrogatories, objections to the form of written interrogatories submitted under sections 25 and 26 of this rule are waived unless served in writing upon the party propounding them within the time allowed for serving succeeding cross or other interrogatories and within 3 calendar days after service of the last interrogatories authorized. E. As to manner of preparation, errors and irregularities in the manner in which the testimony is transcribed or the deposition is prepared, signed, certified, sealed, endorsed, transmitted, filed, or otherwise dealt with by the officer under section 17, 19, 20, and 26 of these rules are waived unless a motion to suppress the deposition or some part thereof is made with reasonable promptness after such defect is, or with due diligence might have been ascertained. 24. Depositions before action or pending appeal.
1. Depositions before action petition. A person who desires to perpetuate his or her own testimony or that of another person regarding any matter that may be cognizable in any court of the Philippines may file a verified petition in the court of the place of the residence of any expected adverse party. 2. Contents of petition. The petition shall be entitled in the name of the petitioner and shall show a. That the petitioner expects to be a party to an action in the Court of the Philippines, but is presently unable to bring it or cause it to be brought. B. The subject matter of the expected action and his or her interest therein, the facts which he or she desires to establish by the proposed testimony, and his or her reasons for desiring to perpetuate it. D. The names are a description of the persons he or she expects will be adverse parties, and their addresses so far as known. And E. The names and addresses of the persons to be examined and the substance of the testimony which he or she expects to elicit from each, and shall ask for an order authorizing the petitioner to take the depositions of the persons to be examined named in the petition for the purpose of perpetuating their testimony. 3. Notice and service. The petitioner shall serve a notice upon each person named in the petition as an expected adverse party, together with a copy of the petition, stating that the petitioner will apply to the court at the time and place named therein for the order described in the petition. At least 20 calendar days before the date of the hearing, the court shall cause notice thereof to be served on the parties and prospective deponents in the manner provided for service of summons. 4. Order and examination. If the court is satisfied that the perpetuation of the testimony may prevent a failure or delay of justice, it shall make an order designating or describing the persons whose deposition may be taken and specifying the subject matter of the examination and whether the depositions shall be taken upon oral examination or written interrogatories. The depositions may then be taken in accordance with Rule 23 before the hearing. 5. Reference to court. For the purpose of applying Rule 23 to depositions for perpetuating testimony, each reference therein to the court in which the action is pending shall be deemed to refer to the court in which the petition for such deposition was filed. 6. Use of depositions. If a deposition to perpetuate testimony is taken under this rule, or if, although not so taken, it would be admissible in evidence, it may be used in any action involving the same subject matter subsequently brought in accordance with the provisions of Sections 4 and 5 of Rule 23. 7. Depositions pending appeal. If an appeal has been taken from a judgment of a court, including the Court of Appeals in proper cases, or before the taking of the appeal, if the time therefore has not expired, the court in which a judgment was rendered may allow the taking of depositions of witnesses to perpetuate their testimony for use in the event of further proceedings in the said court. In such case, the party who desires to perpetuate the testimony may make a motion in the said court for leave to take the depositions upon the same notice and service thereof as if the action was pending therein. The motion shall state a. The names and addresses of the persons to be examined and the substance of the testimony which he or she expects to elicit from each, and b. The reason for perpetuating their testimony. If the court finds that the perpetuation of the testimony is proper to avoid a failure or delay of justice, it may make an order allowing the depositions to be taken, and thereupon the depositions may be taken and used in the same manner and under the same conditions as are prescribed in these rules for deposition in pending actions. Rule 25. Interrogatories to parties. 1. Interrogatories to parties, service thereof. Upon ex parte motion, any party desiring to elicit material and relevant facts from any adverse parties shall file and serve upon the latter written interrogatories to be answered by the party served, or, if the party served is a public or private corporation or a partnership or association, by any officer thereof competent to testify in its behalf. 2. Answer to interrogatories.
The interrogatories shall be answered fully in writing and shall be signed and sworn to by the person making them. The party upon whom the interrogatories have been served shall file and serve a copy of the answers on the party submitting the interrogatories within 15 calendar days after service thereof, unless the court on motion and for good cause shown, extends or shortens the time. 3. Objections to interrogatories. Objections to any interrogatories may be presented to the court within 10 calendar days after service thereof, with notice as in case of a motion, and answers shall be deferred until the objections are resolved, which shall be at as early a time as is practicable. 4. Number of interrogatories. No party may, without leave of court, serve more than one set of interrogatories to be answered by the same party. 5. Scope and use of interrogatories. Interrogatories may relate to any matter that can be inquired into under Section 2 of Rule 23, and the answers may be used for the same purposes provided in Section 4 of the same rule. 6. Effect of failure to serve within written interrogatories. Unless thereafter allowed by the court for good cause shown and to prevent a failure of justice, a party not served with written interrogatories may not be compelled by the adverse party to give testimony in open court or to give a deposition pending appeal. 26. Admission by adverse party. 1. Request for admission. At any time after issue have been joined, a party may file and serve upon any other party a written request for the admission by the latter of the genuineness of any material and relevant document described in and exhibited with the request, or of the truth of any material and relevant matter of fact set forth in the request. Copies of the documents shall be delivered with the request unless copies have already been furnished. 2. Implied admission. Each of the matters of which an admission is requested shall be deemed admitted unless within a period designated in the request, which shall not be less than 15 calendar days after service thereof, or within such further time as the court may allow on motion, the party to whom the request is directed files and serves upon the party requesting the admission a sworn statement either denying specifically the matters of which an admission is requested or setting forth in detail the reasons why he or she cannot truthfully either admit or deny those matters. Objections to any request for admission shall be submitted to the court by the party requested within the period for and prior to the filing of his or her sworn statement as contemplated in the preceding paragraph, and his or her compliance therewith shall be deferred until such objections are resolved, which resolution shall be made as early as practicable. 3. Effect of admission. Any admission made by a party pursuant to such request is for the purpose of the pending action only and shall not constitute an admission by him or her for any other purpose, nor may the same be used against him or her in any other proceeding. For withdrawal, the court may allow the party making an admission under this rule, whether express or implied, to withdraw or amend it upon such terms as may be just. 5. Effect of failure to file and serve request for admission. Unless otherwise allowed by the court for good cause shown and to prevent a failure of justice, a party who fails to file and serve a request for admission on the adverse party of material and relevant facts at issue which are or ought to be within the personal knowledge of the latter shall not be permitted to present evidence on such facts. 27. Production or inspection of documents or things. 1. Motion for production or inspection order. Upon motion of any party showing good cause, therefore, the court in which an action is pending may a. Order any party to produce and permit the inspection and copying or photographing by or on behalf of the moving party of any designated documents, papers, books, accounts, letters, photographs, objects, or tangible things not privileged which constitute or contain evidence material to any matter involved in the action and which are in his or her possession, custody, or control, or b. Order any party to permit entry upon designated land or other property in his or her possession or control for the purpose of inspecting, measuring, surveying, or photographing the property or any designated relevant object or operation thereon. The order shall specify the time, place, and manner of making the inspection and taking copies and photographs, and may prescribe such terms and conditions as are just. 28. Physical and mental examination of persons. 1. When examination may be ordered. In an action in which the mental or physical condition of a party is in controversy, the court in which the action is pending may, in its discretion, order him or her to submit to a physical or mental examination by a physician. 2. Order for examination. The order for examination may be made only on motion for good cause shown and upon notice to the party to be examined and to all other parties, and shall specify the time, place, manner, conditions, and scope of the examination and the person or persons by whom it is to be made. 3. Report of findings. If requested by the party examined, the party causing the examination to be made shall deliver to him or her a copy of a detailed written report of the examining physician, setting out his or her findings and conclusions. After such request and delivery, the party causing the examination to be made shall be entitled, upon request, to receive from the party examined a like report of any examination previously or thereafter made of the same mental or physical condition. If the party examined refuses to deliver such report, the court on motion and notice may make an order requiring delivery on such terms as are just, and if a physician fails or refuses to make such a report, the court may exclude his or her testimony if offered at the trial. 4. Waiver of privilege. By requesting and obtaining a report of the examination so ordered by taking the deposition of the examiner, the party examined waives any privilege he or she may have in that action or any other involving the same controversy regarding the testimony of every other person who has examined or may thereafter examine him or her in respect of the same mental or physical examination. Rule 29. Refusal to comply with modes of discovery. 1. Refusal to answer. If a party or other deponent refuses to answer any question upon oral examination, the examination may be completed on other matters or adjourned as the proponent of the question may prefer. The proponent may thereafter apply to the proper court of the place where the deposition is being taken for an order to compel an answer. The same procedure may be availed of when a party or a witness refuses to answer any interrogatory submitted under Rules 23 or 25. If the application is granted, the court shall require the refusing party or deponent to answer the question or interrogatory, and if it also finds that the refusal to answer was without substantial justification, it may require the refusing party or deponent or the counsel advising the refusal, or both of them, to pay the proponent the amount of the reasonable expenses incurred in obtaining the order, including attorney's fees. If the application is denied and the court finds that it was filed without substantial justification, the court may require the proponent or the counsel advising the filing of the application, or both of them, to pay to the refusing party or deponent the amount of the reasonable expenses incurred in opposing the application, including attorney's fees. Section 2. Contempt of Court. If a party or other witness refuses to be sworn or refuses to answer any question after being directed to do so by the court of the place in which the deposition is being taken, the refusal may be considered a contempt of that court. 3. Other consequences. If any party or an officer or managing agent of a party refuses to obey an order made under Section 1 of this rule requiring him or her to answer designated questions, or an order under Rule 27 to produce any a document or other thing for inspection, copying, or photographing, or to permit it to be done, or to permit entry upon land or other property, or an order made under Rule 28 requiring him or her to submit to a physical or mental examination, the court may make such orders in regard to the refusal as are just, and among others the following: an order that the matters regarding which the questions were asked, or the character or description of the thing or land, or the contents of the paper, or the physical or mental condition of the party, or any other designated facts shall be taken to be established for the purposes of the action in accordance with the claim of the party obtaining the order. B. An order refusing to allow the disobedient party to support or oppose designated claims or defenses, or prohibiting him or her from introducing in evidence designated documents or things or items of testimony, or from introducing evidence of physical or mental condition. C. An order striking out pleadings or parts thereof, or staying further proceedings until the order is obeyed, or dismissing the action or proceeding or any part thereof, or rendering a judgment by default against a disobedient party. And D. In lieu of any of the foregoing orders, or in addition thereto, an order directing the arrest of any party or agent of a party for disobeying any of such orders, except an order to submit to a physical or mental examination. 4. Expenses on refusal to admit. If a party, after being served with a request under Rule 26 to admit the genuineness of any document or the truth of any matter of fact, serves a sworn denial thereof, and if the party requesting the admissions thereafter proves the genuineness of such document or the truth of any such matter of fact, he or she may apply to the court for an order requiring the other party to pay him or her the reasonable expenses incurred in making such proof, including reasonable attorney's fees, unless the court finds that there were good reasons for the denial or that admissions sought were of no substantial importance, such order shall be issued. 5. Failure of party to attend or serve answers. If a party or an officer or managing agent of a party willfully fails to appear before the officer who is to take his or her deposition after being served with a proper notice or fails to serve answers to interrogatories submitted under Rule 25, after proper service of such interrogatories, the court on motion and notice may strike out all or any part of any pleading of that party, or dismiss the action or proceeding or any part thereof, or enter a judgment by default against that party, and in its discretion order him or her to pay reasonable expenses incurred by the other, including attorney's fees. 6. Expenses against the Republic of the Philippines. Expenses and attorney's fees are not to be imposed upon the Republic of the Philippines under this rule. Rule 30, Trial, Section 1, Schedule of Trial. The parties shall strictly observe the scheduled hearings as agreed upon and set forth in the pre-trial order. A. The schedule of the trial dates for both plaintiff and defendant shall be continuous and within the following periods. I. The initial presentation of plaintiff's evidence shall be set not later than 30 calendar days after the termination of the pre-trial conference. Plaintiff shall be allowed to present its evidence within a period of 3 months or 90 calendar days, which shall include the date of the judicial dispute resolution if necessary. II. The initial presentation of defendant's evidence shall be set not later than 30 calendar days after the court's ruling on plaintiff's formal offer of evidence. The defendant shall be allowed to present its evidence within a period of 3 months or 90 calendar days. III. The period for the presentation of evidence on the third, fourth, etc. party claim, counterclaim, or cross-claim shall be determined by the court, the total of which shall in no case exceed 90 calendar days. And I4. If deemed necessary, the court shall set the presentation of the parties' respective rebuttal evidence, which shall be completed within a period of 30 calendar days. B. The trial dates may be shortened depending on the number of witnesses to be presented, provided that the presentation of evidence of all parties shall be terminated within a period of 10 months or 300 calendar days. If there are no third, fourth, etc. party claim, counterclaim, or cross-claim, the presentation of evidence shall be terminated within a period of 6 months or 180 calendar days. The court shall decide and serve copies of its decision to the parties within a period not exceeding 90 calendar days from the submission of the case for resolution, with or without memoranda. Section 2. Adjournments and postponements. A court may adjourn a trial from day to day and to any stated time, as the expeditious and convenient transaction of business may require, but shall have no power to adjourn a trial for a longer period than 1 month for each adjournment, nor more than 3 months in all, except when authorized in writing by the Court Administrator, Supreme Court. The party who caused the postponement is warned that the presentation of evidence must still be terminated on the remaining dates previously agreed upon. 3. Requisites of motion to postpone trial for illness of party or counsel. A motion to postpone a trial on the ground of illness of a party or counsel may be granted if it appears upon affidavit or sworn certification that the presence of such party or counsel at the trial is indispensable, and that the character of his or her illness is such as to render his or her non-attendance excusable. 4. Hearing days and calendar call. Trial shall be held from Monday to Thursday, and courts shall call the cases at exactly 8:30 a.m. and 2 p.m. pursuant to Administrative Circular Number 399. Hearing on motions shall be held on Fridays pursuant to Section 8, Rule 15. All courts shall ensure the posting of their court calendars outside their courtrooms at least 1 day before the scheduled hearings pursuant to OCA Circular Number 250-2015. 5. Order of Trial. subject to the provisions of Section 2 of Rule 31, and unless the court, for special reasons, otherwise directs, the trial shall be limited to issues stated in the pretrial order and shall proceed as follows. A. The plaintiff shall adduce evidence in support of his or her complaint. B. The defendant shall then adduce evidence in support of his or her defense, counterclaim, cross-claim, and third-party complaint. C. The third-party defendant, if any, shall adduce evidence of his or her defense, counterclaim, cross-claim, and fourth-party complaint. D. The fourth party, and so forth, if any, shall adduce evidence of the material facts pleaded by them. E. The parties against whom any counterclaim or cross-claim has been pleaded shall adduce evidence in support of their defense in the order to be prescribed by the court. F. The parties may then respectively adduce rebutting evidence only unless the court, for good reasons and in the furtherance of justice, permits them to adduce evidence upon the original case, and G. Upon admission of the evidence, the case shall be deemed submitted for decision unless the court directs the parties to argue or to submit their respective memoranda or any further pleadings. If several defendants or third-party defendants and so forth, having separate defenses, appear by different counsel, the court shall determine the relative order of presentation of their evidence. 6. Oral offer of exhibits. The offer of evidence, the comment or objection thereto, and the court ruling shall be made orally in accordance with sections 34 to 40 of Rule 132. 7. Agreed statement of facts. The parties to any action may agree, in writing, upon the facts involved in the litigation and submit the case for judgment on the facts agreed upon without the introduction of evidence. If the parties agree only on some of the facts in issue, the trial shall be held as to the disputed facts in such order as the court shall prescribe. 8. Suspension of actions. The suspension of actions shall be governed by the provisions of the Civil Code and other laws. 9. Judge to receive evidence. Delegation to clerk of court. The judge of the court where the case is pending shall personally receive the evidence to be adduced by the parties. However, in default or ex parte hearings and in any case where the parties agree in writing, the court may delegate the reception of evidence to its clerk of court who is a member of the bar. The clerk of court shall have the power to rule on objections to any question or to the admission of exhibits, which objections shall be resolved by the court upon submission of his or her report and the transcripts within 10 calendar days from termination of the hearing. Rule 31. Consolidation or severance. Section 1. Consolidation. When actions involving a common question of law or fact are pending before the court, it may order a joint hearing or trial of any or all the matters in issuing the actions. It may order all the actions consolidated, and it may make such orders concerning proceedings therein as may tend to avoid unnecessary costs or delay. 2. Separate trials. The court, in furtherance of convenience or to avoid prejudice, may order a separate trial of any claim, cross-claim, counterclaim, or third-party complaint, or of any separate issue or of any number of claims, cross-claims, counterclaims, third-party complaints, or issues. Rule 32. Trial by Commissioner. 1. Reference by consent. By written consent of both parties, the court may order any or all of the issues in a case to be referred to a commissioner, to be agreed upon by the parties, or to be appointed by the court. As used in these rules, the word commissioner includes a referee, an auditor, and an examiner. 2. Reference ordered on motion. When the parties do not consent, the court may, upon the application of either or of its own motion, direct a reference to a commissioner in the following cases. A. When the trial of an issue of fact requires the examination of a long account on either side, in which case the commissioner may be directed to hear and report upon the whole issue or any specific question involved therein. B. When the taking of an account is necessary for the information of the court before judgment or for carrying a judgment or order into effect. C. When a question of fact other than upon the pleadings arises upon motion or otherwise in any stage of a case or for carrying a judgment or order into effect. 3. Order of reference. Powers of the commissioner. When a reference is made, the clerk shall forthwith furnish the commissioner with a copy of the order of reference. The order may specify or limit the powers of the commissioner and may direct him or her to report only upon particular issues or to do or perform particular acts or to receive and report evidence only, and may fix the date for beginning and closing the hearings and for the filing of his or her report, subject to the specifications and limitations stated in the order The Commissioner has and shall exercise the power to regulate the proceedings in every hearing before him or her, and to do all acts and take all measures necessary or proper for the efficient performance of his or her duties under the order. He or she may issue subpoenas and subpoenas duces tecum, swear witnesses, and unless otherwise provided in the order of reference, he or she may rule upon the admissibility of evidence. The trial or hearing before him or her shall proceed in all respects as it would if held before the court. 4. Oath of Commissioner. Before entering upon his or her duties, the Commissioner shall be sworn to a faithful and honest performance thereof. 5. Proceedings before Commissioner. Upon receipt of the order of reference, unless otherwise provided therein, the Commissioner shall forthwith set a time and place for the first meeting of the parties or their counsel to be held within 10 calendar days after the date of the order of reference, and shall notify the parties or their counsel. 6. Failure of parties to appear before Commissioner. If a party fails to appear at the time and place appointed, the Commissioner may proceed ex parte or, in his or her discretion, adjourn the proceedings to a future day, giving notice to the absent party or his or her counsel of the adjournment. 7. Refusal of witness. The refusal of a witness to obey a subpoena issued by the Commissioner or to give evidence before him or her shall be deemed a contempt of the court which appointed the Commissioner. 8. Commissioner shall avoid delays. It is the duty of the Commissioner to proceed with all reasonable diligence. Either party on notice to the parties and Commissioner may apply to the court for an order requiring the Commissioner to expedite the proceedings and to make his or her report. 9. Report of Commissioner. Upon the completion of the trial or hearing or proceeding before the Commissioner, he or she shall file with the court his or her report in writing upon the matters submitted to him or her by the order of reference. When his or her powers are not specified or limited, he or she shall set forth his or her findings of fact and conclusions of law in his or her report. He or she shall attach thereto all exhibits, affidavits, depositions, papers, and a transcript, if any, of the testimonial evidence presented before him or her. 10. Notice to parties of the filing of report. Upon the filing of the report, the parties shall be notified by the clerk, and they shall be allowed 10 calendar days within which to signify grounds of objections to the findings of the report if they so desire. Objections to the report based upon grounds which were available to the parties during the proceedings before the Commissioner, other than objections to the findings and conclusions therein set forth, shall not be considered by the court unless they were made before the Commissioner. 11. Hearing upon report. Upon the expiration of the period of 10 calendar days referred to in the preceding section, the report shall be set for hearing, after which the court shall issue an order adopting, modifying, or rejecting the report in whole or in part, or recommitting it with instructions, or requiring the parties to present further evidence before the Commissioner or the court. 12. Stipulations as to findings. When the parties stipulate that the Commissioner's findings of fact shall be final, only questions of law shall thereafter be considered. 13. Compensation of Commissioner. The court shall allow the Commissioner such reasonable compensation as the circumstances of the case warrant, to be taxed as costs against the defeated party or apportioned as justice requires. Rule 33. Demurrer to evidence. Section 1. Demurrer to evidence. After the plaintiff has completed the presentation of his or her evidence, the defendant may move for dismissal on the ground that upon the facts and the law, the plaintiff has shown no right to relief. If his or her motion is denied, he or she shall have the right to present evidence. If the motion is granted, but on appeal the order of dismissal is reversed, he or she shall be deemed to have waived the right to present evidence. 2. Action on demurrer to evidence. A demurrer to evidence shall be subject to the provisions of Rule 15. The order denying the demurrer to evidence shall not be subject of an appeal or petition for certiorari, prohibition, or mandamus before judgment. Rule 34. Judgment on the pleadings. 1. Judgment on the pleadings. Where an answer fails to tender an issue or otherwise admits the material allegations of the adverse party's pleading, the court may, on motion of that party, direct judgment on such pleading. However, in actions for declaration of nullity or annulment of marriage or for legal separation, the material facts alleged in the complaint shall always be proved. 2. Action and motion for judgment on the pleadings. The court may motu proprio or on motion render judgment on the pleadings if it is apparent that the answer fails to tender an issue or otherwise admits the material allegations of the adverse party's pleadings.
Otherwise, the motion shall be subject to the provisions of Rule 15 of these rules. Any action of the court on a motion for judgment on the pleading shall not be subject of an appeal or petition for certiorari, prohibition, or mandamus. Rule 35. Summary Judgments. Section 1. Summary Judgment for Claimant. A party seeking to recover upon a claim, counterclaim, or cross-claim, or to obtain a declaratory relief may, at any time after the pleading and answer thereto has been served, move with supporting affidavits, depositions, or admissions for a summary judgment in his or her favor upon all or any part thereof. 2. Summary judgment for defending party. A party against whom a claim, counterclaim, or cross-claim is asserted or a declaratory relief is sought may at any time move with supporting affidavits, depositions, or admissions for a summary judgment in his or her favor as to all or any part thereof. 3. Motion and proceedings thereon. The motion shall cite the supporting affidavits, depositions, or admissions, and the specific law relied upon. The adverse party may file a comment and serve opposing affidavits, depositions, or admissions within a non-extendable period of 5 calendar days from receipt of the motion, unless the court orders the conduct of a hearing. Judgment sought shall be rendered forthwith if the pleadings, supporting affidavits, depositions, and admissions on file show that, except as to the amount of damages, there is no genuine issue as to any material fact and that the moving party is entitled to judgment as a matter of law. Any action of the court on a motion for summary judgment shall not be subject of an appeal or petition for certiorari, prohibition, or mandamus. 4. Case not fully adjudicated on motion. If on motion under this rule, judgment is not rendered upon the whole case or for all the relief sought, and a trial is necessary, the court may, by examining the pleadings and the evidence before it and by interrogating counsel, ascertain what material facts exist without substantial controversy, including the extent to which the amount of damages or other relief is not in controversy, and direct such further proceedings in the action as are just. The facts so ascertained shall be deemed established, and the trial shall be conducted on the controverted facts accordingly. 5. Form of affidavits and supporting papers. Supporting and opposing affidavits shall be made on personal knowledge, shall set forth such facts as would be admissible in evidence, and shall show affirmatively that the affiant is competent to testify to the matters stated therein. Certified true copies of all papers or parts thereof referred to in the affidavit shall be attached thereto or served therewith. 6. Affidavits in bad faith. Should it appear to its satisfaction at any time that any of the affidavits presented pursuant to this rule are presented in bad faith or solely for the purpose of delay, the court shall forthwith order the offending party or counsel to pay to the other party the amount of the reasonable expenses which the filing of the affidavits cost him or her to incur, including attorney's fees. It may, after hearing further, adjudge the offending party or counsel guilty of contempt. Rule 36. Judgments, final orders, and entry thereof. Section 1. Rendition of judgments and final orders. A judgment or final order determining the merits of the case shall be in writing, personally, and directly prepared by the judge, stating clearly and distinctly the facts and the law on which it is based, signed by him, and filed with the clerk of the court. 2. Entry of judgments and final orders. If no appeal or motion for new trial or reconsideration is filed within the time provided in these rules, the judgment or final order shall forthwith be entered by the clerk in the book of entries of judgments. The date of finality of the judgment or final order shall be deemed to be the date of its entry. The record shall contain the dispositive part of the judgment or final order and shall be signed by the clerk with a certificate that such judgment or final order has become final and executory. 3. Judgment for or against one or more of several parties. Judgment may be given for or against one or more of several plaintiffs and for or against one or more of several defendants. When justice so demands, the court may require the parties on each side to file adversary pleadings as between themselves and determine their ultimate rights and obligations. 4. Several judgments. In an action against several defendants, the court may, when a several judgment is proper, render judgment against one or more of them, leaving the action to proceed against the others. 5. Separate judgments.
When more than one claim for relief is presented in an action, the court at any stage, upon a determination of the issues material to a particular claim and all counterclaims arising out of the transaction or occurrence, which is the subject matter of the claim, may render a separate judgment disposing of such claim. The judgment shall terminate the action with respect to the claim so disposed of, and the action shall proceed as to the remaining claims. In case a separate judgment is rendered, the court by order may stay its enforcement until the rendition of a subsequent judgment or judgments, and may prescribe such conditions as may be necessary to secure the benefit thereof to the party in whose favor the judgment is rendered. Section 6. Judgment against entity without juridical personality. When judgment is rendered against two or more persons sued as an entity without juridical personality, the judgment shall set out their individual or proper names if known. Rule 37. New trial or reconsideration. Section 1. Grounds of and period for filing motion for new trial or reconsideration. Within the period for taking an appeal, the aggrieved party may move the trial court to set aside the judgment or final order and grant a new trial for one or more of the following causes materially affecting the substantial rights of said party. A. Fraud, accident, mistake, or excusable negligence which ordinary prudence could not have guarded against, and by reason of which such aggrieved party has probably been impaired in his rights, or B. Newly discovered evidence which he could not, with reasonable diligence, have discovered and produced at the trial, and which, if presented, would probably alter the result. Within the same period, the aggrieved party may also move for reconsideration upon the grounds that the damages awarded are excessive, that the evidence is insufficient to justify the decision or final order, or that the decision or final order is contrary to law. 2. Contents of motion for new trial or reconsideration and notice thereof. The motion shall be made in writing stating the ground or grounds therefore, a written notice of which shall be served by the movant on the adverse party. A motion for new trial shall be proved in the matter provided for proof of motions. A motion for the cause mentioned in paragraph A of the preceding section shall be supported by affidavits of merits which may be rebutted by affidavits. A motion for the cause mentioned in paragraph B shall be supported by affidavits of the witnesses by whom such evidence is expected to be given, or by duly authenticated documents which are proposed to be introduced in evidence. A motion for reconsideration shall point out specifically the findings or conclusions of the judgment or final order which are not supported by the evidence or which are contrary to law, making express reference to the testimonial or documentary evidence or to the provisions of law alleged to be contrary to such findings or conclusions. A pro forma motion for new trial or reconsideration shall not toll the reglementary period of appeal. 3. Action upon motion for new trial or reconsideration. A trial court may set aside the judgment or final order and grant a new trial upon such terms as may be just or may deny the motion. If the court finds that excessive damages have been awarded or that the judgment or final order is contrary to the evidence or law, it may amend such judgment or final order accordingly. 4. Resolution of motion. A motion for new trial or reconsideration shall be resolved within 30 days from the time it is submitted for resolution. 5. Second motion for new trial. A motion for new trial shall include all grounds then available, and those not so included shall be deemed waived. A second motion for new trials based on the ground not existing nor available when the first motion was made may be filed within the time herein provided, excluding the time during which the first motion had been pending. No party shall be allowed a second motion for reconsideration of a judgment or final order. 6. Effect of granting of motion for new trial. If a new trial is granted in accordance with the provisions of this rule, the original judgment or final order shall be vacated, and the action shall stand for trial de novo, but the recorded evidence taken upon the formal trial, in so far as the same is material and competent to establish the issues, shall be used at the new trial without retaking the same. 7. Partial new trial or reconsideration. If the grounds for a motion under this rule appear to the court to affect the issues as to only a part or less than all of the matter in controversy, or only one or less than all of the parties to it, the court may order a new trial or grant a reconsideration as to such issues, if severable, without interfering with the judgment or final order upon the rest. 8. Effect of order for partial new trial. When less than all of the issues are ordered or tried, the court may either enter a judgment or final order as to the rest, or stay the enforcement of such judgment or final order until after the new trial. 9. Remedy against order denying a motion for new trial or reconsideration. An order denying a motion for new trial or reconsideration is not appealable, the remedy being an appeal from the judgment or final order. Rule 38. Relief from judgments, orders, or other proceedings. Section 1. Petition for relief from judgment, order, or other proceedings. When a judgment or final order is entered or any other proceeding is thereafter taken against a party in any court through fraud, accident, mistake, or excusable negligence, he may file a petition in such court and in the same case praying that the judgment, order, or proceeding be set aside. 2. Petition for relief from denial of appeal. When a judgment or final order is rendered by any court in a case, and a party thereto, by fraud, accident, mistake, or excusable negligence, has been prevented from taking an appeal, he may file a petition in such court and in the same case praying that the appeal be given due course. 3. Time for filing petition, contents and verification. A petition provided for in either of the preceding sections of this rule must be verified, filed within 60 days after the petitioner learns of the judgment, final order, or other proceeding to be set aside, and not more than 6 months after such judgment or final order was entered, or such proceeding was taken, and must be accompanied by affidavits showing the fraud, accident, mistake, or excusable negligence relied upon, and the facts constituting the petitioner's good and substantial cause of action or defense, as the case may be. 4. Order to file an answer. If the petition is sufficient in form and substance to justify relief, the court in which it is filed shall issue an order requiring the adverse parties to answer the same within 15 days from the receipt thereof. The order shall be served in such manner as court may direct, together with copies of the petition and the accompanying affidavits. 5. Preliminary injunction pending proceedings. The court in which the petition is filed may grant such preliminary injunction as may be necessary for the preservation of the rights of the parties upon the filing by the petitioner of a bond in favor of the adverse party. Condition that if the petition is dismissed or the petitioner fails on the trial of the case upon its merits, he will pay the adverse party all damages and costs that may be awarded to him by reason of the issuance of such injunction or the other proceedings following the petition. But such injunction shall not operate to discharge or extinguish any lien which the adverse party may have acquired upon the property of the petitioner. 6. Proceedings after answer is filed. After the filing of the answer or the expiration of the period, therefore, the court shall hear the petition, and if after such hearing it finds that the allegations thereof are not true, the petition shall be dismissed. But if it finds some allegations to be true, it shall set aside the judgment or final order or other proceeding complained of upon such terms as may be just. Thereafter, the case shall stand as if such judgment, final order, or other proceeding had never been rendered, issued, or taken. The court shall then proceed to hear and determine the case as if a timely motion for a new trial or reconsideration had been granted by it. 7. Procedure where the denial of an appeal is set aside. Where the denial of an appeal is set aside, the lower court shall be required to give due course to the appeal and to elevate the record of the appealed case as if a timely and proper appeal had been made. Rule 39. Execution, satisfaction, and effect of judgments. Section 1. Execution upon judgments or final orders. Execution shall issue as a matter of right, on motion, upon a judgment or order that disposes of the action or proceeding upon the expiration of the period to appeal therefrom, if no appeal has been duly perfected. If the appeal has been duly perfected and finally resolved, the execution may forthwith be applied for in the court of origin, on motion of the judgment obligee, submitting therewith certified true copies of the judgment or judgments or final order or orders sought to be enforced and of the entry thereof with notice to the adverse party. The appellate court may, on motion in the same case, when the interest of justice so requires, direct the court of origin to issue the writ of execution. 2. Discretionary execution. A. Execution of a judgment or final order pending appeal. On motion of the prevailing party with notice of the adverse party filed in the trial court while it has jurisdiction over the case and is in possession of either the original record or the record on appeal, as the case may be at the time of the filing of such motion, said court may, in its discretion, order execution of a judgment or final order even before the expiration of the period to appeal. After the trial court has lost jurisdiction, the motion for execution pending appeal may be filed in the appellate court. Discretionary execution may only issue upon good reasons to be stated in a special order after due hearing. B. Execution of several separate or partial judgments. A several separate or partial judgment may be executed under the same terms and conditions as execution of a judgment or final order pending appeal. 3. Stay of discretionary execution. Discretionary execution issued under the preceding section may be stayed upon approval by the proper court of a sufficient supersedes bond filed by the party against whom it is directed, conditioned upon the performance of the judgment or order, allowed to be executed in case it shall be finally sustained in whole or in part. The bond thus given may be proceeded against on motion with notice to the surety. 4. Judgments not stayed by appeal. Judgments and actions for injunction, receivership, counting, and support, and such other judgments as are now or may hereafter be declared to be immediately executory, shall be enforceable after their rendition and shall not be stayed by an appeal not taken therefrom, unless otherwise ordered by the trial court. On appeal therefrom, the appellate court in its discretion may make an order suspending, modifying, restoring, or granting the injunction, receivership, accounting, or award of support. The stay of execution shall be upon such terms as to bond or otherwise as may be considered proper for the security or protection of the rights of the adverse party. 5. Effect of reversal of executed judgment. Where the executed judgment is reversed totally or partially, or annulled on appeal or otherwise, the trial court may, on motion, issue such orders of restitution or reparation of damages as equity and justice may warrant under the circumstances. 6. Execution by motion or by independent action. A final and executory judgment or order may be executed on motion within 5 years from the date of its entry. After the lapse of such time and before it is barred by the statute of limitations, a judgment may be enforced by action. The revived judgment may also be enforced by motion within 5 years from the date of its entry and thereafter by action before it is barred by the statute of limitations. 7. Execution in case of death of party. In case of death of a party, execution may issue or be enforced in the following manner. A. In case of the death of the judgment obligee upon the application of his executor or administrator or successor in interest. B. In case of the death of the judgment obligor against his executor or administrator or successor in interest, if the judgment be for the recovery of real or personal property or the enforcement of a lien thereon. C. In case of the death of the judgment obligor, after execution is actually levied upon any of his property, the same may be sold for the satisfaction of the judgment obligation, and the officer making the sale shall account to the corresponding executor or administrator for any surplus in his hands. 8. Issuance, form, and contents of a writ of execution. The writ of execution shall 1. Issue in the name of the Republic of the Philippines from the court which granted the motion. 2. State the name of the court, the case number and title, the dispositive part of the subject judgment or order. And 3. Require the sheriff or other proper officer to whom it is directed to enforce the writ according to its terms in the manner hereinafter provided. A. If execution be against the property of the judgment obligor, to satisfy the judgment with interest out of the real or personal property of such judgment obligor. B. If it be against real or personal property in the hands of personal representatives, heirs, devisees, legatees, tenants, or trustees of the judgment obligor, to satisfy the judgment with interest out of such property. C. If it be for the sale of real or personal property, to sell such property, describing it, and apply the proceeds in conformity with the judgment, the material parts of which shall be recited in the writ of execution. D. If it be for the delivery of the possession of real or personal property, to deliver the possession of the same, describing it to the party entitled thereto, and to satisfy any costs, damages, rents, or profits covered by the judgment out of the personal property of the person against whom it was rendered, and if sufficient personal property cannot be found, and then out of the real property. And E. In all cases, the writ of execution shall specifically state the amount of the interest, costs, damages, rents, or profits due as of the date of the issuance of the writ, aside from the principal obligation under the judgment. For this purpose, the motion for execution shall specify the amounts of the foregoing reliefs sought by the movement. 9. Execution of judgments for money. How enforced? A. Immediate payment on demand. The officer shall enforce an execution of a judgment for money by demanding from the judgment obligor the immediate payment of the full amount stated in the writ of execution and all lawful fees. The judgment obligor shall pay in cash, certified bank check payable to the judgment obligee, or any other form of payment acceptable to the latter, the amount of the judgment debt under proper receipt directly to the judgment obligee or his authorized representative if present at the time of payment. The lawful fees shall be handed under proper receipt to the executing sheriff, who shall turn over the said amount within the same day to the clerk of court of the court that issued the writ. If the judgment obligee or his authorized representative is not present to receive payment, the judgment obligor shall deliver the aforesaid payment to the executing sheriff. The latter shall turn over all the amounts coming into his possession within the same day to the clerk of court of the court that issued the writ, or if the same is not practicable, deposit said amounts to a fiduciary account in the nearest government depository bank of the regional trial court of the locality. The clerk of said court shall thereafter arrange for the remittance of the deposit to the account of the court that issued the writ, whose clerk of court shall then deliver said payment to the judgment obligee in satisfaction of the judgment. The excess, if any, shall be delivered to the judgment obligor, while the lawful fees shall be retained by the clerk of court for disposition as provided by law. In no case shall the executing sheriff demand that any payment by check be made payable to him. B. Satisfaction by levy. If the judgment obligor cannot pay or all or part of the obligation in cash, certified bank check or other mode of payment acceptable to the judgment obligee, the officer shall levy upon the properties of the judgment obligor of every kind and nature whatsoever which may be disposed of for value and not otherwise exempt from execution, giving the latter the option to immediately choose which property or part thereof may be levied upon, sufficient to satisfy the judgment. If the judgment obligor does not exercise the option, the officer shall first levy on the personal properties, if any, and then on the real properties if the personal properties are insufficient to answer for the judgment. The sheriff shall sell only a sufficient portion of the personal or real property of the judgment obligor which has been levied upon. When there is more property of the judgment obligor than is sufficient to satisfy the judgment and lawful fees, he must sell only so much of the personal or real property as is sufficient to satisfy the judgment and lawful fees. Real property, stocks, shares, debts, credits, and other personal property, or any interest in either real or personal property, may be levied upon in like manner and with like effect as under a writ of attachment. C. Garnishment of debts and credits. The officer may levy on debts due the judgment obligor and other credits, including bank deposits, financial interests, royalties, commissions, and other personal property not capable of manual delivery in the possession or control of third parties. Levy shall be made by serving notice upon the person owing such debts or having in his possession or control such credits to which the judgment obligor is entitled. The garnishment shall cover only such amount as will satisfy the judgment and all lawful fees. The garnishee shall make a written report to the court within 5 days from service of the notice of garnishment, stating whether or not the judgment obligor has sufficient funds or credits to satisfy the amount of the judgment. If not, the report shall state how much funds or credits the garnishee holds for the judgment obligor. The garnished amount in cash or certified bank check issued in the name of the judgment obligee shall be delivered directly to the judgment obligee within 10 working days from service of notice on said garnishee requiring such delivery, except the lawful fees which shall be paid directly to the court. In the event there are two or more garnishees holding deposits or credits sufficient to satisfy the judgment, the judgment obligor, if available, shall have the right to indicate the garnishee or garnishees who shall be required to deliver the amount due. Otherwise, the choice shall be made by the judgment obligee. The executing sheriff shall observe the same procedure under paragraph A with the same respect to delivery of payment to the judgment obligee. Section 10. Execution of judgments for a specific act. A. Conveyance, delivery of deeds or other specific acts, vesting title. If a judgment directs a party to execute a conveyance of land or personal property, or to deliver deeds or other documents, or to perform any other specific act in connection therewith, and the party fails to comply within the time specified, the court may direct the act to be done at the cost of the disobedient party by some other person appointed by the court, and the act when done shall have like effect as if done by the party. If real or personal property is situated within the Philippines, the court in lieu of directing a conveyance thereof may by an order divest the title of any party and vest it in others, which shall have the force and effect of a conveyance executed in due form of law. B. Sale of real or personal property. If the judgment be for the sale of real or personal property, to sell such property, describing it, and apply the proceeds in conformity with the judgment. C. Delivery or restitution of real property. The officer shall demand of the person against whom the judgment for the delivery or restitution of real property is rendered, and all persons claiming rights under him to peaceably vacate the property within 3 working days, and restore possession thereof to the judgment obligee. Otherwise, the officer shall oust all such persons therefrom with the assistance, if necessary, of appropriate peace officers, and employing such means as may be reasonably necessary, to retake possession and place the judgment obligee in possession of such property. Any costs, damages, rents, or profits awarded by the judgment shall be satisfied in the same manner as a judgment for money. D. Removed of improvements on property subject of execution. When the property subject of the execution contains improvements constructed or planted by the judgment obligor or his agent, the officer shall not destroy, demolish, or remove said improvements except upon special order of the court, issued upon motion of the judgment obligee after due hearing, and after the former has failed to remove the same within a reasonable time fixed by the court. E. Delivery of personal property. In judgments for the delivery of personal property, the officer shall take possession of the same, and forthwith deliver it to the party entitled thereto, and satisfy any judgment for money as therein provided. 11. Execution of special judgments. When a judgment requires the performance of any act other than those mentioned in the 2 preceding sections, a certified copy of the judgment shall be attached to the writ of execution, and shall be served by the officer upon the party against whom the same is rendered, or upon any other person required thereby, or by law, to obey the same, and such party or person may be punished for contempt if he disobeys such judgment. 12. Effect of levy on execution as to third persons. The levy on execution shall create a lien in favor of the judgment obligee over the right, title, and interest of the judgment obligor in such property at the time of the levy, subject to liens and encumbrances then existing. 13. Property exempt from execution. Except as otherwise expressly provided by law, the following property and no other shall be exempt from execution: A. The judgment obligor's family home as provided by law, or the homestead in which he resides, and land necessarily used in connection therewith. B. Ordinary tools and implements personally used by him in his trade, employment, or livelihood. C. Three horses, or three cows, or three carabaos, or other beasts of burden, such as the judgment obligor may select necessarily used by him in his ordinary occupation. D. His necessary clothing and articles for ordinary personal use, excluding jewelry. E. Household furniture and utensils necessary for housekeeping and used for that purpose by the judgment obligor and his family, such as the judgment obligor may select of a value not exceeding 100,000 pesos. F. Provision for individual or family use sufficient for 4 months. G. The professional libraries and equipment of judges, lawyers, physicians, pharmacists, dentists, engineers, surveyors, clergymen, teachers, and other professionals, not exceeding 300,000 pesos in value. H. One fishing boat and accessories not exceeding the total value of 100,000 pesos owned by a fisherman and by the lawful use of which he earns his livelihood. I. So much of the salaries, wages, or earnings of the judgment obligor for his personal services within the 4 months preceding the levy as are necessary for the support of his family. J. Lettered gravestones. K. Monies, benefits, privileges, or annuities accruing or in any manner growing out of any life insurance. L. The right to receive legal support or money or property obtained as such support or any pension or gratuity from the government. M. Property specially exempted by law. But no article or species of property mentioned in this section shall be exempt from execution issued upon a judgment recovered for its price or upon a judgment of foreclosure of a mortgage thereon. 14. Return of writ of execution. The writ of execution shall be returnable to the court issuing it immediately after the judgment has been satisfied in part or in full. If the judgment cannot be satisfied in full within 30 days after his receipt of the writ, the officer shall report to the court and state the reason therefor. Such writ shall continue in effect during the period within which the judgment may be enforced by motion. The officer shall make a report to the court every 30 days on the proceedings taken thereon until the judgment is satisfied in full or its effectivity expires. The returns or periodic reports shall set forth the whole of the proceedings taken, and shall be filed with the court and copies thereof promptly furnished the parties. 15. Notice of sale of property on execution. Before the sale of property on execution, notice thereof must be given as follows. A. In case of perishable property, by posting written notice of the time and place of the sale in 3 public places, preferably in conspicuous areas of the municipal or city hall, post office, and public market in the municipality or city where the sale is to take place, for such time as may be reasonable, considering the character and condition of the property. B. In case of other personal property, by posting a similar notice in the 3 public places above mentioned for not less than 5 days. C. In case of real property, by posting for 20 days in the 3 public places above mentioned, a similar notice particularly describing the property and stating where the property is to be sold and if the assessed value of the property exceeds 50,000 pesos, by publishing a copy of the notice once a week for 2 consecutive weeks in one newspaper selected by raffle, whether in English, Filipino, or any major regional language published, edited, and circulated or in the absence thereof, having general circulation in the province or city. D. In all cases, written notice of the sale shall be given to the judgment obligor at least 3 days before the sale, except as provided in paragraph A hereof, where notice shall be given at any time before the sale, in the same manner as personal service of pleadings and other papers are provided by Section 6 of Rule 13. The notice shall specify the place, date, and exact time of the sale, which should not be earlier than 9 o'clock in the morning and not later than 2 o'clock in the afternoon. The place of the sale may be agreed upon by the parties. In the absence of such agreement, the sale of real property or personal property not capable of manual delivery shall be held in the office of the clerk of court of the regional trial court or the municipal trial court which issued the writ or which was designated by the appellate court. In the case of personal property capable of manual delivery, the sale shall be held in the place where the property is located.
Section 16. Proceedings for property claimed by third person. If the property levied on is claimed by any person other than the judgment obligor or his agent, and such person makes an affidavit of his title thereto or right to the possession thereof, stating the grounds of such right or title, and serves the same upon the officer making the levy and a copy thereof upon the judgment obligee, the officer shall not be bound to keep the property, unless such judgment obligee, on demand of the officer, files a bond approved by the court to indemnify the third-party claimant in a sum not less than the value of the property levied on. In case of disagreement as to such value, the same shall be determined by the court issuing the writ of execution. No claim for damages for the taking or keeping of the property may be enforced against the bond unless the action therefore is filed within 120 days from the date of the filing of the bond. The officer shall not be liable for damages for the taking or keeping of the property to any third-party claimant if such bond is filed. Nothing herein contained shall prevent such claimant or any third person from vindicating his claim to the property in a separate action, or prevent the judgment obligee from claiming damages in the same or a separate action against a third-party claimant who filed a frivolous or plainly spurious claim. When the writ of execution is issued in favor of the Republic of the Philippines or any officer duly representing it, the filing of such bond shall not be required, and in case the sheriff or levying officer is sued for damages as a result of the levy, he shall be represented by the Solicitor General, and if held liable therefor, the actual damages adjudged by the court shall be paid by the National Treasurer out of such funds as may be appropriated for the purpose. 17. Penalty for selling without notice or removing or defacing notice. An officer selling without the notice prescribed by Section 15 of this rule shall be liable to pay punitive damages in the amount of 5,000 pesos to any person injured thereby, in addition to his actual damages, both to be recovered by motion in the same action, and a person willfully removing or defacing the notice posted, if done before the sale, or before the satisfaction of the judgment, if it be satisfied before the sale, shall be liable to pay 5,000 pesos to any person injured by reason thereof, in addition to his actual damages, to be recovered by motion in the same action. 18. No sale if judgment and costs paid. At any time before the sale of property on execution, the judgment obligor may prevent the sale by paying the amount required by the execution and the costs that have been incurred therein. 19. How property sold on execution. Who may direct manner and order of sale. All sales of property under execution must be made at public auction to the highest bidder to start at the exact time fixed in the notice. After sufficient property has been sold to satisfy the execution, no more shall be sold than any excess property or proceeds of the sale shall be promptly delivered to the judgment obligor or his authorized representative, unless otherwise directed by the judgment or order of the court. When the sale is of real property, consisting of several known lots, they must be sold separately, or when a portion of such real property is claimed by a third person, he may require it to be sold separately. When the sale is of personal property capable of manual delivery, it must be sold within view of those attending the same, and in such parcels as are likely to bring the highest price. The judgment obligor, if present at the sale, may direct the order in which property, real or personal, shall be sold, when such property consists of several known lots or parcels which can be sold to advantage separately. Neither the officer conducting the execution sale nor his deputies can become a purchaser, nor be interested directly or indirectly in any purchase at such a sale. 20. Refusal of purchaser to pay. If a purchaser refuses to pay the amount bid by him for property struck off to him at a sale under execution, the officer may again sell the property to the highest bidder and shall not be responsible for any loss occasioned thereby, but the court may order the refusing purchaser to pay into the court the amount of such loss with costs, and may punish him for contempt if he disobeys the order. The amount of such payment shall be for the benefit of the person entitled to the proceeds of the execution, unless the execution has been fully satisfied, in which event such proceeds shall be for the benefit of the judgment obligor. The officer may thereafter reject any subsequent bid of such purchaser who refuses to pay. 21. Judgment obligee as purchaser. When the purchaser is the judgment obligee and no third-party claim has been filed, he need not pay amount of his judgment. If it does, He shall pay only the excess. 22. Adjournment of sale. By written consent of the judgment obligor and obligee, or their duly authorized representatives, the officer may adjourn the sale to any date and time agreed upon by them. Without such agreement, he may adjourn the sale from day to day if it becomes necessary to do so, for lack of time to complete the sale on the day fixed in the notice or the day to which it was adjourned. 23. Conveyance to purchaser of personal property capable of manual delivery. When the purchaser of any personal property capable of manual delivery pays the purchase price, the officer making the sale must deliver the property to the purchaser and, if desired, execute and deliver to him a certificate of sale. The sale conveys to the purchaser all the rights which a judgment obligor had in such property as of the date of the levy on execution or preliminary attachment. 24. Conveyance to purchaser of personal property not capable of manual delivery. When the purchaser of any personal property not capable of manual delivery pays the purchase price, the officer making the sale must execute and deliver to the purchaser a certificate of sale. Such certificate conveys to the purchaser all the rights which the judgment obligor had in such property as of the date of the levy on execution or preliminary attachment. 25. Conveyance of real property. Certificate thereof given to purchaser and filed with registry of deeds. Upon a sale of real property, the officer must give to the purchaser a certificate of sale containing a particular description of the real property sold, b. the price paid for each distinct lot or parcel, c. the whole price paid by him, d. a statement that the right of redemption expires 1 year from date of the registration of the certification of sale. Such certification must be registered in the registry of deeds of the place where the property is situated. 26. Certificate of sale where property claimed by third person. When a property sold by virtue of a writ of execution has been claimed by a third person, the certificate of sale to be issued by the sheriff pursuant to sections 23, 24, and 25 of this rule shall make express mention of the existence of such third-party claim. 27. Who may redeem real property so sold. Real property sold as provided in the last preceding section, or any part thereof sold separately, may be redeemed in the manner hereinafter provided by the following persons. A. The judgment obligor or his successor in interest in the whole or any part of the property. B. A creditor having a lien by virtue of an attachment, judgment, or mortgage on the property sold or on some part thereof subsequent to the lien under which the property was sold. Such redeeming creditor is termed a redemptioner. 28. Time and manner of and amounts payable on successive redemptions notice to be given and filed. The judgment obligor or redemptioner may redeem the property from the purchaser at any time within 1 year from the date of the registration of the certificate of sale by paying the purchaser the amount of his purchase with 1% per month interest thereon in addition up to the time of redemption, together with the amount of any assessments or taxes which the purchaser may have paid thereon after purchase, and interest on such last named amount at the same rate. And if the purchaser be also a creditor having a prior lien to that of the redemptioner, other than the judgment under which such purchase was made, the amount of such other lien with interest. Property so redeemed may again be redeemed within 60 days after the last redemption upon payment of the sum paid on the last redemption, with 2% thereon in addition, and the amount of any assessments or taxes which the last redemptioner may have paid thereon after redemption by him, with interest on such last named amount, and in addition, the amount of any liens held by said last redemptioner prior to his own with interest. The property may be again, and as often as a redemptioner is so disposed, redeemed from any previous redemptioner within 60 days after the last redemption, on paying the sum paid on the last previous redemption, with 2% thereon in addition, and the amounts of any assessments or taxes which the last previous redemptioner paid after the redemption thereon, with interest thereon, and the amount of any liens held by the last redemptioner prior to his own with interest. Written notice of any redemption must be given to the officer who made the sale, and a duplicate filed with the registry of deeds of the place, and if any assessments or taxes are paid by the redemptioner, or if he has or acquires any lien other than that upon which the redemption was made, notice thereof must in like manner be given to the officer and filed with the registry of deeds. If such notice be not filed, the property may be redeemed without paying such assessments, taxes, or liens.
29. Effect of redemption by judgment obligor, and a certificate to be delivered and recorded thereupon, to whom payments on redemption made. If the judgment obligor redeems, he must make the same payments as are required to effect the redemption by a redemptioner, whereupon no further redemption shall be allowed and he is restored to his estate. The person to whom the redemption payment is made must execute and deliver to him a certificate of redemption acknowledged before a notary public or other officer authorized to take acknowledgments of conveyances of real property. Such certificate must be filed and recorded in the registry of deeds of the place in which the property is situated, and the registrar of deeds must note the record thereof on the margin of the record of the certificate of the sale. The payments mentioned in this and the last preceding sections may be made to the purchaser or redemptioner, or for him to the officer who made the sale. 30. Proof required of redemptioner. A redemptioner must produce to the officer or person from whom he seeks to redeem, and serve with his notice to the officer a copy of the judgment or final order under which he claims the right to redeem, certified by the clerk of the court wherein the judgment or final order is entered, or if he redeems upon a mortgage or other lien, a memorandum of the record thereof, certified by the registrar of deeds, or an original or certified copy of any assignment necessary to establish his claim, and an affidavit executed by him or his agent showing the amount then actually due on the lien. 31. Manner of using premises pending redemption. Waste restraint. Until the expiration of the time allowed for redemption, the court may, as in other proper cases, restrain the commission of waste on the property by injunction on the application of the purchaser or the judgment obligee, with or without notice, but it is not waste for a person in possession of the property at the time of the sale, or entitled to possession afterwards, during the period allowed for redemption, to continue to use it in the same manner in which it was previously used, or to use it in the ordinary course of husbandry, or to make the necessary repairs to buildings thereon while he occupies the property. 32. Rents, earnings, and income of property pending redemption. The purchaser or redemptioner shall not be entitled to receive the rents, earnings, and income of the property sold on execution, or the value of the use and occupation thereof. All rents, earnings, and income derived from the property belong to the judgment obligor until the expiration of his period of redemption. 33. Deed and possession to be given at expiration of redemption period by whom executed or given. If no redemption be made within 1 year from the date of the registration of the certificate of sale, the purchaser is entitled to a conveyance and possession of the property, or if so redeemed whenever 60 days have elapsed and no other redemption has been made, and notice thereof given, has expired, the last redemptioner is entitled to the conveyance and possession, but in all cases, the judgment obligor shall have the entire period of 1 year from the date of the registration of the sale to redeem the property. The deed shall be executed by the officer making the sale, or by his successor in office, and in the latter case shall have the same validity as though the officer making the sale had continued in office and executed it. Upon the expiration of the right of redemption, the purchaser or redemptioner shall be substituted to and acquire all the rights, title, interest, and claim of the judgment obligor to the property as of the time of the levy. The possession of the property shall be given to the purchaser or last redemptioner by the same officer unless a third party is actually holding the property adversely to the judgment obligor. 34. Recovery of price if sale not effective. Revival of judgment. If the purchaser of real property sold on execution, or his successor in interest, fails to recover the possession thereof, or is evicted therefrom in consequence of irregularities in the proceedings concerning the sale, or because the judgment has been reversed or set aside, or because the property sold was exempt from execution, or because a third person has vindicated his claim to the property, he may, on motion in the same action or in a separate action, recover from the judgment obligee the price paid with interest, or so much thereof as has not been delivered to the judgment obligor, or he may, on motion, have the original judgment revived in his name for the whole price with interest, or so much thereof as has been delivered to the judgment obligor. The judgment so revived shall have the same force and effect as an original judgment would have as of the date of the revival, and no more. 35. Right to contribution or reimbursement. When property liable to an execution against several persons is sold thereon, and more than a due proportion of the judgment is satisfied out of the proceeds of the sale of the property of one of them, or one of them pays, without a sale, more than his proportion, he may compel a contribution from the others, and when a judgment is upon an obligation of one of them, a security for another, and the surety pays the amount, or any part thereof, either by sale of his property or before sale, he may compel repayment from the principal. 36. Examination of judgment obligor when judgment unsatisfied. When the return of a writ of execution issued against a property of a judgment obligor or any one of several obligors in the same judgment shows that the judgment remains unsatisfied in whole or in part, the judgment obligee at any time after such return is made shall be entitled to an order from the court which rendered the said judgment, requiring such judgment obligor to appear and be examined concerning his property and income before such court or before a commissioner appointed by it at a specified time and place, and proceedings may thereupon be had for the application of the property and income of the judgment obligor towards the satisfaction of the judgment. But no judgment obligor shall be so required to appear before a court or commissioner outside the province or city in which such obligor resides or is found. 37. Examination of obligor of judgment obligor. When the return of a writ of execution against the property of a judgment obligor shows that the judgment remains unsatisfied in whole or in part, and upon proof to the satisfaction of the court which issued the writ that a person, corporation, or other judicial entity has property of such judgment obligor is indebted to him, the court may, by an order, require such person, corporation, or other juridical entity, or any officer or member thereof, to appear before the court or a commissioner appointed by it, at a time and place within the province or city where such debtor resides or is found, and be examined concerning the same. The service of the order shall bind all credits due to judgment obligor and all money and property of the judgment obligor in the possession or in the control of such person, corporation, or judicial entity from the time of service, and the court may also require notice of such proceeding to be given to any party to the action in such manner as it may deem proper. 38. Enforcement of attendance and conduct of examination. A party or other person may be compelled by an order or subpoena to attend before the court or commissioner to testify as provided in the two preceding sections, and upon failure to obey such order or a subpoena or to be sworn, or to answer as a witness or to subscribe his disposition, may be punished for contempt as other cases. Examinations shall not be unduly prolonged, but the proceedings may be adjourned from time to time. If the examination is before a commissioner, he must state to the court. All examinations and answers before a court, a commissioner must be under oath, and when a corporation or other juridical entity answer, it must be on the oath of an authorized officer or agent thereof. 39. Obligor may pay execution against obligee. After a writ of execution against property has been issued, a person indebted to the judgment obligor may pay to the sheriff holding the writ of execution the amount of his debt or so much thereof as may be necessary to satisfy the judgment in the manner prescribed in Section 9 of this rule, and the sheriff's receipt shall be a sufficient discharge for the amount so paid or directed to be credited by the judgment obligee on the execution. 40. Order for application of property and income to satisfaction of judgment. The court may order any property of the judgment obligor or money due him, not except from execution, in the hands of either himself or another person, or of a corporation or other juridical entity, to be applied to the satisfaction of the judgment, subject to any prior rights over such property. If, upon investigation of his current income and expenses, it appears that the earnings of the judgment obligor for his personal services are more than necessary for the support of his family, the court may order that he pay the judgment in fixed monthly installments, and upon his failure to pay any such installment and due without good excuse, may punish him for indirect contempt. 41. Appointment of receiver. The court may appoint a receiver of the property of the judgment obligor, and it may also forbid a transfer or other disposition of, or any interference with, the property of the judgment obligor not exempt from execution. 42. Sale of ascertainable interest of judgment obligor in real estate. If it appears that the judgment obligor has an interest in real estate in the place in which proceedings are had, as mortgagor or mortgagee or otherwise, and his interest therein can be ascertained without controversy, the receiver may be ordered to sell and convey such real estate or the interest of the obligor therein, and such sale shall be conducted in all respects in the same manner as is provided for the sale of real estate upon execution, and the proceedings thereon shall be approved by the court before the execution of the deed. 43. Proceedings when indebtedness denied or another person claims the property. If it appears that a person or corporation alleged to have property of the judgment obligor or to be indebted to him claims a property in the adverse to him or denies the debt, the court may authorize by an order made to that effect the judgment obliging to institute an action against such or corporation for the recovery of such interest or debt, forbid a transfer or other disposition of such interest or debt with 120 days from notice of the order. Punish may disobedience of such order as for contempt. Such order may be modified or vacated at any time by the court which issued it or by the court in which the action is brought upon such terms as may be just. 44. Entry of satisfaction of judgment by clerk of court. Satisfaction of a judgment shall be entered by the clerk of court in the court docket and in the execution book upon the return of a writ of execution showing the full satisfaction of the judgment, or upon the filing of an admission to the satisfaction of the judgment executed and acknowledged in the same manner as a conveyance of real property by the judgment obligee or by his counsel, unless a revocation of his authority is filed, or upon the endorsement of such admission by the judgment obliging or his counsel on the face of the record of the judgment. 45. Entry of satisfaction with or without admission. Whenever a judgment is satisfied in fact or otherwise than upon an execution, on demand of the judgment obligor, the judgment obligee or his counsel must execute and acknowledge or endorse an admission of the satisfaction as provided in the last preceding section, and after notice and upon motion, the court may order either the judgment obligee or his counsel to do so, or may order the entry of satisfaction to be made without such admission. 46. When principal bound by judgment against surety. When a judgment is rendered against a party who stands as surety for another, the latter is also bound from the time that he has notice of the action or proceeding and an opportunity at the surety's request to join in the defense. 47. Effect of judgments or final orders. The effect of a judgment or final order rendered by a court of the Philippines having jurisdiction to pronounce a judgment or final order may be as follows. A. In case of a judgment or final order against a specific thing or in respect to the probate of a will or the administration respect to the personal, technical, or legal condition or status of a particular person, another, the judgment or final order is inclusive upon the title to the thing, the will or administration, or the condition, status, or relationship of the person. However, the probate of a will or granting of letters of administration should only be prima facie evidence of the death of the testator or intestate. B. In other cases, the judgment or final order is, with respect to the matter directly adjudged or, as to any other matter that could have been raised in relation thereto, conclusive between the parties and their successors in interest by title, subsequent to the commencement of the action or special proceeding, litigating for the same thing and under the same title in the same capacity, and C. In any other litigation between the same parties or their successors in interest that only is deemed to have been adjudged in a former judgment or final order which appears upon its face to have been so adjudged or which was actually necessarily included therein or necessary thereto. 48. Effect of foreign judgments or final orders. The effect of a judgment or final order of a tribunal of a foreign country having jurisdiction to render the judgment or final order is as follows. A. In case of a judgment or final order upon a specific thing, the judgment or final order is conclusive upon the title to the thing. And B. In case of a judgment or final order against a person, the judgment or final order is presumptive evidence of a right as between the parties and their successors in interest by a subsequent title. In either case, the judgment or final order may be repelled by evidence of a want of jurisdiction, want of notice to the party, collusion, fraud, or clear mistake of law or fact.
Appeals. Rule 40. Appeal from municipal trial courts to the regional trial courts. Section 1. Where to appeal. An appeal from a judgment or final order of a municipal trial court may be taken to the regional trial court, exercising jurisdiction over the area to which the former pertains. The title of the case shall remain as it was in the court of origin, but the party appealing the case shall be further referred to as the appellant and the adverse party as the appellee. 2. When to appeal. An appeal may be taken within 15 days after notice to the appellant of the judgment or final order appealed from. Where a record on appeal is required, the appellant shall file a notice of appeal and a record on appeal within 30 days after notice of the judgment or final order. The period of appeal shall be interrupted by a timely motion for new trial or reconsideration. No motion for extension of time to file a motion for new trial or reconsideration shall be allowed. 3. How to appeal. The appeal is taken by filing a notice of appeal with the court that rendered the judgment or final order appealed from. The notice of appeal shall indicate the parties to the appeal, the judgment or final order or part thereof appealed from, and state the material dates showing the timeliness of the appeal. A record on appeal shall be required only in special proceedings and in other cases of multiple or separate appeals. The form and contents of the record on appeal shall be as provided in Section 6, Rule 41. Copies of the notice of appeal and the record on appeal were required shall be served on the adverse party. 4. Perfection of appeal, effect thereof. The perfection of the appeal and the effect thereof shall be governed by the provisions of Section 9, Rule 41. 5. Appellate court docket and other lawful fees. Within the period for taking an appeal, the appellant shall pay to the clerk of the court which rendered the judgment or final order appealed from the full amount of the appellate court docket and other lawful fees. Proof of payment thereof shall be transmitted to the appellate court together with the original record or the record in appeal as the case may be. 6. Duty of the clerk of court. Within 15 days from the perfection of the appeal, the clerk of court or the branch clerk of court of the lower court shall transmit the original record or the record on appeal, together with the transcripts and exhibits which he shall certify as complete to the proper regional trial court. A copy of his letter of transmittal of the record to the appellate court shall be furnished the parties. 7. Procedure in the regional trial court. A. Upon receipt of the complete record or the record in appeal, the clerk of court of the regional trial court shall notify the parties of such fact. B. Within 15 days from such notice, it shall be the duty of the appellant to submit a memorandum which shall briefly discuss the errors imputed to the lower court, a copy of which shall be furnished by him to the adverse party. Within 15 days from receipt of the appellant's memorandum, the appellee may file his memorandum. Failure of the appellant to file a memorandum shall be a ground for dismissal of the appeal. C. Upon the filing of the memorandum of the appellee or the expiration of the period to do so, the case shall be considered submitted for decision. The regional trial court shall decide the case on the basis of the entire record of the proceedings had in the court of origin and such memoranda as are filed. 8. Appeal from orders dismissing case without trial, lack of jurisdiction. If an appeal is taken from an order of the lower court dismissing the case without a trial on the merits, the regional trial court may affirm or reverse it, as the case may be. In case of affirmance and the ground of dismissal is lack of jurisdiction over the subject matter, the regional trial court, if it has jurisdiction thereover, shall try the case on the merits as if the case was originally filed with it. In case of reversal, the case shall be remanded for further proceedings. If the case was tried on the merits by the lower court without jurisdiction over the subject matter, the regional trial court on appeal shall not dismiss the case if it has original jurisdiction thereof, but shall decide the case in accordance with the preceding section, without prejudice to the admission of amended pleadings and additional evidence in the interest of justice. 9. Applicability of Rule 41. The other provisions of Rule 41 shall apply to appeals provided for herein so far as they are not inconsistent with or may serve to supplement the provisions of this rule. Rule 41. Appeal from the regional trial courts. 1. Subject of appeal. An appeal may be taken from a judgment or final order that completely disposes of the case or of a particular matter therein when declared by these rules to be appealable. No appeal may be taken from a. An order denying a petition for relief or any similar motion seeking relief from judgment. B. An interlocutory order. C. An order disallowing or dismissing an appeal. D. An order denying a motion to set aside a judgment by consent, confession, or compromise on the ground of fraud, mistake, or duress, or any other ground vitiating consent. E. An order of execution
F. A judgment or final order for or against one or more of several parties or in separate claims, counterclaims, cross-claims, and third-party complaints while the main case is pending unless the court allows an appeal therefrom. And G. An order dismissing an action without prejudice. In all the above instances where the judgment or final order is not appealable, the aggrieved party may file an appropriate special civil action under Rule 65. 2. Modes of appeal. A. Ordinary appeal. The appeal to the Court of Appeals in cases decided by the regional trial court in the exercise of its original jurisdiction shall be taken by filing a notice of appeal with the court which rendered the judgment or final order appealed from and serving a copy thereof upon the adverse party. No record on appeal shall be required except in special proceedings and other cases of multiple or separate appeals where the law or these rules so require. In such cases, the record on appeal shall be filed and served in like manner. B. Petition for review. The appeal to the Court of Appeals in cases decided by the regional trial court in the exercise of its appellate jurisdiction shall be by petition for review in accordance with Rule 42. C. Appeal by certiorari. In all cases where only questions of law are raised or involved, the appeal shall be to the Supreme Court by petition for review and certiorari in accordance with Rule 45. 3. Period of ordinary appeal. The appeal shall be taken within 15 days from notice of the judgment or final order appealed from. Where a record on appeal is required, the appellant shall file a notice of appeal and a record on appeal within 30 days from notice of the judgment or final order. However, in appeal in habeas corpus cases shall be taken within 48 hours from notice of the judgment or final order appealed from. The period of appeal shall be interrupted by a timely motion for new trial or reconsideration. No motion for extension of time to file a motion for new trial or reconsideration shall be allowed. 4. Appellate court docket and other lawful fees. Within the period for taking an appeal, the appellant shall pay to the clerk of the court which rendered the judgment or final order appealed from the full amount of the appellate court docket and other lawful fees. Proof of payment of said fees shall be transmitted to the appellate court together with the original record or the record on appeal. 5. Notice of appeal. The notice of appeal shall indicate the parties to the appeal, specify the judgment or final order or part thereof appealed from, specify the court to which the appeal is being taken, and state the material dates showing the timeliness of the appeal. 6. Record on appeal, form and contents thereof. The full names of all the parties to the proceedings shall be stated in the caption of the record on appeal, and it shall include the judgment or final order from which the appeal is taken, and in chronological order, copies of only such pleadings, petitions, motions, and all interlocutory orders as are related to the appeal judgment or final order for the proper understanding of the issue involved, together with such data as will show that the appeal was perfected on time. If an issue of fact is to be raised on appeal, the record of appeal shall include by reference all the evidence, testimonial, and documentary taken upon the issue involved. The reference shall specify the documentary evidence by the exhibit numbers or letters by which it was identified when admitted or offered at the hearing, and the testimonial evidence by the names of the corresponding witnesses. If the whole testimonial and documentary evidence in the case is to be included, a statement to that effect will be sufficient without mentioning the names of the witnesses or the numbers or letters of exhibits. Every record on appeal exceeding 20 pages must contain a subject index. 7. Approval of record on appeal. Upon the filing of the record on appeal for approval, and if no objection is filed by the appellee within 5 days from receipt of a copy thereof, the trial court may approve it as presented or upon its own motion, or at the instance of the appellee, may direct its amendment by the inclusion of any omitted matters which are deemed essential to the determination of the issue of law or fact involved in the appeal. If the trial court orders the amendment of the record, the appellant, within the time limited in the order, or such extension thereof as may be granted, or if no time is fixed by the order within 10 days from receipt thereof, shall redraft the record by including therein, in their proper chronological sequence, such additional matters as the court may have directed him to incorporate, and shall thereupon submit a redrafted record for approval upon notice to the appellee in like manner as the original draft. 8. Joint record on appeal. Where both parties are appellants, they may file a joint record on appeal within the times fixed by Section 3 of this rule or that fixed by the court. 9.
Perfection of appeal, effect thereof. A party's appeal by notice of appeal is deemed perfected as to him upon the filing of the notice of appeal in due time. A party's appeal by record on appeal is deemed perfected as to him with respect to the subject matter thereof upon the approval of the record on appeal filed in due time. In appeals by notice of appeal, the court loses jurisdiction over the case upon the perfection of the appeals filed in due time and the expiration of the time to appeal of the other parties. In appeals by record on appeal, the court loses jurisdiction only over the subject matter thereof upon the approval of the records on appeal filed in due time and the expiration of the time to appeal of the other parties. In either case, prior to the transmittal of the record or the record on appeal, the court may issue orders for the protection and preservation of the rights of the parties, which do not involve any matter litigated by the appeal, approve compromises, permit appeals of indigent litigants, order execution pending appeal in accordance with Section 2 of Rule 39 and allow withdrawal of the appeal. 10. Duty of clerk of court of the lower court upon a perfection of appeal. Within 30 days after perfection of all the appeals in accordance with the preceding section, it shall be the duty of the clerk of court of the lower court: A. To verify the correctness of the original record or the record in appeal as the case may be, certification of its correctness. B. To verify the size of the records that will be transmitted to the appellate court. C. If found to be incomplete, to take such measures as may be required to complete the records, availing of the authority that he or the court may exercise for this purpose. And D. To transmit the records to the appellate court. If the efforts to complete the records fail, he shall indicate in his letter of transmittal the exhibits or transcripts not included in the records being transmitted to the appellate court, the reasons for their non-transmittal, and the steps taken or that could be taken to have them available. The clerk of court shall furnish the parties with copies of his letter of transmittal of the records to the appellate court. 11. Transcript. Upon the perfection of the appeal, the clerk shall immediately direct the stenographers concerned to attach to the record of the case 5 copies of the transcripts of the testimonial evidence referred to in the record on appeal. The stenographers concerned shall transcribe such testimonial evidence and shall prepare and affix to their transcripts an index containing the names of the witnesses and the pages wherein their testimonies are found, and the list of the exhibits and the pages wherein each of them appears to have been offered and admitted or rejected by the trial court. Transcripts shall be transmitted to the clerk of the trial court, who shall thereupon arrange the same in the order in which the witnesses testified at the trial, and shall cause the pages to be numbered consecutively. 12. Transmittal. The clerk of the trial court shall transmit to the appellate court the original record or the approved record on appeal within 30 days from the perfection of the appeal, together with the proof of payment of the appellate court docket and other lawful fees, a certified true copy of the minutes of the proceedings, the order of approval, the certificate of correctness, the original documentary evidence referred to therein, and the original and 3 copies of the transcripts. Copies of the transcripts and certified true copies of the documentary evidence shall remain in the lower court for the examination of the parties. 13. Dismissal of appeal. Prior to the transmittal of the original record or the record on appeal to the appellate court, the trial court may motu proprio or on motion dismiss the appeal for having been taken out of time or for non-payment of the docket and other lawful fees within the reglementary period. 42. Rule 42. Petition for review from the original trial courts to the Court of Appeals. 1. How appeals taken. Time for filing. A party desiring to appeal from a decision of the regional trial court rendered in the exercise of its appellate jurisdiction may file a verified petition for review with the Court of Appeals, paying at the same time to the clerk of said court the corresponding docket and other lawful fees, depositing the amount of 500 pesos for costs, and furnishing the regional trial court and the adverse party with a copy of the petition. The petition shall be filed and served within 15 days from notice of the decision sought to be reviewed or of the denial of petitioner's motion for new trial or reconsideration filed in due time after judgment. Upon proper motion and the payment of the full amount of the docket and other lawful fees, and the deposit for costs before the expiration of the reglementary period, the Court of Appeals may grant an additional period of 15 days only within which to file the petition for review. No further extension shall be granted except for the most compelling reason and in no case to exceed 15 days. 2. Form and contents. The petition shall be filed in 7 legible copies, with the original copy intended for the court being indicated as such by the petitioner, and shall a. State the full names of the parties to the case without impeding the lower courts or judges thereof, either as petitioners or respondents. B. Indicate the specific material dates showing that it was filed on time. C. Set forth concisely a statement of the matters involved, the issues raised, the specification of errors of fact or law, or both allegedly committed by the regional trial court, and the reasons or arguments relied upon for the allowance of the appeal. D. Be accompanied by clearly legible duplicate originals or true copies of the judgments or final orders of both lower courts, certified correct by the clerk of court of the regional trial court, the requisite number of plain copies thereof, and of the pleadings and other material portions of the record as would support the allegations of the petition. The petitioner shall also submit together with the petition a certification under oath that he has not heretofore commenced any other action involving the same issues in the Supreme Court, the Court of Appeals or different divisions thereof, or any other tribunal or agency. If there is such other action or proceeding, he must state the status of the same, and if he should thereafter learn that a similar action or proceeding has been filed or is pending before the Supreme Court, the Court of Appeals or different divisions thereof, or any other tribunal or agency, he undertakes to promptly inform the aforesaid courts and other tribunal or agency thereof within 5 days therefrom. 3. Effect of failure to comply with the requirements. The failure of the petitioner to comply with any of the foregoing requirements regarding the payment of the docket and other lawful fees, the deposit for costs, proof of service of the petition, and the contents of and the documents which should accompany the petition shall be sufficient ground for the dismissal thereof. 4. Action on the petition. The Court of Appeals may require the respondent to file a comment on the petition, not a motion to dismiss, within 10 days from notice, or dismiss the petition if it finds the same to be patently without merit, prosecuted manifestly for delay, or that the questions raised therein are too unsubstantial to require consideration. 5. Contents of comment. The comment of the respondent shall be filed in 7 legible copies, accompanied by certified true copies of such material portions of the record referred to therein, together with other supporting papers, and shall a. State whether or not he accepts the statement of matters involved in the petition. B. Point out such inefficiencies or inaccuracies as he believes exist in petitioner's statement of matters involved, but without repetition. And C. State the reasons why the petition should not be given due course. A copy thereof shall be served on the petitioner. C. Due course. If upon the filing of the comment or such other pleadings as the court may allow or require, or after the expiration of the period for the filing thereof, without such comment or pleading having been submitted, the Court of Appeals finds prima facie that the lower court has committed an error of fact or law that will warrant a reversal or modification of the appeal decision, it may accordingly give due course to the petition. 7. Elevation of record. Whenever the Court of Appeals deems it necessary, it may order the clerk of court of the regional trial court to elevate the original record of the case, including the oral and documentary evidence within 15 days from notice. 8. Perfection of appeal, effect thereof. Upon the timely filing of a petition for review and the payment of the corresponding docket and other lawful fees, the appeal is deemed perfected as to the petitioner. The regional trial court loses jurisdiction over the case upon the perfection of the appeals filed in due time and the expiration of the time to appeal of the other parties. However, before the Court of Appeals gives due course to the petition, the regional trial court may issue orders for the protection and preservation of the rights of the parties, which do not involve any matter litigated by the appeal, approve compromises, permit appeals of indigent litigants, order execution pending appeal in accordance with Section 2 of Rule 39, and allow withdrawal of the appeal. B. Except in civil cases decided under the rule on summary procedure, the appeal shall stay the judgment or final order unless the Court of Appeals, the law, or these rules shall provide otherwise. 9. Submission for decision. If the petition is given due course, the Court of Appeals may set the case for oral argument or require the parties to submit memoranda within a period of 15 days from notice. The case shall be deemed submitted for decision upon the filing of the last pleading or memorandum required by these rules or by the court itself. Rule 43. Appeals from the Court of Tax Appeals and quasi-judicial agencies to the Court of Appeals. 1. Scope.
This rule shall apply to appeals from judgments or final orders of the Court of Tax Appeals and from awards, judgments, final orders, or resolutions of or authorized by any quasi-judicial agency in the exercise of its quasi-judicial functions. Among these agencies are the Civil Service Commission, Central Board of Assessment Appeals, Securities and Exchange Commission, Office of the President, Land Registration Authority, Social Security Commission, Civil Aeronautics Board, Bureau of Patents, Trademarks and Technology Transfer, National Electrification Administration, Energy Regulatory Board, National Telecommunications Commission, Department of Agrarian Reform under Republic Act No. 6657, Government Service Insurance System, Employees Compensation Commission, Agricultural Inventions Board, Insurance Commission, Philippine Atomic Energy Commission, Board of Investments, Construction Industry Arbitration Commission, and voluntary arbitrators authorized by law. 2. Cases not covered. This rule shall not apply to judgments or final orders issued under the Labor Code of the Philippines. 3. Where to appeal. An appeal under this rule taken to the Court of Appeals within the period and in the manner herein provided, whether the appeal involves questions of fact, of law, or mixed questions of fact and law. 4. Period of appeal. The appeal shall be taken within 15 days from notice of the award, judgment, final order, or resolution, or from the date of its last publication, if publication is required by law for its effectivity, or of the denial of petitioner's motion for new trial or reconsideration, duly filed in accordance with the governing law of the court or agency a quo. Only one motion for reconsideration shall be allowed. Upon proper motion and the payment of the full amount of the docket fee before the expiration of the reglementary period, the Court of Appeals may grant an additional period of 15 days only within which to file the petition for review. No further extension shall be granted except for the most compelling reason and in no case to exceed 15 days. 5. How appeal taken. Appeal shall be taken by filing a verified petition for review in 7 legible copies with the Court of Appeals with proof of service of a copy thereof on the adverse party and on the court or agency a quo. The original copy of the petition intended for the Court of Appeals shall be indicated as such by the petitioner. Upon the filing of the petition, the petitioner shall pay to the clerk of court of the Court of Appeals the docketing and other lawful fees and deposit the sum of 500 pesos for costs. Exemption from payment of docketing and other lawful fees and the deposit for costs may be granted by the Court of Appeals upon a verified motion setting forth valid grounds therefor. If the Court of Appeals denies the motion, the petitioner shall pay the docketing and other lawful fees and deposit for costs within 15 days from notice of the denial. 6. Contents of the petition. A petition for review shall a. State the full names of the parties to the case without impleading the court or agencies either as petitioners or respondents. B. Contain a concise statement of the facts and issues involved and the grounds relied upon for the review. C. Be accompanied by a clearly legible duplicate original or a certified true copy of the award, judgment, final order, or resolution appealed from, together with certified true copies of such material portions of the record referred to therein and other supporting papers. And D. Contain a sworn certification against forum shopping as provided in the last paragraph of Section 2, Rule 42. The petition shall state the specific material dates showing that it was filed within the period fixed herein. 7. Effect of failure to comply with requirements. The failure of the petitioner to comply with any of the foregoing requirements regarding the payment of the docket and other lawful fees, the deposit for costs, proof of service of the petition, and the contents of and the documents which should accompany the petition shall be sufficient ground for the dismissal thereof. 8. Action on the petition. The Court of Appeals may require the respondent to file a comment on the petition, not a motion to dismiss, within 10 days from notice, or dismiss the petition if it finds the same to be patently without merit, prosecuted, or that the questions raised therein are too unsubstantial to require consideration. And contents of comment. The comment shall be filed within 10 days from notice in 7 legible copies and accompanied by clearly legible certified true copies of such material portions of the record referred to therein, together with other supporting papers. The comment shall a. Point out insufficiencies or inaccuracies in petitioner's statement of facts and issues, and b. State the reasons why the petition should be denied or dismissed. A copy thereof shall be served on the petitioner, and proof of such service shall be filed with the Court of Appeals. D. Due course. If upon the filing of the comment or such other pleadings or documents as may be required or allowed by the Court of Appeals or upon the expiration of the period for the filing thereof,
and on the basis of the petition or the records, the Court of Appeals finds prima facie that the court or agency concerned has committed errors of fact or law that would warrant reversal or modification of the award, judgment, final order, or resolution sought to be reviewed. It may give due course to the petition. Otherwise, it shall dismiss the same. The findings of fact of the court or agency concerned, when supported by substantial evidence, shall be binding on the Court of Appeals. 11. Transmitted of record. Within 15 days from notice that the petition has been given due course, the Court of Appeals may require the court or agency concerned to transmit the original or a legible certified true copy of the entire record of the proceeding under review. The record to be transmitted may be abridged by agreement of all parties to the proceeding. The Court of Appeals may require or permit subsequent correction of or addition to the record. 12. Effect of appeal. The appeal shall not stay the award, judgment, final order, or resolution sought to be reviewed unless the Court of Appeals shall direct otherwise upon such terms as it may deem just. 13. Submission for decision. If the petition is given due course, the Court of Appeals may set the case for oral argument or require the parties to submit memoranda within a period of 15 days from notice. The case shall be deemed submitted for decision upon the filing of the last pleading or memorandum required by these rules or by the Court of Appeals. Procedure in the Court of Appeals, Rule 44, Ordinary Appeal Cases. 1. Title of Cases. In all cases appealed to the Court of Appeals under Rule 41, the title of the case shall remain as it was in the court of origin, but the party appealing the case shall be further referred to as the appellant and the adverse party as the appellee. 2. Counsel and Guardians. The counsel and guardians ad litem of the parties in the court of origin shall be respectively considered as their counsel and guardians ad litem in the Court of Appeals. When others appear or are appointed, notice thereof shall be served immediately on the adverse party and filed with the court. 3. Order of transmittal of record. If the original record or the record on appeal is not transmitted to the Court of Appeals within 30 days after the perfection of the appeal, either party may file a motion with the trial court with notice to the other for the transmittal of such record or record on appeal. 4. Docketing of case. Upon receiving the original record or the record on the appeal and the accompanying documents and exhibits transmitted by the lower court, as well as the proof of payment of the docket and other lawful fees, the clerk of court of the Court of Appeals shall docket the case and notify the parties thereof. Within 10 days from receipt of said notice, the appellant, in appeals by record on appeal, shall file with the clerk of court 7 clearly legible copies of the approved record on appeal, together with the proof of service of 2 copies thereof upon the appellee. Any unauthorized alteration, omission, or addition in the approved record on appeal shall be a ground for dismissal of the appeal. 5. Completion of record. Where the record of the docketed case is incomplete, the clerk of court of the Court of Appeals shall so inform said court and recommend to it measures necessary to complete the record. It shall be the duty of said court to take appropriate action towards the completion of the record within the shortest possible time. 6. Dispensing with complete record. Where the completion of the record could not be accomplished within a sufficient period allotted for said purpose due to insuperable or extremely difficult causes, the court, on its own motion or on motion of any of the parties, may declare that the record and its accompanying transcripts and exhibits so far available are sufficient to decide the issues raised in the appeal and shall issue an order explaining the reasons for such declaration. 7. Appellant's briefs. It shall be the duty of the appellant to file with the court within 45 days from receipt of the notice of the clerk that all the evidence, oral and documentary, are attached to the record. 7 copies of his legibly typewritten, mimeographed or printed brief with proof of service of 2 copies thereof upon the appellee. 8.
Appellee's brief. Within 45 days from receipt of the appellant's brief, the appellee shall file with the court 7 copies of his legibly typewritten, mimeographed, or printed brief, with proof of service of 2 copies thereof upon the appellant. 9. Appellant's reply brief. Within 20 days from receipt of the appellee's brief, the appellant may file a reply brief answering points in the appellee's brief not covered in his main brief. 10. Time for filing memoranda in special cases. In certiorari, prohibition, mandamus, quo warranto, and habeas corpus cases, the parties shall file in lieu of briefs the respective memoranda within a non-extendable period of 30 days from receipt of the notice issued by the clerk that all the evidence, oral and documentary, is already attached to the record. The failure of the appellant to file his memoranda within the period, therefore, may be a ground for dismissal of the appeal. 11. Several appellants or appellees or several counsel for each party. Where there are several appellants or appellees, each counsel representing one or more, but not all of them, shall be served with only one copy of the briefs. When several counsel represent one appellant or appellee, copies of the brief may be served upon any of them. 12. Extension of time for filing briefs. Extension of time for the filing of briefs shall not be allowed, except for good and sufficient cause, and only if the motion for extension is filed before the expiration of the time sought to be extended. 13. Contents of appellant's brief. The appellant's brief shall contain, in the order herein indicated, the following: A. A subject index of the matter in the brief with a digest of the arguments and page references, and a table of cases alphabetically arranged, textbooks and statutes, cited with references to the pages where they are cited. B. An assignment of errors intended to be urged, which errors shall be separately, distinctly, and concisely stated without repetition and numbered consecutively. C. Under the heading Statement of the Case, a clear and concise statement of the nature of the action, a summary of the proceedings, the appealed rulings and orders of the court, the nature of the judgment, and any other matters necessary to an understanding of the nature of the controversy, with page references to the record. D. Under the heading Statement of Facts, a clear and concise statement in the narrative form of the facts admitted by both parties and of those in controversy, together with the substance of the proof relating thereto in sufficient detail to make it clearly intelligible, with page references to the record. E. A clear and concise statement of the issues of fact law to be submitted to the court for its judgment. F. Under the heading Argument, the appellant arguments on each assignment of error with page reference to the record. The authorities relied upon shall be cited by the page of the report at which the case begins and the page of the report on which the citation is found. G. Under the heading Relief, a specification of the order or judgment which the appellant seeks, and H. In cases not brought up by record on appeal, the appellant's brief shall contain, as an appendix, a copy of the judgment or final order appealed from. 13. Contents of appellee's brief. The appellee's brief shall contain, in the order here indicated, the following: A. A subject index of the matter in the brief with a digest of the arguments and page references, and a table of cases alphabetically arranged, textbooks and statutes cited with references to the pages where they are cited. B. Under the heading Statement of Facts, the appellee shall state that he accepts the statement of facts in the appellant's brief, or under the heading Counter Statement of Facts, he shall point out such indeficiencies or inaccuracies as he believes exist in the appellant's statement of facts with references to the pages of the record in support thereof, but without repetition of matters in the appellant's statement of facts. And C. Under the heading Argument, the appellee shall set forth his arguments in the case on each assignment of error with page references to the record. The authorities relied on shall be cited by the page of the report at which the case begins and the page of the report on which the citation is found. 15. Questions that may be raised on appeal. Whether or not the appellant has filed a motion for new trial court below, he may include in his assignment of any question of law or fact that has been raised in the below and which is within the issues framed by the parties. Rule 45. Appeal by certiorari to the Supreme Court. 1. Filing of petition with Supreme Court. A party desiring to appeal by certiorari from a judgment, final order, or resolution of the Court of Appeals, the Sandigan Bayan, the Court of Tax Appeals, the Regional Trial Court, or other courts, whenever authorized by law, may file with the Supreme Court a verified petition for review on certiorari. The petition may include an application for a writ of preliminary injunction or other provisional remedies, and shall raise only questions of law, which must be distinctly set forth. The petitioner may seek the same provisional remedies by verified motion filed in the same action or proceeding at any time during its pendency.
2. Time for filing extension. The petition shall be filed within 15 days from notice of the judgment or final order or resolution appealed from, or of the denial of the petitioner's motion for new trial or reconsideration filed in due time after notice of the judgment. On motion, duly filed and served, with full payment of the docket and other lawful fees, and the deposit for costs before the expiration of the reglementary period, the Supreme Court may for justifiable reasons grant an extension of 30 days only within which to file the petition. 3. Docket and other lawful fees. Proof of service of petition. Unless he has heretofore done so, the petitioner shall pay the corresponding docket and other lawful fees to the clerk of court of the Supreme Court and deposit the amount of 500 pesos for costs at the time of the filing of the petition. Proof of service of a copy thereof on the lower court concerned and on the adverse party shall be submitted together with the petition. 4. Contents of petition. The petition shall be filed in 18 copies, with the original copy intended for the court being indicated as such by the petitioner, and shall a. State the full name of the appealing party as the petitioner and the adverse party as respondent, without impleading the lower courts or judges thereof, either as petitioners or respondents. B. Indicate the material dates showing when notice of the judgment or final order or resolution, subject thereof, was received, when a motion for new trial or reconsideration, if any, was filed, and when notice of the denial thereof was received. C. Set forth concisely a statement of the matters involved and the reasons or arguments relied on for the allowance of the petition. D. Be accompanied by a clearly legible duplicate original or a certified true copy of the judgment or final order or resolution certified by the clerk of court of the court a quo, and the requisite number of plain copies thereof, and such material portions of the record as would support the petition. And E. Contain a sworn certification against forum shopping as provided in the last paragraph of Section 2, Rule 42. 5. Dismissal or denial of petition. The failure of the petitioner to comply with any of the foregoing requirements regarding the payment of the docket and other lawful fees, deposit for costs, proof of service of the petition, and the contents of, and the documents which should accompany the petition, shall be sufficient ground for the dismissal thereof. The Supreme Court may, on its own initiative, deny the petition on the ground that the appeal is without merit or is prosecuted manifestly for delay, or that the questions raised therein are too unsubstantial to require consideration. 6. Review discretionary. A review is not a matter of right, but of sound judicial discretion. It will be granted only when there are special and important reasons therefor. The following, while neither controlling nor fully measuring the court's discretion, indicate the character of the reasons which will be considered. A. When the court a quo has decided a question of substance not theretofore determined by the Supreme Court, or has decided it in a way probably not in accord with law or with the applicable decisions of the Supreme Court, or B. When the court a quo has so far departed from the accepted and usual course of the judicial proceedings, or so far sanctioned such departure by a lower court as to call for an exercise of the power of supervision. 7. Pleadings and documents that may be required. Sanctions. For purposes of determining whether the petition should be dismissed or denied pursuant to Section 5 of this rule, or where the petition is given due course under Section 8 hereof, the Supreme Court may require or allow the filing of such pleadings, briefs, memoranda, or documents as it may deem necessary, within such periods and under such conditions as it may consider appropriate, and impose the corresponding sanctions in case of non-filing or unauthorized filing of such pleadings and documents, or non-compliance with the conditions therefore. 8. Due course. Elevation of records. If the petition is given due course, the Supreme Court may require the elevation of the complete record of the case or specified parts thereof within 15 days from notice. 9. Rule applicable to both civil and criminal cases. The mode of appeal prescribed in this rule shall be applicable to both civil and criminal cases, except in criminal cases where the penalty imposed is death, reclusion perpetua, or life imprisonment. Rule 46. Original cases. 1. Title of cases. In all cases originally filed in the Court of Appeals, the party instituting the action shall be called the petitioner and the opposing party the respondent. 2. To what actions applicable? This rule shall apply to original actions for certiorari, prohibition, mandamus, and quo warranto. Except as otherwise provided, the actions for annulment of judgment shall be governed by Rule 47 for certiorari, prohibition, and mandamus by Rule 65, and for quo warranto by Rule 66. 3.
Contents and filing of petition. Effect of non-compliance with requirements. The petition shall contain the full names and actual addresses of all the petitioners and respondents, a concise statement of the matters involved, the actual factual background of the case, and the grounds relied upon for the relief prayed for. In actions filed under Rule 65, the petition shall further indicate the material dates showing when notice of the judgment or final order or resolution subject thereof was received, when a motion for new trial or reconsideration, if any, was filed, and when notice of the denial thereof was received. It shall be filed in 7 clearly legible copies, together with proof of service thereof on the respondent, with the original copy intended for the court indicated as such by the petitioner, and shall be accompanied by a clearly legible duplicate original or certified true copy of the judgment, order, resolution, or ruling subject thereof, such material portions of the record as are referred to therein, and other documents relevant or pertinent thereto. The certification shall be accomplished by the proper clerk of court, or by his duly authorized representative, or by the proper officer of the court, tribunal, agency, or office involved, or by his duly authorized representative. The other requisite number of copies of the petition shall be accompanied by clearly legible plain copies of all documents attached to the original. The petitioner shall also submit, together with the petition, a sworn certification that he has not theretofore commenced any other action involving the same issues in the Supreme Court, the Court of Appeals, or different divisions thereof, or any other tribunal or agency. If there is such other action or proceeding, he must state the status of the same, and if he should thereafter learn that a similar action or proceeding has been filed or is pending before the Supreme Court, the Court of Appeals, or different divisions thereof, or any other tribunal or agency, he undertakes to promptly inform the aforesaid courts and other tribunal or agency thereof within 5 days therefrom. A petitioner shall pay the corresponding docket and other lawful fees to the clerk of court and deposit the amount of 500 pesos for costs at the time of the filing of the petition. The failure of the petitioner to comply with any of the foregoing requirements shall be sufficient ground for the dismissal of the petition. 4. Jurisdiction over person of respondent, how acquired. The court shall acquire jurisdiction over the person of the respondent by the service on him of its order or resolution indicating its initial action on the petition, or by his voluntary submission to such jurisdiction. 5. Action by the court. The court may dismiss the petition outright with specific reasons for such dismissal, or require the respondent to file a comment on the same within 10 days from notice. Only pleadings required by the court shall be allowed. All other pleadings and papers may be filed only with leave of court. 6. Determination of factual issues. Whenever necessary to resolve factual issues, the court itself may conduct hearings thereon or delegate the reception of the evidence on such issues to any of its members or to an appropriate court, agency, or office. 7. Effect of failure to file comment. When no comment is filed by any of the respondents, the case may be decided on the basis of the record without prejudice to any disciplinary action which the court may take against a disobedient party. Rule 47. Annulment of judgments or final orders and resolutions. 1. Coverage. This rule shall govern the annulment by the Court of Appeals of judgments or final orders and resolutions and civil actions of regional trial courts for which the ordinary remedies of new trial, appeal, petition for relief, or other appropriate remedies are no longer available through no fault of the petitioner. 2. Grounds for annulment. The annulment may be based only on the grounds of extrinsic fraud and lack of jurisdiction. Extrinsic fraud shall not be a valid ground if it was availed of or could have been availed of in a motion for new trial or petition for relief. 3. Period for filing action. If based on extrinsic fraud, the action must be filed within 4 years from its discovery, and if based on lack of jurisdiction, before it is barred by laches or estoppel. 4. Filing and contents of petition. The action shall be commenced by filing a verified petition alleging therein, with particularity, the facts and the law relied upon for annulment, as well as those supporting the petitioner's good and substantial cause of action for defense, as the case may be. The petition shall be filed in 7 clearly legible copies, together with sufficient copies corresponding to the number of respondents. A certified true copy of the judgment or final order or resolution shall be attached to the original copy of the petition intended for the court and indicated as such by the petitioner. A petitioner shall also submit together with the petition affidavits of witnesses or documents supporting the cause of action or defense and a sworn certification that A has not theretofore commenced any other action involving the same issues in the Supreme Court, the Court of Appeals, or different divisions thereof, or any other tribunal or agency, if there is such other action or proceeding. He must state the status of the same, and if he should thereafter learn that a similar action or proceeding has been filed or is pending before the Supreme Court, the Court of Appeals, or different divisions thereof, or any other tribunal or agency, he undertakes to promptly inform the aforesaid courts and other tribunal or agency thereof within 5 days therefrom. 5. Action by the court. Should the court find no substantial merit in the petition, the same may be dismissed outright with specific reasons for such dismissal. Should prima facie merit be found in the petition, the same shall be given due course and summons shall be served on the respondent. C. Procedure. The procedure in ordinary civil cases shall be observed. Should a trial be necessary, the reception of the evidence may be referred to a member of the court or a judge of a regional trial court. 7. Effect of judgment. A judgment of annulment shall set aside a question judgment or final order or resolution, and render the same null and void, without prejudice to the original action being refiled in the proper court. However, where the judgment or final order or resolution is set aside on the ground of extrinsic fraud, the court may on motion order the trial court to try the case, as if a timely motion for new trial had been granted therein. 8. Suspension of prescriptive period. A prescriptive period for the refiling of the aforesaid original action shall be deemed suspended from the filing of such original action until the finality of the judgment of annulment. However, the prescriptive period shall not be suspended where the extrinsic fraud is attributable to the plaintiff in the original action. 9. Relief available. The judgment of annulment may include the award of damages, attorney's fees, and other relief. If the question judgment or final order or resolution had already been executed, the court may issue such orders of restitution or other relief as justice and equity may warrant under the circumstances. 10. Annulment of judgments or final orders of municipal trial courts. An action to annul a judgment or final order of a municipal trial court shall be filed in the regional trial court having jurisdiction over the former. It shall be treated as an ordinary civil action, and sections 2, 3, 4, 7, 8, and 9 of this rule shall be applicable thereto. Rule 38. Preliminary Conference. 1. Preliminary Conference. At any time during the pendency of a case, the court may call the parties and their counsel to a preliminary conference. A. To consider the possibility of an amicable settlement, except when the case is not allowed by law to be compromised. B. To define, simplify, and clarify the issues for determination. C. To formulate stipulations of facts and admissions of documentary exhibits. Limit the number of witnesses to be presented in cases falling within the original jurisdiction of the court or those within its appellate jurisdiction, where a motion for new trial is granted on the ground of newly discovered evidence. And B. To take up such other matters which may aid the court in the prompt disposition of the case. 2. Record of the conference. The proceedings at such conference shall be recorded, and, upon the conclusion thereof, a resolution shall be issued embodying all the actions taken therein, the stipulations and admissions made, and the issues defined. 3. Binding effect of the results of the conference. Subject to such modifications which may be made to prevent manifest injustice, the resolution in the preceding section shall control the subsequent proceedings in the case unless, within 5 days from notice thereof, any party shall satisfactorily show valid cause why the same should not be followed. Rule 49. Oral Argument. 1. When allowed, at its own instance or upon motion of a party, the court may hear the parties in oral argument on the merits of a case or on any material incident in connection therewith. The original argument shall be limited to such matters as the court may specify in its order or resolution. 2. Conduct of oral argument. Unless authorized by the court, only one counsel may argue for a party. The duration allowed for each party, the sequence of the argumentation, and all other related matters shall be as directed by the court. 3. No hearing or oral argument for motions. Motions shall not be set for hearing, and, unless the court otherwise directs, no hearing or oral argument shall be allowed in support thereof. The adverse party may file objections to the motion within 5 days from service, upon the expiration of which such motion shall be deemed submitted for resolution. Rule 50, Dismissal of Appeal. 1. Grounds for dismissal of appeal. An appeal may be dismissed by the Court of Appeals on its own motion or on that of the appellee on the following grounds. A. Failure of the record on appeal to show on its face that the appeal was taken within the period fixed by these rules. B. Failure to file the notice of appeal or the record on appeal within the period prescribed by these rules. C. Failure of the appellant to pay the docket and other lawful fees as provided in Section 5 of Rule 40 and Section 4 of Rule 41. D. Unauthorized alterations, omissions, or additions in the approved record on appeal as provided in Section 4 of Rule 44. E. Failure of the appellant to serve and file the required number of copies of his brief or memorandum within the time provided by these rules. F. Absence of specific assignment of errors in the appellant's brief or of page references to the record as required in Section 13, paragraphs A, C, D, and F of Rule 44. G. Failure of the appellant to take the necessary steps for the correction or completion of the record within the time limited by the court in its order. H. Failure of the appellant to appear at the preliminary conference under Rule 48 or to comply with orders, circulars, or directives of the court without justifiable cause. And I. The fact that the order or judgment appealed from is not appealable. 2. Dismissal of improper appeal to the Court of Appeals. An appeal under Rule 41 taken from the Regional Trial Court to the Court of Appeals, raising only questions of law, shall be dismissed, issues purely of law not being reviewable by said court. Similarly, an appeal by notice of appeal instead of by petition for review from the appellate judgment of a regional trial court shall be dismissed. An appeal erroneously taken to the Court of Appeals shall not be transferred to the appropriate court but shall be dismissed outright. 3. Withdrawal of appeal. An appeal may be withdrawn as of right at any time before the filing of the appellee's brief. Thereafter, the withdrawal may be allowed in the discretion of the court. Rule 41. Judgment. 1. When case deemed submitted for judgment. A case shall be deemed submitted for judgment. A. In ordinary appeals, where no hearing on the merits of the main case is held upon the filing of the last pleading, brief, or memorandum required by the rules, or by the court itself, or the expiration of the period for its filing. Where such a hearing is held upon its termination or upon the filing of the last pleading or memorandum, as may be required or permitted to be filed with the court, or the expiration of the period for its filing. B. In original review, where no comment is filed upon the expiration of the period to comment, where no hearing is held upon the filing of the last pleading required or permitted to be filed by the court, or the expiration of the period for its filing, where a hearing on the merits of the main case is held upon its termination or upon the filing of the last pleading or memorandum as may be required or permitted to be filed by the court, or the expiration of the period for its filing. 2. By whom rendered. The judgment shall be rendered by the members of the court who participated in the deliberation of the merits of the case before its assignment to a member for the writing of the decision. 3. Quorum and voting in the court. The participation of all 3 justices of a division shall be necessary at the deliberation, and the unanimous vote of the 3 justices shall be required for the pronouncement of a judgment or final resolution. If the 3 justices do not reach a unanimous vote, the clerk shall enter the votes of the dissenting justices in the record. Thereafter, the chairman of the division shall refer the case, together with the minutes of the deliberation, to the presiding justice, who shall designate 2 justices chosen by raffle from among all the other members of the court to sit temporarily with them, forming a special division of 5 justices. The participation of all the 5 members of the special division shall be necessary for the deliberation required in Section 2 of this rule, and the concurrence of a majority of such division shall be required for the pronouncement of a judgment or final resolution. 4. Disposition of a case. The Court of Appeals, in the exercise of its appellate jurisdiction, may affirm, reverse, or modify the judgment or final order appealed from, and may direct a new trial or further proceedings to be had. 5. Form of decision. Every decision or final resolution of the court in appealed cases shall clearly and distinctly state the findings of fact and the conclusion of law on which it is based, which may be contained in the decision or final resolution itself, or adopted from those set forth in the decision, order, or resolution appealed from. 6. Harmless error. No error in either the admission or the exclusion of evidence, and no error or defect in any ruling or order or in anything done or omitted by the trial court or by any of the parties is ground for granting a new trial or for setting aside, modifying, or otherwise disturbing a judgment or order, unless refusal to take such action appears to the court inconsistent with substantial justice. The court at every stage of the proceeding must disregard any error or defect which does not affect the substantial rights of the parties. 7. Judgment where there are several parties. In all actions or proceedings, an appeal judgment may be affirmed as to some of the appellants, and reversed as to others, and the case shall thereafter be proceeded with so far as necessary, as if separate actions had been begun and prosecuted, and execution of the judgment of affirmance may be had accordingly, and costs may be adjudged in such cases as the court shall deem proper. 8. Questions that may be decided. No error which does not affect the jurisdiction over the subject matter or the validity of the judgment appealed from or the proceedings therein will be considered unless stated in the assignment of errors or closely related to or dependent on an assigned error and properly argued in the brief, save as the court may pass upon plain errors and clerical errors. 9. Promulgation and notice of judgment. After the judgment or final resolution and dissenting or separate opinions, if any, are signed by the justices taking part, they shall be delivered for filing to the clerk, who shall indicate thereon the date of promulgation, and cause true copies thereof to be served upon the parties or their counsel. 10. Entry of judgments and final resolutions. If no appeal or motion for new trial or reconsideration is filed within the time provided in these rules, the judgment or final resolution shall forthwith be entered by the clerk in the book of entries of judgment. The date when the judgment or final resolution becomes executory shall be deemed as the date of its entry. The record shall contain the dispositive part of the judgment or final resolution and shall be signed by the clerk with a certificate that such judgment or final resolution has become final and executory. 11. Execution of judgment. Except where the judgment or final order or resolution or a portion thereof is ordered to be immediately executory, the motion for its execution may only be filed in the proper court after its entry. In original actions in the Court of Appeals, its writ of execution shall be accompanied by a certified true copy of the entry of judgment or final resolution and addressed to any appropriate officer for its enforcement. In appealed cases where the motion for execution pending appeal is filed in the Court of Appeals at the time that it is in possession of the original record or the record in appeal, the resolution granting such motion shall be transmitted to the lower court from which the case originated, together with a certified true copy of the judgment or final order to be executed, with a directive for such court of origin to issue the proper writ for its enforcement. Rule 52. Motion for reconsideration. 1. Period for filing. A party may file a motion for reconsideration of a judgment or final resolution within 15 days from notice thereof, with proof of service on the adverse party. 2. Second motion for reconsideration. No second motion for reconsideration of a judgment or final resolution by the same party shall be entertained. 3. Resolution of motion. In the Court of Appeals, a motion for reconsideration shall be resolved within 90 days from the date when the court declares it submitted for resolution. 4. Stay of execution. The pendency of a motion for reconsideration filed on time and by the proper party shall stay the execution of the judgment or final resolution sought to be reconsidered unless the court, for good reasons, shall otherwise direct. Rule 53. New trial. Section 1. Period for filing. Grant. At any time after the appeal from the lower court has been perfected and before the Court of Appeals loses jurisdiction over the case, a party may file a motion for a new trial on the ground of newly discovered evidence, which could not have been discovered prior to the trial in the court below by the exercise of due diligence, and which is of such a character as would probably change the result. The motion shall be accompanied by affidavits showing the facts constituting the grounds, therefore, the newly discovered evidence. 2. Hearing and order. The Court of Appeals shall consider the new evidence together with that adduced at the trial below, and may grant or refuse a new trial, or may make such order, with notice to both parties as to the taking of further testimony, either orally in court or by depositions, or render such judgment as ought to be rendered upon such terms as it may deem just. Section 3. Resolution of motion. In the Court of Appeals, a motion for new trial shall be resolved within 90 days from the date when the court declares it submitted for resolution. 4. Procedure in new trial. Unless the court otherwise directs, the procedure in the new trial shall be the same as that granted by a regional trial court.
Rule 54, Internal Business. 1. Distribution of cases among divisions. All the cases of the Court of Appeals shall be allotted among the different divisions thereof for hearing and decision. The Court of Appeals sitting en banc shall make proper orders or rules to govern the allotment of cases among the different divisions, the constitution of such divisions, the regular rotation of justices among them, the filling of vacancies occurring therein, and other matters relating to the business of the court, and such rules shall continue in force until repealed or altered by it or by the Supreme Court. 2. Quorum of the Court. A majority of the actual members of the Court shall constitute a quorum for its sessions en banc. 3 members shall constitute a quorum for the sessions of a division. The affirmative votes of the majority of the members present shall be necessary to pass a resolution of the Court en banc. The affirmative votes of 3 members of the division shall be necessary for the pronouncement of a judgment or final resolution, which shall be reached in consultation before the writing of the opinion by any member of the division. Rule 55. Publication of judgments and final resolutions. 1. Publication. The judgments and final resolutions of the court shall be published in the official gazette and in the reports officially authorized by the court in the language in which they have been originally written, together with the syllabi therefore prepared by the reporter in consultation with the writers thereof. Memoranda of all other judgments and final resolutions not so published shall be made by the reporter and published in the official gazette and the authorized reports. 2. Preparation of opinions for publication. The reporter shall prepare and publish with each reported judgment and final resolution a concise synopsis of the facts necessary for a clear understanding of the case, the names of counsel, the material and controverted points involved, the authorities cited therein, and a syllabus which shall be confined to points of law. 3. General makeup of volumes. The published decisions and final resolutions of the Supreme Court shall be called Philippine Reports, while those of the Court of Appeals shall be known as the Court of Appeals Reports. Each volume thereof shall contain a table of the cases reported and the cases cited in the opinions, with the complete alphabetical index of the subject matters of the volume. It shall consist of not less than 700 pages printed upon good paper, well bound and numbered consecutively in the order of the volumes published. Procedure in the Supreme Court. Rule 56A. Original cases. 1. Original cases cognizable. Only petitions for certiorari, prohibition, mandamus, quo warranto, habeas corpus, disciplinary proceedings against members of the judiciary and attorneys, and cases affecting ambassadors, other public ministers, and consuls may be filed originally in the Supreme Court. 2. Rules applicable. The procedure in original cases for certiorari, prohibition, mandamus, quo warranto, and habeas corpus shall be in accordance with the applicable provisions of the Constitution, laws, and rules 46, 48, 49, 51, 52, and this rule, subject to the following provisions. A. All references in said rules to the Court of Appeal shall be understood to also apply to the Supreme Court. B. The portions of said rules dealing strictly with and specifically intended for appealed cases in the Court of Appeals shall not be applicable. And C. 18 clearly legible copies of the petition shall be filed, together with proof of service and all adverse parties. The proceedings for the disciplinary action against members of the judiciary shall be governed by the laws and rules prescribed therefore, and those against attorneys by Rule 139 as amended. Rule 56B. Appealed cases. 3. Mode of appeal. An appeal to the Supreme Court may be taken only by a petition for review on certiorari, except in criminal cases where the penalty imposed is death, reclusion perpetua, or life imprisonment. 4. Procedure.
The appeal shall be governed by and disposed of in accordance with the applicable provisions of the Constitution, laws, rules 45, 48, sections 1, 2, and 5 to 11 of Rule 51, 52, and this rule. 5. Grounds for dismissal of appeal. The appeal may be dismissed motu proprio or on motion of the respondent on the following grounds. A. Failure to take the appeal within the reglementary. B. Lack of merit in the petition. C. Failure to pay the requisite docket fee and other lawful fees or to make a deposit for costs. D. Failure to comply with the requirements regarding proof of service and contents of and the documents which should accompany the petition. E. Failure to comply with any circular, directive, or order of the Supreme Court without justifiable cause. F. Error in the choice or mode of appeal. And G. The fact that the case is not appealable to the Supreme Court. 6. Disposition of improper appeal. Except as provided in Section 3, Rule 122 regarding appeals in criminal cases, where the penalty imposed is death, reclusion perpetua, or life imprisonment, an appeal taken to the Supreme Court by notice of appeal shall be dismissed. An appeal by certiorari taken to the Supreme Court from the regional trial court submitting issues of fact may be referred to the Court of Appeals for decision or appropriate action. The determination of the Supreme Court on whether or not issues of fact are involved shall be final. 7. Procedure if opinion is equally divided. Where the court en banc is equally divided in opinion, or the necessary majority cannot be had, the case shall again be deliberated on, and if after such deliberation no decision is reached, the original action commenced in the court shall be dismissed. In appealed cases, the judgment or order appealed from shall stand affirmed, and on all incidental matters the petition or motion shall be denied. Provisional remedies. Rule 57. Preliminary attachment. 1. Grounds upon which attachment may issue. At the commencement of the action or at any time before entry of judgment, a plaintiff or any proper party may have the property of the adverse party attached as security for the satisfaction of any judgment that may be recovered in the following cases. A. In an action for the recovery of a specified amount of money or damages other than moral and exemplary cause of action arising from law, contract, quasi-contract, delict, or quasi-delict against a party who is about to depart from the Philippines with intent to defraud his creditors. B. In an action for money or property embezzled or fraudulently misapplied or converted to his own use by a public officer or an officer of a corporation or an attorney factor, broker, agent, or clerk in the course of his employment as such, or by any other person in a fiduciary capacity or for a willful violation of duty. C. In an action to recover the possession of property unjustly or fraudulently taken, detained, or converted, when the property or any part thereof has been concealed, removed, or disposed of to prevent its being found or taken by the applicant or an authorized person. D. In an action against a party who has been guilty of a fraud in contracting the debt or incurring the obligation upon which the action is brought or in the performance thereof. E. In an action against a party who has removed or disposed of his property or is about to do so with intent to defraud his creditors. Or F. In an action against a party who does not reside and is not found in the Philippines or on whom summons may be served by publication. 2. Issuance and contents of order. An order of attachment may be issued either ex parte or upon motion with notice and hearing by the court in which the action is pending or by the Court of Appeals or the Supreme Court, and must require the sheriff of the court to attach so much of the property in the Philippines of the party against whom it is issued, not exempt from execution, as may be sufficient to satisfy the applicant's demand, unless such party makes deposit or gives a bond as hereinafter provided in an amount equal to that fixed in the order, which may be the amount sufficient to satisfy the applicant's demand or the value of the property to be attached as stated by the applicant, exclusive of costs. Several writs may be issued at the same time to the sheriffs of the courts of the different judicial regions. 3. Affidavit and bond required. An order of attachment shall be granted only when it appears by the affidavit of the applicant or of some other person who personally knows the facts that a sufficient cause of action exists, that the case is one of those mentioned in Section 1 hereof, that there is no other sufficient security for the claim sought to be enforced by the action, and that the amount due to the applicant or the value of the property the possession of which he is entitled to recover is as much as the sum for which the order is granted above all legal counterclaims. The affidavit and the bond required by the next succeeding section must be duly filed with the court before the order issues. 4. Condition of applicant's bond. The party applying for the order must thereafter give a bond executed to the adverse party in the amount fixed by the court in its order granting the issuance of the writ, condition that the latter will pay all the costs which may be adjudged to the adverse party and all damages which she may sustain by reason of the attachment, if the court shall finally adjudge that the applicant was not entitled thereto. 5. Manner of attaching property. The sheriff enforcing the writ shall without delay and with all reasonable diligence attach to await judgment and execution in the action only so much of the property in the Philippines of the party against whom the writ is issued, not exempt from execution, as may be sufficient to satisfy the applicant's demand, unless the former makes a deposit with the court from which the writ is issued or gives a counter bond executed to the applicant in an amount equal to the bond fixed by the court in the order of attachment or to the value of the property to be attached exclusive of costs. No levy on attachment pursuant to the writ issued under Section 2 hereof shall be enforced unless it is preceded or contemporaneously accompanied by service of summons together with a copy of the complaint, the application for attachment, the applicant's affidavit and bond, and the order and writ of attachment on the defendant within the Philippines. The requirement of prior or contemporaneous service of summons shall not apply when the summons could not be served personally or by substituted service despite diligent efforts, or the defendant is a resident of the Philippines, temporarily absent therefrom, or the defendant is a non-resident of the Philippines, or the action is one in rem or quasi in rem. 6. Sheriff's return. After enforcing the writ, the sheriff must likewise, without delay, make a return thereon to the court from which the writ issued, with a full statement of his proceeding under the writ and a complete inventory of the property attached, together with any counter bond given by the party against whom attachment is issued, and serve copies thereof on the applicant. 7. Attachment of real and personal property, recording thereof. Real and personal property shall be attached by the sheriff executing the writ in the following manner. A. Real property or growing crops thereon, or any interest therein, standing upon the record of the registry of deeds of the province in the name of the party against whom attachment is issued, or not appearing at all upon such records, or belonging to the party against whom attachment is issued and held by any other persons, or standing on the records of the registry of deeds in the name of any other person, by filing with the Registry of Deeds a copy of the order, together with a description of the property attached, and a notice that it is attached, or that such real property and any interest therein held by or standing in the name of such other person are attached, and by leaving a copy of such order, description, and notice with the occupant of the property, if any, or with such other person, or his agent, if found within the province. Where the property has been brought under the operation of either the Land Registration Act or the Property Registration Decree, the notice shall contain a reference to the number of the certificate of title, the volume and page in the registration book where the certificate is registered, and the registered owner or owners thereof. The Register of Deeds must index attachments filed under this section and the names of the applicant, the adverse party, or the person by whom the property is held or in whose name it stands in the records. If the attachment is not claimed on the entire area of the land covered by the certificate of title, a description sufficiently accurate for the identification of the land or interest to be affected shall be included in the registration of such attachment. B. Personal property capable of manual delivery, by taking and safely keeping it in his custody after issuing the corresponding receipt therefor. C. Stocks or shares, or an interest in stocks or shares of any corporation or company, by leaving with the president or managing agent a copy of the writ and a notice stating that the stock or interest of the party against whom this issued is attached in pursuance of such writ. D. Debts and credits, including bank deposits, financial interest, royalties, commissions, and other personal property not capable of manual delivery, by leaving with the person owing such debts or having in his possession or under his control such credits or other personal property, or with his agent, a copy of the writ and notice that the debts owing by him to the party against whom attachment is issued, and the credits and other personal property in his possession or under his control belonging to said party, are attached in pursuance of such writ. E. The interest of the party against whom attachment is issued in property belonging to the estate of the decedent, whether as heir, legatee, or devisee, by serving the executor or administrator or other personal representative of the decedent with a copy of the writ and notice that said interest is attached. A copy of said writ of attachment of said notice shall also be filed in the office of the clerk of the court in which said estate is being settled and served upon the heir, legatee, or devisee concerned. the property sought to be attached is in custodial legis, a copy of the writ of attachment shall be filed with the proper court or quasi-judicial agency, and notice of the attachment served upon the custodian of such property. 8. Effect of attachment of debts, credits, and all other similar personal property. All persons having in their possession or under their control any credits or other similar personal property belonging to the party against whom attachment is issued, or owing any debts to him at the time of service upon them of the copy of the writ of attachment and notice as provided in the last preceding section, shall be liable to the applicant for the amount of such credits, debts, or other similar personal property until the attachment is discharged or any judgment recovered by him is satisfied, unless such property is delivered or transferred or such debts are paid to the clerk, sheriff, or other proper officer of the court issuing the attachment. 9. Effect of attachment of interest in property belonging to the estate of a decedent. The attachment of the interest of an heir, legatee, or devisee in the property belonging to the estate of a decedent shall not impair the powers of the executor, administrator, or other persona representative of the decedent over such property for the purpose of administration. Such personal representative, however, shall report the attachment to the court when any petition for distribution is filed, and in the order made upon such petition, distribution may be awarded to such heir, legatee, or devisee. But the property attached shall be ordered delivered to the sheriff making the levy, subject to the claim of such heir, legatee, or devisee, or any person claiming under him. 10. Examination of party whose property is attached and persons indebted to him or controlling his property. Delivery of property to sheriff. Any person owing debts to the party whose property is attached or having in his possession or under his control any credit or other personal property belonging to such party may be required to attend before the court in which the action is pending or before a commissioner appointed by the court and be examined on oath respecting the same. The party whose property is attached may also be required to attend for the purpose of giving information respecting his property and may be examined on oath. The court may, after such examination, order personal property capable of manual delivery belonging to him in the possession of the person so required to attend before the court, to be delivered to the clerk of the court or sheriff on such terms as may be just, having reference to any lien thereon or claim against the same, to await the judgment in the action. 11. When attached property may be sold after levy on attachment and before entry of judgment, whenever it shall be made to appear to the court in which the action is pending, upon hearing with notice to both parties that the property attached is perishable, or that the interests of all the parties to the action will be subserved by the sale thereof, the court may order such property to be sold at public auction in such manner as it may direct, and the proceeds of such sale to be deposited in court to abide the judgment in the action. 12. Discharge of attachment upon giving counter bond. After a writ of attachment has been enforced, the party whose property has been attached, or the person appearing on his behalf, may move for the discharge of the attachment wholly or in part on the security given. The court shall, after due notice and hearing, order the discharge of the attachment if the movant makes a cash deposit or files a counter bond executed to the attaching party, the clerk of the court, where the application is made in amount equal to that fixed by the court in the order of attachment, exclusive of costs. But if the attachment is sought to be discharged with respect to a particular property, the counter bond shall be equal to the value of that property as determined by the court. In either case, the cash deposit or the counter bond shall secure the payment of any judgment that the attaching party may recover in the action. A notice of the deposit shall forthwith be served on the attaching party. Upon the discharge of an attachment in accordance with the provisions of this section, the property attached or the proceeds of any sale thereof shall be delivered to the party making the deposit or giving the counter bond, or to the person appearing on his behalf, the deposit or counter bond aforesaid standing in place of the property so released. Should such counter bond for any reason be found to be or become insufficient, and the party furnishing the same fail to file an additional counter bond, the attaching party may apply for a new order of attachment. Section 9. Judgment to include recovery against sureties.
The amount, if any, to be awarded to any party upon any bond filed in accordance with the provisions of this rule shall be claimed, ascertained, and granted under the same procedure prescribed in Section 20 of Rule 57. Rule 60. Replevin. 1. Application. A party praying for the recovery of possession of personal property may, at the commencement of the action or at any time before answer, apply for an order for the delivery of such property to him in the manner hereinafter provided. 2. Affidavit and bond. The applicant must show by his own affidavit or that of some other person who personally knows the facts: A, that the applicant is the owner of the property claimed, particularly describing it, or is entitled to the possession thereof. B. That the property is wrongfully detained by the adverse party, alleging the cause of detention thereof, according to the best of his knowledge, information, and belief. C. That the property has not been distrained or taken for a tax assessment or a fine pursuant to law, or seized under a writ of execution or preliminary attachment, or otherwise placed under custodial legis, or if so seized, that it is exempt from such seizure or custody. And D, the actual market value of the property. The applicant must also give a bond executed to adverse party in double the value of the property as stated in the affidavit aforementioned for the return of the property to the adverse party if such return be adjudged, and for the payment to the adverse party of such sum as he may recover from the applicant in the action. 3. Order. Upon the filing of such affidavit and approval of the bond, the court shall issue an order and the corresponding writ of replevin describing the personal property alleged to be wrongfully detained and requiring the sheriff forthwith to take such property into his custody. 4. Duty of the sheriff. Upon receiving such order, the sheriff must serve a copy thereof on the adverse party, together with a copy of the application, affidavit, and bond, and must forthwith take the property if it be in the possession of the adverse party or his agent, and retain it in his custody. If the property or any part thereof be concealed in the building or enclosure, the sheriff must demand its delivery, and if it be not delivered, he must cause the building or enclosure to be broken open and take the property into his possession. After the sheriff has taken possession of the property as herein provided, he must keep it in a secure place and shall be responsible for its delivery to the party entitled thereto upon receiving his fees and necessary expenses for taking and keeping the same. 5. Return of property. If the adverse party objects to the sufficiency of the applicant's bond or of the surety or sureties thereon, he cannot immediately require the return of the property, but if he does not so object, he may at any time before the delivery of the property to the applicant require the return thereof by filing with the court where the action is pending a bond executed to the applicant in double the value of the property as stated in the applicant's affidavit for the delivery thereof to the applicant. If such delivery be adjudged, and for the payment of such sum to him as may be recovered against the adverse party, and by serving a copy of such bond on the applicant. C. Disposition of property by sheriff. If within 5 days after the taking of the property by the sheriff, the adverse party does not object to the sufficiency of the bond, or of the surety or sureties thereon, or if the adverse party so objects and the court affirms its approval of the applicant's bond or approves a new bond, or if the adverse party requires the return of the property but his bond is objected to and found insufficient and he does not forthwith file an approved one, the property shall be delivered to the applicant. If for any reason the property is not delivered to the applicant, the sheriff must return it to the adverse party. 7. Proceedings for property claimed by third person. If the property taken is claimed by any person other than the party against whom the writ of replevin had been issued or his agent, and such person makes an affidavit of his title thereto, or right to the possession thereof, stating the grounds therefore, and serves such affidavit upon the sheriff while the latter has possession of the property, and a copy thereof upon the applicant. The sheriff shall not be bound to keep the property under replevin or deliver it to the applicant unless the applicant or his agent, on demand of said sheriff, shall file a bond approved by the court to indemnify the third-party claimant in a sum not less than the value of the property under replevin as provided in Section 2 hereof. In case of disagreement as to such value, the court shall determine the same. No claim for damages for the taking or keeping of the property may be enforced against the bond unless the action therefore is filed within 120 days from the date of the filing of the bond. The sheriff shall not be liable for damages for the taking or keeping of such property to any such third-party claimant if such bond shall be filed. Nothing herein contained shall prevent such claimant
or any third person from vindicating his claim to the property, or prevent the applicant from claiming damages against a third party claimant who filed a frivolous or plainly spurious claim in the same or a separate action. When the writ of replevin is issued in favor of the Republic of the Philippines or any officer duly representing it, the filing of such bond shall not be required, and in case the sheriff is sued for damages, as a result of the reprieving, he shall be represented by the Solicitor General, and if held liable therefore, the actual damages adjudged by the court shall be paid by the National Treasurer out of the funds to be appropriated for the purpose. 8. Return of papers. The sheriff must file the order with his proceedings endorsed thereon with the court within 10 days after taking the property mentioned therein. 9. Judgment. After trial of the issues, the court shall determine who has the right of possession to and the value of the property, and shall render judgment in the alternative for the delivery thereof to the party entitled to the same, or for its value in case delivery cannot be made, and also for such damages as either party might prove with costs. 10. Judgment to include recovery against sureties. The amount, if any, to be awarded to any party upon any bond filed in accordance with the provisions of this rule shall be claimed, ascertained, and granted under the same procedure as prescribed in Section 20 of Rule 57. Rule 61. Support pendente lite. 1. Application at the commencement of the proper action or proceeding or at any time prior to the judgment or final order. A verified application for support pendente lite may be filed by any party stating the grounds for the claim and the financial conditions of both parties and accompanied by affidavits, depositions, or other authentic documents in support thereof. 2. Comment. A copy of the application and all supporting documents shall be served upon the adverse party, who shall have 5 days to comment thereon unless a different period is fixed by the court upon his motion. The comment shall be verified and shall be accompanied by affidavits, depositions, or other authentic documents in support thereof. 3. Hearing. After the comment is filed or after the expiration of the period for its filing, the application shall be set for hearing not more than 3 days thereafter. The facts in issue shall be proved in the same manner as is provided for evidence on motions. 4. Order. The court shall determine provisionally the pertinent facts and shall render such orders as justice and equity may require, having due regard to the probable outcome of the case and such other circumstances as may aid in the proper resolution of the question involved. If the application is granted, the court shall fix the amount of money to be provisionally paid or such other forms of support as should be provided, taking into account the necessities of the applicant and the resources or means of the adverse party and the terms of payment or mode for providing the support. If the application is denied, the principal case shall be tried and decided as early as possible. 5. Enforcement of order. If the adverse party fails to comply with an order granting support pendente lite, the court shall, voto proprio or upon motion, issue an order of execution against him without prejudice to his liability for contempt. When the person ordered to give support pendente lite refuses or fails to do so, any third person who furnished that support to the applicant may, after due notice and hearing in the same case, obtain a writ of execution to enforce his right of reimbursement against the person ordered to provide such support. 6. Support in criminal cases. In criminal actions where the civil liability includes support for the offspring as a consequence of the crime and the civil aspect thereof has not been waived, reserved, or instituted prior to its filing, the accused may be ordered to provide support pendente lite to the child born to the offending party allegedly because of the crime. The application therefore may be filed successively by the offended party, her parents, grandparents, or guardian, and the state in the corresponding criminal case during its pendency, in accordance with the procedure established under this rule. 7. Restitution. When the judgment or final order of the court finds that the person who has been providing support pendente lite is not liable, therefore, it shall order the recipient thereof to return to the former the amounts already paid with legal interest from the dates of actual payment without prejudice to the right of the recipient to obtain reimbursement in a separate action from the person legally obliged to give the support. Should the recipient fail to reimburse said amounts, the person who provided the same may likewise seek reimbursement thereof in a separate action from the person legally obliged to give support. Special Civil Actions. Rule 62. Interpleader. 1. When interpleader proper. Whenever conflicting claims upon the same subject matter are or may be made against a person who claims no interest whatever in the subject matter, or an interest which in whole or in part is not disputed by the claimants, he may bring an action against the conflicting claimants to compel them to interplead and litigate their several claims among themselves. 2. Order. Upon the filing of the complaint, the court shall issue an order requiring the conflicting claimants to interplead with one another. If the interests of justice so require, the court may direct in such order that the subject matter be paid or delivered to the court. 3. Summons. Summons shall be served upon the conflicting claimants together with a copy of the complaint and order. 4. Motion to dismiss. Within the time for filing an answer, each claimant may file a motion to dismiss on the ground of impropriety of the interpleader action or on other appropriate grounds specified in Rule 16. The period to file the answer shall be told, and if the motion is denied, the movement may file his answer within the remaining period, but which shall not be less than 5 days in any event, reckoned from notice of denial. Section 5. Answer and other pleadings. Each claimant shall file his answer setting forth his claim within 15 days from service of the summons upon him, serving a copy thereof upon each of the other conflicting claimants who may file their reply thereto as provided by these rules. If any claimant fails to plead within the time herein fixed, the court may on motion declare him in default and thereafter render judgment barring him from any claim in respect to the subject matter. The parties in an interpleader action may file counterclaims, cross-claims, third-party complaints, and responsive pleadings thereto as provided by these rules. 6. Determination. After the pleadings of the conflicting claimants have been filed and pre-trial has been conducted in accordance with the rules, the court shall proceed to determine the respective rights and adjudicate their several claims. 7. Docket and other lawful fees, costs, and litigation expenses as liens. The docket and other lawful fees paid by the party who filed the complaint under this rule, as well as the costs and litigation expenses, shall constitute a lien or charge upon the subject matter of the action unless the court shall order otherwise. Rule 63. Declaratory relief and similar remedies. 1. Who may file a petition? Any person interested under a deed, will, contract, or other written instrument, or whose rights are affected by a statute, executive order or regulation, ordinance, or any other governmental regulation may, before breach or violation thereof, bring an action in the appropriate regional trial court to determine any question of construction or validity arising and for a declaration of his rights or duties thereunder, and or to consolidate ownership under Article 1607 of the Civil Code may be brought under this rule. 2. Parties. All persons who have or claim any interest which would be affected by the declaration shall be made parties, and no declaration shall, except as otherwise provided in these rules, prejudice the rights of persons not parties to the action. 3. Notice on Solicitor General. In any action which involves the validity of a statute, executive order, or regulation, or any other governmental regulation, the Solicitor General shall be notified by the party assailing the same and shall be entitled to be heard upon such question. For local government ordinances, in any action involving the validity of a local government ordinance, the corresponding prosecutor or attorney of the local governmental unit involved shall be similarly notified and entitled to be heard. If such ordinance is alleged to be unconstitutional, the Solicitor General shall also be notified and entitled to be heard. 5. Court action discretionary. Except in actions falling under the second paragraph of Section 1 of this rule, the court, motu proprio or upon motion, may refuse to exercise the power to declare rights and to construe instruments in any case where a decision would not terminate the uncertainty or controversy which gave rise to the action, or in any case where the declaration or construction is not necessary and proper under the circumstances. 6. Conversion into ordinary action. If before the final termination of the case, a breach or violation of an instrument or a statute, executive order or regulation, ordinance, or any other governmental regulation should take place, the action may thereupon be converted into an ordinary action, and the parties shall be allowed to file such pleadings as may be necessary or proper. Rule 64. Review of judgments and final orders or resolutions of the Commission on Elections and the Commission on Audit. 1. Scope. This rule shall govern the review of judgments and final orders or resolutions of the Commission on Elections and the Commission on Audit. 2. Mode of review. A judgment or final order or resolution of the Commission on Elections and the Commission on Audit may be brought by the aggrieved party to the Supreme Court on certiorari under Rule 65, except as hereinafter provided. 3. Time to file petition. The petition shall be filed within 30 days from notice of the judgment or final order or resolution sought to be reviewed. The filing of a motion for new trial or reconsideration of said judgment or final order or resolution, if allowed under the procedural rules of the commission concerned, shall interrupt the period herein fixed. If the motion is denied, the aggrieved party may file the petition within the remaining period, but which shall not be less than 5 days in any event reckoned from notice of denial. 4. Docket and other lawful fees. Upon the filing of the petition, the petitioner shall pay to the clerk of court the docket and other lawful fees and deposit the amount of 500 pesos for costs. 5. Form and contents of petition. The petition shall be verified and filed in 18 legible copies. The petition shall name the aggrieved party as petitioner and shall join as respondents the commission concerned and the person or persons interested in sustaining the judgment, final order, or resolution a quo. The petition shall state the facts with certainty, present clearly the issues involved, set forth the grounds and brief arguments relied upon for review, and pray for judgment annulling or modifying the question judgment, final order, or resolution. Findings of fact of the Commission supported by substantial evidence shall be final and non-reviewable. The petition shall be accompanied by a clearly legible duplicate original or certified true copy of the judgment, final order, or resolution subject thereof, together with certified true copies of such material portions of the record as are referred to therein and other documents relevant and pertinent thereto. The requisite number of copies of the petition shall contain play copies of all documents attached to the original copy of said petition. The petition shall state the specific material dates showing that it was filed within the period fixed herein, and it shall contain a sworn certification against forum shopping as provided in the third paragraph of Section 3, Rule 46. The petition shall further be accompanied by proof of service of a copy thereof on the commission concerned and on the adverse party, and of the timely payment of docket and other lawful fees. The failure of petitioner to comply with any of the foregoing requirements shall be sufficient ground for the dismissal of the petition. 6. Order to comment. If the Supreme Court finds the petition sufficient in form and substance, it shall order the respondents to file their comments on the petition within 10 days from notice thereof. Otherwise, the court may dismiss the petition outright. The court may also dismiss the petition if it was filed manifestly for delay or the question raised are too unsubstantial to warrant further proceedings. 7. Comments of respondents. The comments of the respondents shall be filed in 18 legible copies. The original shall be accompanied by certified true copies of such material portions of the record as are referred to therein, together with other supporting papers. The requisite number of copies of the comments shall contain plain copies of all documents attached to the original, and a copy thereof shall be served on the petitioner. No other pleading may be filed by any party unless required or allowed by the court. 8. Effect of filing. The filing of a petition for certiorari shall not stay the execution of the judgment or final order or resolution sought to be reviewed, unless the Supreme Court shall direct otherwise upon such terms as it may deem just. 9. Submission for decision. Unless the court sets the case for oral argument or requires the parties to submit memoranda, the case shall be deemed submitted for decision upon the filing of the comments on the petition or of such other pleadings or papers as may be required or allowed, or the expiration of the period to do so. Rule 65. Certiorari, Prohibition, and Mandamus. 1. Petition for certiorari. When any tribunal, board, or officer exercising judicial or quasi-judicial functions has acted without or in excess of its or his jurisdiction, or with great abuse of discretion amounting to lack or excess of jurisdiction, and there is no appeal or any plain, speedy, and adequate remedy in the ordinary course of law, a person aggrieved thereby may file a verified petition in the proper court, alleging the facts with certainty and praying that judgment be rendered, annulling or modifying the proceedings of such tribunal, board, or officer, and granting such incidental reliefs as law and justice may require. The petition shall be accompanied by a certified true copy of the judgment, order, or resolution subject thereof, copies of all pleadings and documents relevant and pertinent thereto, and a sworn certification of non-forum shopping as provided in the third paragraph of Section 3, Rule 46. 2. Petition for prohibition. When the proceedings of any tribunal, corporation, board, officer, or person, whether exercising judicial, quasi-judicial, or ministerial functions, are without or in excess of its or his jurisdiction, or with grave abuse of discretion amounting to lack or excess of jurisdiction, and there is no appeal or any other plain, speedy, and adequate remedy in the ordinary course of law, a person aggrieved thereby may file a verified petition in the proper court, alleging the facts with certainty. And praying that judgment be rendered, commanding the respondent to desist from further proceedings in action or matter specified therein, or otherwise granting such incidental reliefs as law and justice may require. The petition shall likewise be accompanied by a certified true copy of the judgment, order, or resolution subject thereof, copies of all pleadings and documents relevant and pertinent thereto, and a sworn certification of non-forum shopping as provided in the third paragraph of Section 3, Rule 46. 3. Petition for mandamus. When any tribunal, corporation, board, officer, or person unlawfully neglects the performance of an act which the law specifically enjoins as a duty resulting from an office, trust, or station, or unlawfully excludes another from the use and enjoyment of a right or office to which such other is entitled, and there is no other plain, speedy, and adequate remedy in the ordinary course of law, the person aggrieved thereby may file a verified petition in the proper court, alleging the facts with certainty, and praying that judgment be rendered, commanding the respondent, immediately or at some other time to be specified by the court, do the act required to be done to protect the rights of the petitioner, and to pay the damages sustained by the petitioner by reason of the wrongful acts of the respondent. The petition shall also contain a sworn certification of non-forum shopping as provided in the third paragraph of Section 3, Rule 46. 4. When and where to file the petition. The petition shall be filed not later than 60 days from notice of the judgment, order, or resolution. In case a motion for reconsideration or new trial is timely filed, whether such motion is required or not, the petition shall be filed not later than 60 days counted from the notice of the denial of the motion. If the petition relates to an act or an omission of a municipal trial court or of a corporation, a board, an officer, or a person, shall be filed with the regional trial court exercising jurisdiction over the territorial area as defined by the Supreme Court. It may also be filed with the Court of Appeals or with the Sandigan Bayan, whether or not the same is in aid of the court's appellate jurisdiction. If the petition involves an act or an omission of a quasi-judicial agency, unless otherwise provided by law or these rules, the petition shall be filed with and be cognizable only by the Court of Appeals. In election cases involving an act or an omission of a municipal or a regional trial court, the petition shall be filed exclusively with the Commission on Elections in aid of its appellate jurisdiction. 5. Respondents and costs in certain cases. When the petition filed relates to the acts or omissions of a judge, court, quasi-judicial agency, tribunal, corporation, board, officer, or person, the petition will join as private respondent or respondents with such public respondent or respondents, the person or persons interested in sustaining the proceedings in the court, and it shall be the duty of such private respondents to appear and defend, both in his or their own behalf and in behalf of the public respondent or respondents affected by the proceedings, and the costs awarded in such proceedings in favor of the petitioner shall be against the private respondents only, and not against the judge, court, quasi-judicial agency, tribunal, corporation, board, officer, or person impleaded as public respondent or respondents. Unless otherwise specifically directed by the court where the petition is pending, the public respondents shall not appear in or file an answer or comment to the petition or any pleading therein. If the case is elevated to a higher court by either party, the public respondents shall be included therein as nominal parties. However, unless otherwise specifically directed by the court, they shall not appear or participate in the proceedings therein. 6. Order to comment. If the petition is sufficient in form and substance to justify such process, the court shall issue an order requiring the respondent or respondents to comment on the petition within 10 days from receipt of a copy thereof. Such order shall be served on the respondents in such manner as the court may direct, together with a copy of the petition and any annexes thereto. In petitions for certiorari before the Supreme Court and the Court of Appeals, the provisions of Section 2, Rule 56 shall be observed. Before giving due course thereto, the court may require the respondents to file their comment to, without a motion to dismiss, the petition. Thereafter, the court may require the filing of a reply and such other responsive or other pleadings as it may deem necessary and proper. 7. Expediting proceedings, injunctive relief. The court in which the petition is filed may issue orders expediting the proceedings, and it may also grant a temporary restraining order or a writ of preliminary injunction for the preservation of the rights of the parties pending such proceedings. The petition shall not interrupt the course of the principal case unless a temporary restraining order or a writ of preliminary injunction has been issued, enjoining the public respondent from further proceeding with the case. The public respondent shall proceed with the principal case within 10 days from the filing of a petition for certiorari with a higher court or tribunal, absent a temporary restraining order or a preliminary injunction, or upon its expiration. Failure of the public respondent to proceed with the principal case may be a ground for an administrative charge. 8. Proceedings after comment is filed. After the comment or other pleadings required by the court are filed, or the time for the filing thereof has expired, the court may hear the case or require the parties to submit memoranda. If, after such hearing or filing of memoranda or upon the expiration of the period for filing, the court finds that the allegations of the petitioner are true, it shall render judgment for such relief to which the petitioner is entitled. However, the court may dismiss the petition if it finds the same patently without merit or prosecuted manifestly for delay, or if the questions raised therein are too unsubstantial to require consideration. In such event, the court may award in favor of the respondent treble costs solidarily against the petitioner and counsel, in addition to subjecting counsel to administrative sanctions under Rule 139 and 139b of the Rules of Court. The court may impose motu proprio based on res ipsa loquitur, other disciplinary sanctions or measures on erring lawyers for patently dilatory and unmeritorious petitions for certiorari. 9. Service and enforcement of order or judgment. A certified copy of the judgment rendered in accordance with the last preceding section shall be served upon the court, quasi-judicial agency, tribunal, corporation, board, officer, or person concerned in such manner as the court may direct, and disobedience thereto shall be punished as contempt. An execution may issue for any damages or costs awarded in accordance with Section 1 of Rule 39. Rule 66. Quo warranto. 1. Action by government against individuals. An action for the usurpation of a public office, position, or franchise may be commenced by a verified petition brought in the name of the Republic of the Philippines against a person who usurps, intrudes into, or unlawfully holds or exercises a public office, possession, or franchise. B. A public officer who does or suffers an act which, by the provision of law, constitutes a ground for the forfeiture of his office, or C. An association which acts as a corporation within the Philippines without being legally incorporated or without lawful authority so to act. 2. When Solicitor General or Public Prosecutor must commence action. A Solicitor General or a public prosecutor, when directed by the President of the Philippines, or when, upon complaint or otherwise, he has good reason to believe that any case specified in the preceding section can be established by proof, must commence such action. 3. When Solicitor General or public prosecutor may commence action with permission of court. A Solicitor General or a public prosecutor may, with the permission of the court in which the action is to be commenced, bring such an action at the request and upon the relation of another person, but in such case the officer bringing it may first require an indemnity for the expenses and costs of the action in an amount approved by and to be deposited in the court by the person at whose request and upon whose relation the same is brought. 4. when hearing had on application for permission to commence action. Upon application for permission to commence such action in accordance with the next preceding section, the court shall direct that notice be given to the respondent so that he may be heard in opposition thereto, and if permission is granted, the court shall issue an order to that effect, copies of which shall be served on all interested parties, and the petition shall then be filed within the period ordered by the court. 5. When an individual may commence such an action, a person claiming to be entitled to a public office or position usurped or unlawfully held or exercised by another may bring an action therefore in his own name. 6. Parties and contents of petition against usurpation. When the action is against a person for usurping a public office, position, or franchise, the petition shall set forth the name of the person who claims to be entitled thereto, if any, with an averment of his right to the same, and that the respondent is unlawfully in possession thereof. All persons who claim to be entitled to the public office, position, or franchise may be made parties, and their respective rights to such public office, position, or franchise determined in the same action. 7. Venue. An action under the preceding six sections can be brought only in the Supreme Court, the Court of Appeals, or in the regional trial court exercising jurisdiction over the territorial area where the respondent or any of the respondents resides, but when the Solicitor General commences the action, it may be brought in a regional trial court in the City of Manila, in the Court of Appeals, or in the Supreme Court. 8. Period for pleadings and proceedings may be reduced, action given precedence. The court may reduce the period provided by these rules for filing pleadings and for all other proceedings in the action in order to secure the most expeditious determination of the matters involved therein consistent with the rights of the parties. Such action may be given precedence over any other civil matter pending in the court. 9. Judgment where usurpation found. When the respondent is found guilty of usurping, intruding into, or unlawfully holding or exercising a public office, position, or franchise, judgment shall be rendered that such respondent be ousted and altogether excluded therefrom, and that the petitioner or relator, as the case may be, recover his costs. Such further judgment may be rendered determining the respective rights in and the public office, possession, or franchise of all the parties to the action as justice requires. 10. Rights of persons adjudged entitled to public office, delivery of books and papers, damages. If judgment be rendered in favor of the person averred in the complaint to be entitled to the public office, he may, after taking the oath of office and executing any official bond required by law, take upon himself the execution of the office, and may immediately thereafter demand of the respondent all the books and papers in the respondent's custody or control appertaining to the office to which the judgment relates. If the respondent refuses or neglects to deliver any book or paper pursuant to such demand, he may be punished for contempt as having disobeyed a lawful order of the court. The person adjudged entitled to the office may also bring action against the respondent to recover the damages sustained by such person by reason of the usurpation. 11. Limitations. Nothing contained in this rule shall be construed to authorize an action against a public officer or employee for his ouster from office unless the same be commenced within 1 year after the cause of such ouster or the right of the petitioner to hold such office or position arose, nor to authorize an action for damages in accordance with the provisions of the next preceding section unless the same be commenced within 1 year after the entry of the judgment establishing the petitioner's right to the office in question. 12. Judgment for costs. In an action brought in accordance with the provisions of this rule, the court may render judgment for costs against either the petitioner, the relator, or the respondent, or the person or persons claiming to be a corporation, or may apportion the costs as justice requires. Rule 67. Expropriation. 1. The complaint. The right of eminent domain shall be exercised by the filing of a verified complaint, which shall state with certainty the right and purpose of expropriation, describe the real or personal property sought to be expropriated, and join as defendants all persons owning or claiming to own or occupying any part thereof or interest therein, showing, so far as practicable, the separate interests of each defendant. If the title to any property sought to be expropriated appears to be in the Republic of the Philippines, although occupied by private individuals, or if the title is otherwise obscure or doubtful so that the plaintiff cannot with accuracy or certainty specify who are the real owners, averment to that effect shall be made in the complaint. 2. Entry of plaintiff upon depositing value with authorized government depository. Upon the filing of the complaint or at any time thereafter and after due notice to the defendant, the plaintiff shall have the right to take or enter upon the possession of the real property involved if he deposits with the authorized government depository an amount equivalent to the assessed value of the property for purposes of taxation to be held by such bank subject to the orders of the court. Such deposit shall be in money, unless in lieu thereof the court authorizes the deposit of a certificate of deposit of a government bank of the Republic of the Philippines, payable and demand to the authorized government depository. If personal property is involved, its value shall be provisionally ascertained and the amount to be deposited shall be promptly fixed by the court. After such deposit is made, the court shall order the sheriff or other proper officer to forthwith place the plaintiff in possession of the property involved and promptly submit a report thereof to the court with service of copies to the parties. 3. Defenses and objections. If a defendant has no objection or defense to the action or the taking of his property, he may file and serve a notice of appearance and a manifestation to that effect, specifically designated or identifying the property in which he claims to be interested within the time stated in the summons. Thereafter, he shall be entitled to notice of all proceedings affecting the same. If a defendant has any objection to the filing of or to the allegations in the complaint, or any objection or defense to the taking of his property, he shall serve his answer within the time stated in the summons. The answer shall specifically designate or identify the property in which he claims to have an interest, state the nature and extent of the interest claimed, and adduce all his objections and defenses to the taking of his property. No counterclaim, cross-claim, or third-party complaint shall be alleged or allowed in the answer or any subsequent pleading. A defendant waives all defenses and objections not so alleged, but the court, in the interest of justice, may permit amendments to the answer to be made not later than 10 days from the filing thereof. However, at the trial of the issue of just compensation, whether or not a defendant has previously appeared or answered, he may present evidence as to the amount of the compensation to be paid for his property, and he may share in the distribution of the award. 4. Order of expropriation. If the objections to and the defenses against the right of the plaintiff to expropriate the property are overruled, or when no party appears to defend as required by this rule, the court may issue an order of expropriation declaring that the plaintiff has a lawful right to take the property sought to be expropriated for the public use or purpose described in the complaint upon the payment of just compensation to be determined as of the date of the taking of the property or the filing of the complaint, whichever came first. A final order sustaining the right to expropriate the property may be appealed by any party aggrieved thereby. Such appeal, however, shall not prevent the court from determining the just compensation to be paid. After the rendition of such an order, the plaintiff shall not be permitted to dismiss or discontinue the proceeding except on such terms as the court deems just and equitable. 5. Ascertainment of compensation. Upon the rendition of the order of expropriation, the court shall appoint not more than 3 competent and disinterested persons as commissioners to ascertain and report to the court that just compensation for the property sought to be taken. The order of appointment shall designate the time and place of the first session of the hearing to be held by the commissioners and specify the time within which the report shall be submitted to the court. Copies of the order shall be served on the parties. Objections to the appointment of any of the commissioners shall be filed with the court within 10 days from service and shall be resolved within 30 days after all the commissioners shall have received copies of the objections. 6. Proceedings by Commissioners. Before entering upon the performance of their duties, the Commissioners shall take and subscribe an oath that they will faithfully perform their duties as Commissioners, which oath shall be filed in court with the other proceedings in the case. Evidence may be introduced by either party before the Commissioners who are authorized to administer oaths on hearings before them, and the Commissioners shall, unless the parties consent to the contrary, after due notice to the parties to attend, view and examine the property sought to be expropriated and its surroundings, and may measure the same, after which either party may, by himself or counsel, argue the case. The commissioners shall assess the consequential damages to the property not taken, and deduct from such consequential damages the consequential benefits to be derived by the owner from the public use or purpose of the property taken, the operation of its franchise by the corporation, or the carrying on of the business of the corporation or person taking the property. But in no case shall the consequential benefits assessed exceed the consequential damages assessed, or the owner be deprived of the actual value of his property so taken. 7. Report by commissioners and judgment thereupon. The court may order the commissioners to report when any particular portion of the real estate shall have been passed upon by them and may render judgment upon such partial report and direct the commissioners to proceed with their work as to subsequent portions of the property sought to be expropriated, and may from time to time so deal with such property. The commissioners shall make a full and accurate report to the court of all their proceedings, and such proceedings shall not be effectual until the court shall have accepted their report and rendered judgment in accordance with their recommendations. Except as otherwise expressly ordered by the court, such report shall be filed within 60 days from the date the commissioners were notified of their appointment, which time may be extended in the discretion of the court. Upon the filing of such report, the clerk of the court shall serve copies thereof on all interested parties, with notice that they are allowed 10 days within which to file objections to the findings of the report if they so desire. 8. Action upon Commissioner's Report. Upon the expiration of the period of 10 days referred to in the preceding section, or even before the expiration of such period but after all the interested parties have filed their objections to the report or their statement of agreement therewith, the court may, after hearing, accept the report and render judgment in accordance therewith, or for cause shown, it may recommit the same to the commissioners for further report of facts, or it may set aside the report and appoint new commissioners, or it may accept the report in part and reject it in part, and it may make such order or render such judgment as shall secure to the plaintiff the property essential to the exercise of his right of expropriation, and to the defendant just compensation for the property so taken. 9. Uncertain ownership, conflicting claims. If the ownership of the property taken is uncertain or there are conflicting claims to any part thereof, the court may order any sum or sums awarded as compensation for the property to be paid to the court for the benefit of the person adjudged in the same proceeding to be entitled thereto. But the judgment shall require the payment of the sum or sums awarded to either the defendant or the court before the plaintiff can enter upon the property or retain it for the public use or purpose if entry has already been made. 10. Rights of plaintiff after judgment and payment. Upon payment by the plaintiff to the defendant of the compensation fixed by the judgment, with legal interest thereon from the taking of the possession of the property, or after tender to him of the amount so fixed in payment of the costs, the plaintiff shall have the right to enter upon the property expropriated, and to appropriate it for the public use or purpose defined in the judgment, or to retain it should he have taken immediate possession thereof, under the provisions of Section 2 hereof. If the defendant and his counsel absent themselves from the court, or decline to receive the amount tendered, the same shall be ordered to be deposited in court, and such deposit shall have the same effect as actual payment thereof to the defendant or the person ultimately adjudged entitled thereto. 11. Entry not delayed by appeal. Effect of reversal. The right of the plaintiff to enter upon the property of the defendant and appropriate the same for public use or purpose shall not be delayed by an appeal from the judgment. But if the appellate court determines that plaintiff has no right of expropriation, judgment shall be rendered ordering the regional trial court to forthwith enforce the restoration to the defendant of the possession of the property, and to determine the damages which the defendant sustained and may recover by reason of the possession taken by the plaintiff. 12. Costs by whom paid. The fees of the commissioners shall be taxed as a part of the costs of the proceedings. All costs except those of rival claimants litigating their claims shall be paid by the plaintiff unless an appeal is taken by the owner of the property, and the judgment is affirmed, in which event the costs of the appeal shall be paid by the owner. 13. Recording judgment and its effect. The judgment entered in expropriation proceedings shall state definitely, by an adequate description, the particular property or interest therein expropriated, and the nature of the public use or purpose for which it is expropriated. When real estate is expropriated, a certified copy of such judgment shall be recorded in the registry of deeds of the place in which the property is situated, and its effect shall be to vest in the plaintiff the title to the real estate so described for such public use or purpose. 14. Power of guardian in such proceedings. The guardian or guardian ad litem of a minor or of a person judicially declared to be incompetent may, with the approval of the court, first had, do and perform on behalf of his ward any act, matter, or thing respecting the expropriation for public use or purpose of property belonging to such minor or person judicially declared to be incompetent, which such minor or person judicially declared to be incompetent could do in such proceedings if he were of age or competent. Rule 68. Foreclosure of real estate mortgage. Section 1. Complaint in action for foreclosure. In an action for the foreclosure of a mortgage or other encumbrance upon real estate, the complaint shall set forth the date and due execution of the mortgage, its assignments, if any, the names and residences of the mortgager and the mortgagee, a description of the mortgage property, a statement of the date of the note or other documentary evidence of the obligation secured by the mortgage, the amount claimed to be unpaid thereon, and the names and residences of all persons having or claiming an interest in the property subordinate in right to that of the holder of the mortgage, all of whom shall be made defendants in the action. 2. Judgment on foreclosure for payment or sale. If upon the trial in such action the court shall find the facts set forth in the complaint to be true, it shall ascertain the amount due to the plaintiff upon the mortgage debt or obligation, including interest and other charges as approved by the court, and costs, and shall render judgment for the sum so found due, and order that the same be paid to the court or to the judgment obligee within a period of not less than 90 days nor more than 120 days from the entry of judgment, and that in default of such payment the property shall be sold at public auction to satisfy the judgment. 3. Sale of mortgage property effect. When the defendant, after being directed to do so as provided in the next preceding section, fails to pay the amount of the judgment within the period specified therein, the court, upon motion, shall order the property to be sold in the manner and under the provisions of Rule 39 and other regulations governing sales of real estate under execution. Such sale shall not affect the rights of persons holding prior encumbrances upon the property or a part thereof, and when confirmed by an order of the court, also upon motion, it shall operate to divest the rights in the property of all the parties to the action, and to vest their rights in the purchaser, subject to such rights of redemption as may be allowed by law, upon the finality of the order of confirmation or upon the expiration of the period of redemption when allowed by law, the purchaser at the auction sale or last redemptioner, if any, shall be entitled to the possession of the property, unless a third party is actually holding the same, adversely to the judgment obliger. The said purchaser or last redemptioner may secure a writ of possession upon motion from the court which ordered the foreclosure. 4. Disposition of proceeds of sale. The amount realized from the foreclosure sale of the mortgage property shall, after deducting the costs of the sale, be paid to the person foreclosing the mortgage, and when there shall be any balance or residue, after paying off the mortgage debt due, the same shall be paid to junior encumbrances in the order of their priority, to be ascertained by the court, or if there be no such encumbrances, or there be a balance or residue after payment to them, then to the mortgagor or his duly authorized agent or to the person entitled to it. 5. House sale to proceed in case the debt is not all due. If the debt for which the mortgage or encumbrance was held and is not all due as provided in the judgment, as soon as a sufficient portion of the property has been sold to pay the total amount and the costs due, the sale shall terminate, and afterwards, as often as more becomes due for principal or interest and other valid charges, the court may, on motion, order more to be sold. But if the property cannot be sold in portions without prejudice to the parties, the whole shall be ordered to be sold in the first instance, and the entire debt and costs shall be paid, if the proceeds of the sale be sufficient therefor, there being a rebate of interest where such rebate is proper. 6. Deficiency judgment. If upon the sale of any real property as provided in the next preceding section, there be a balance due to the plaintiff after applying the proceeds of the sale, the court, upon motion, shall render judgment against the defendant for any such balance for which, by the record of the case, he may personally be liable to the plaintiff, upon which execution may issue immediately, if the balance is all due at the time of the rendition of the judgment. Otherwise, the plaintiff shall be entitled to execution at such time as the balance remaining becomes due under the terms of the original contract, which time shall be stated in the judgment. 7. Registration. A certified copy of the final order of the court confirming the sale shall be registered in the registry of deeds. If no right of redemption exists, the certificate of title in the name of the mortgagor shall be cancelled, and a new one issued in the name of the purchaser. Where a right of redemption exists, the certificate of title in the name of the mortgagor shall not be cancelled, but the certificate of sale and the order confirming the sale shall re-register, and a brief memorandum thereof made by the registrar of deeds upon the certificate of title. In the event the property is redeemed, the deed of redemption shall be registered with the registry of deeds, and a brief memorandum thereof shall be made by the register of deeds on said certificate of title. If the property is not redeemed, the final deed of sale executed by the sheriff in favor of the purchaser at the foreclosure sale shall be registered with the Registry of Deeds, whereupon the certificate of title in the name of the mortgager shall be cancelled and a new one issued in the name of the purchaser. 8. Applicability of other provisions. The provisions of sections 31, 32, and 34 of Rule 39 shall be applicable to the judicial foreclosure of real estate mortgages under this rule in so far as the former are not inconsistent with or may serve to supplement the provisions of the latter. Rule 69. Partition. 1. Complaint in action for partition of real estate. A person having the right to compel the partition of real estate may do so as provided in this rule, setting forth in his complaint the nature and extent of his title and an adequate description of the real estate of which partition is demanded, and joining as defendants all other persons interested in the property. 2. Order for partition and partition by agreement thereunder. If after the trial the court finds that the plaintiff has the right thereto, it shall order the partition of the real estate among all the parties in interest. Thereupon, the parties may, if they are able to agree, make the partition among themselves with proper instruments of conveyance, and the court shall confirm the partition so agreed upon by all the parties, and such partition, together with the order of the court confirming the same, shall be recorded in the registry of deeds of the place in which the property is situated. A final order decreeing partition and accounting may be appealed by any party aggrieved thereby. 3. Commissioners to make partition when parties fail to agree. If the parties are unable to agree upon the partition, the court shall appoint not more than 3 competent and disinterested persons as commissioners to make the partition, commanding them to set off to the plaintiff and to each party in interest such part and proportion of the property as the court shall direct. 4. Oath and duties of commissioners. Before making such partition, the commissioners shall take and subscribe an oath that they will faithfully perform their duties as commissioners, which oath shall be filed in court with the other proceedings in the case. In making the partition, the commissioners shall view and examine the real estate after due notice to the parties to attend at such view and examination, and shall hear the parties as to their preference in the portion of the property to be set apart to them and the comparative value thereof, and shall set apart the same to the parties in lots or parcels as will be most advantageous and equitable, having due regard to the improvement, situation, and quality of the different parts thereof. 5. Assignment or sale of real estate by commissioners. When it is made to appear to the commissioners that the real estate or a portion thereof cannot be divided without prejudice to the interests of the parties, the court may order it assigned to one of the parties willing to take the same, provided he pays to the other party such amounts as the commissioners deem equitable, unless one of the interested parties asks the property to be sold instead of being so assigned, in which case the court shall order the commissioners to sell the real estate at public sale under such conditions and within such time as the court may determine. 6. Report of commissioners proceedings not binding until confirmed. The commissioners shall make a full and accurate report to the court of all their proceedings as to the partition or the assignment of real estate to one of the parties, or the sale of the same. Upon the filing of such report, the clerk of court shall serve copies thereof on all the interested parties with notice that they are allowed 10 days within which to file objections to the findings of the report if they so desire. No proceeding had before or conducted by the commissioners shall pass the title to the property or bind the parties until the court shall have accepted the report of the commissioners and rendered judgment thereon. 7. Action of the court upon commissioners' report. Upon the expiration of the period of 10 days referred to in the preceding section, or even before the expiration of such period but after the interested parties have filed their objection to the report or their statement of agreement therewith, the court may, upon hearing, accept the report and render judgment in accordance therewith, or for cause shown, recommit the same to the commissioners for further report of facts, or set aside the report and appoint new commissioners, or accept the report in part and reject it in part, and may make such order and render such judgment as shall effectuate a fair and just partition of the real estate, or of its value, if assigned or sold as above provided, between the several owners thereof. 8. Accounting for rent and profits and action for partition. In an action for partition in accordance with this rule, a party shall recover from another his just share of rents and profits received by such other party from the real estate in question, and the judgment shall include an allowance for such rents and profits. 9. Power of guardian in such proceedings. The guardian or guardian ad litem of a minor or person judicially declared to be incompetent may, with the approval of the court first had, do and perform on behalf of his ward any act, matter, or thing respecting the partition of real estate, which the minor or person judicially declared to be incompetent could do in partition proceedings if he were of age or competent. 10. Costs and expenses to be taxed and collected. The court shall equitably tax in a portion between or among the parties the costs and expenses which accrue in the action, including the compensation of the commissioners, having regard to the interests of the parties, and execution by issue thereof, as in other cases. 11. The judgment and its effect. Copy to be recorded in Registry of Deeds. If actual partition of property is made, the judgment shall state definitely, by metes and bounds and adequate description, the particular portion of the real estate assigned to each party, and the effect of the judgment shall be to vest in each party to the action in severally the portion of the real estate assigned to him. If the whole property is assigned to one of the parties upon his paying to the others the sum or sums ordered by the court, the judgment shall state the fact of such payment and of the assignment of the real estate to the party making the payment, and the effect of the judgment shall be to vest in the party making the payment the whole of the real estate free from any interest on the part of the other parties to the action. If the property is sold and the sale confirmed by the court, the judgment shall state the name of the purchaser or purchasers and a definite description of the parcels of real estate sold to each purchaser, and the effect of the judgment shall be to vest the real estate in the purchaser or purchasers making the payment or payments free from the claims of any of the parties to the action. A certified copy of the judgment shall in either case be recorded in the Registry of Deeds of the place in which the real estate is situated, and the expenses of such recording shall be taxed as part of the costs of the action. 12. Neither paramount rights nor amicable partition affected by this rule. Nothing in this rule contained shall be construed so as to prejudice, defeat, or destroy the right or title of any person claiming the real estate involved by title under any other person, or by title paramount to the title of the parties among whom the partition may have been made, nor so as to restrict or prevent persons holding real estate jointly or in common from making an amicable partition thereof by agreement and suitable instruments of conveyance without recourse to an action. 13. Partition of personal property. The provisions of this rule shall apply to partitions of estates composed of personal property, or of both real and personal property, in so far as the same may be applicable. Rule 70. Forcible entry and unlawful detainer. Section 1. Who may institute proceedings and when? Subject to the provisions of the next succeeding section, a person deprived of the possession of any land or building by force, intimidation, threat, strategy, or stealth, or a lesser, vendor, vendee, or other person against whom the possession of any land or building is unlawfully withheld after the expiration or termination of the right to hold possession by virtue of any contract, express or implied, or the legal representatives or assigns of any such lesser, vendor, vendee, or other person may at any time within 1 year after such unlawful deprivation or withholding of possession bring an action in the proper municipal trial court against a person or persons unlawfully withholding or depriving of possession, or any person or persons claiming under them for title restitution of such possession, together with damages and costs. 2. Lesser to proceed against lessee only after demand. Unless otherwise stipulated, such action by the lessor shall be commenced only after demand to pay or comply with the conditions of the lease and to vacate is made upon the lessee, or by serving written notice of such demand upon the person found on the premises, or by posting such notice on the premises, if no person be found thereon, and the lessee fails to comply therewith, after 15 days in the case of land or 5 days in the case of buildings. 3. Summary procedure. Except in cases covered by the agricultural tenancy laws or when the law otherwise expressly provides, all actions for forcible entry and lawful detainer, irrespective of the amount of damages or unpaid rentals sought to be recovered, shall be governed by the summary procedure hereunder provided. 4. Pleadings allowed. The only pleadings allowed to be filed are the complaint, compulsory counterclaim, and cross-claim pleaded in the answer, and the answers thereto. All pleadings shall be verified. 5. Action on complaint. The court may, from an examination of the allegations in the complaint, and such evidence as may be attached thereto, dismiss the case outright on any of the grounds for the dismissal of a civil action which are apparent therein. If no ground for dismissal is found, it shall forthwith issue summons. 6. Answer. Within 10 days from service of summons, the defendant shall file his answer to the complaint and serve a copy thereof